Huh. For what? What I? ಯಾವ್ದ್ರಲ್ಲಿ? We'll call it. ಈಗಲೇ ತಗೋಬೇಕಾ? What for? Vivatsa Vishwas. Next week it will come. Yes. Don't worry about the memo. It will come. ಮೂಡ ಹಂಗೇಳಿ. ಎಸ್. ಒಂದು ನಿಮಿಷ ಅವ್ರೇನೋ ಹೇಳ್ತಿದಾರಲ್ಲ, ಒಂದು ನಿಮಿಷ.
It has been quashed by my lord.
Correct. Supreme Court has confirmed it.
So the petitioner before my lords are suffering from the same parity.
We'll see. We'll take it. Give it.
Date may be fixed.
Stay ಇದೆಯಲ್ಲ.
Please, my lord.
ಮತ್ತೆ wait. Stay ಇರೋದ್ರಿಂದ we'll take it on 9th January. Madam, 9th January will score.
Milords, moving some being spoken to, Milords.
Why?
Just to change the name of the advocate, Milords. The arguing
Advocate name change.
arguing counsel's name is not printed, Milords. That's all.
Right. Which is that, sir? Which matter?
In IT matters, Milords. Income tax matters.
ಯಾವ್ದು ಫೇಸ್ಲೆಸ್?
Faceless, Milords.
ಯಾಕೆ ಆರ್ಗ್ಯೂಯಿಂಗ್ ಕೌನ್ಸಿಲ್ ಬಂದಿಲ್ವಾ ಅದರಲ್ಲಿ? It's not printed, is it?
Ravi Shankar sir's name is printed. Arguing counsel is Lochna as well.
Lochna's name is not there. All right, give it. Yes. ಅದೇನು ಅಷ್ಟೊಂದು ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
13 are there.
ಓ, ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಟು.
Yes.
ಮತ್ತೇನಾಗ್ಬೋದು ಮೇಡಮ್? ಅಲ್ಲ, ಅದೇನು ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಟು ಬೇಡ. ಚೇಂಬರ್ ಆರ್ಡರ್ ವಿಲ್ ಡೂ ಇಟ್. ಕೀಪ್ ಇಟ್. ವೈ ಡಿಡ್ ವೇಸ್ಟ್ ಪೇಪರ್? ಬಟ್ numbers ಬರ್ಕೊಡಿ. ಸಿ, in all these, just make note of the numbers and give it to me. We will change it in the chamber. This need not be posted for being spoken.
Milords, serial number 130, serial number 39 mad. List number 1. Senior counsel is out of station.
Out of station.
Next week alla.
ಆಯ್ತು.
39 serial.
ಆಯ್ತು. ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಲ್ಲ?
Entry ಮಾಡಿದ್ರು.
We'll adjourn, don't worry.
Grateful.
Interim order ಇದ್ರೆ I will adjourn it. Interim order ಇಲ್ಲ ಅಂದ್ರೆ let the petitioners counsel come. And then we'll. Sir, Vaidyanathan sir.
Yes, my lord. I'm waiting for item number 23 for orders.
Yes, we'll call the list.
Number 1.
Lords, I appear for respondent, my lords.
Well, where is Sunil Kumar?
Lords,
ಆಯ್ತು, 9ಕ್ಕೆ ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್.
Lords, 1 and 4 are connected, my lords.
I know 1 and 4 are connected. Serial number 1 and serial number 4, both will take on 9th.
Please, my lord, I'll intimate the other counsel.
Intimate them. List these, one ನಿಮಿಷ. List 1, I'll tag along with 4. List them both on 9th. Tag beda. List them both on 9th in seriatim, not tagging. Interim order subsisting would continue to the next date of hearing.
Please, my lord.
Yes. Review kashta, madam. Supreme Court lately has said we should not. Difficult. You tell him this and get him. Difficult. Yes.
3.
Kudi. Notice madam. Office objections comply again. Agide madam. Non-compliance. Last time.
For adjournment.
Straight to illa. Learned additional SPP is directed to accept notice for the first respondent. Emergent notice to the second respondent, returnable by the 9th of January, list on 9th January.
4 at the side.
Please, Your Lordship.
Yes, sir.
Lord, this matter regarding that Valmiki is in
Hello, sir. Yes.
CAD, SIT, my Lord.
We'll pass it.
Okay.
We'll pass it over. Let Jagdish come.
Please, Your Lordship.
Yes.
6, number 6.
Okay for the petition.
ಯಾಕೆ ಸರ್ ಮತ್ತೆ
ಇಲ್ಲ, it is because of the
10
non-payment.
ಲಕ್ಷ ಕೊಟ್ಟಿಲ್ವಾ?
I have contacted my party, please, my lords. It
Ah.
may be had on 10th or 12th. I will contact them again, please, my lords.
ಇಲ್ಲ ಕಾಂಟ್ಯಾಕ್ಟ್ ಇಲ್ವೇ ಇಲ್ಲ. ವಿಲ್ ಡೈರೆಕ್ಟ್ ರಿಕವರಿ ಅರಿಯರ್ಸ್ ಲ್ಯಾಂಡ್ ರೆವಿನ್ಯೂ.
It may be had on 12th, my lords. On that day, I will make submissions.
ಲಿಟಪಿಲ್ ಏನಾಯ್ತು?
ಇಲ್ಲ, I had given back the file, my lords. Please.
Yes, at the request of the council appearing for the petitioner, list the matter on 12th. 12th ಬೇಡ 9th. 9th Jan. is okay. 9th ಅಂದ್ರೆ 9th Jan.
7.
ಕೊಡಿ.
Appearing for the petitioner, my lord.
This court on so and so had granted, while disposing the petition, had directed the concerned court to dispose the petition itself with an outer limit of 6 months from the date of receipt of the copy of the order. Next 1 week, had passed the following order. Who has filed this application? Letter, all right. The communication is now sent from the concerned court seeking the extension of time to dispose the application so filed. Though the reasons rendered in the application is hardly satisfactory, in the interest of justice, I deem it appropriate to grant 8 more weeks' time to comply with the order dated 13th June 2025, with an observation that any further communication in this regard would be viewed seriously.
8. Number 8.
In modification. What modification? Procedural.
Number 9.
ಸೀನಪ್ಪರ ನೀವೇ
Yes, colleagues.
ಏನೇನು ಪ್ರಾಬ್ಲಮ್?
Not sir.
ಯಾಕೆ ಇವೆಲ್ಲ ಬೇಕಾ?
ಅಲ್ಲ sir, this is ಅಲ್ಲ. ಅಲ್ಲ sir, I don't know, the track of the suit, my lord, says like
ಲಿಸ್ಟ್ ಆಗಿತ್ತು, ಲಿಸ್ಟ್ ಕೇಳಿದಾಗ ನಾನೇ ಹೇಳಿದೆ. ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಇಲ್ಲೇ ಬಂದಿದ್ಯಾ?
I did move it in front of to that court. It was my says area. This court was also opinion class. Now what have you other area is there because memo of instructions are outside of the passenger manaka. Area the other matter has to be, what has happened? The track of the suit makes me worrisome. Track of the suit makes my client worrisome. Because my client is also practicing as a client. That's the reason. But what happened to us, sir? I didn't know anything about this. But we are two parties in this matter. The other
when matters were listed, ಎಲ್ಲದಕ್ಕೂ ನಾನೇ date ಕೊಟ್ಟೆ. Because I was not sitting, but list ಆಗಿತ್ತು. ಹಾಗಾಗಿ ಇದನ್ನ ಕೇಳಿದ್ದೀನಲ್ಲ ನಾನೇ.
She went in due course, madam, and I don't know, the other side was very hectic, madam. That's the reason, madam. I didn't say anything. I was just this thing. The other side was very kind. In fact, I don't want to go further.
Early, ಬೇರೆ ಕೆಲಸ ಮುಗಿಸ್ಕೊಂಡು ಬರ್ತೀರಾ?
ಆಯ್ತು.
ಅವ್ರು ಹೇಳಿದ್ರು, ಅವ್ರು ಬಂದ್ರೆ ನೀವು ಇಲ್ಲೇ ಇದ್ರೆ ತಗೊಂಡು.
Admission 10.
My lords, it's pending consideration for final hearing, my lords.
Huh? Then we'll close this, Rahul.
My lords, may I say this, my lords? The reason stay was not granted is because it is quashed. The Supreme Court admitted the matter. Lords, now
Maybe,
that it
sir.
is pending
Mere
for final
admission of the
hearing.
matter, we will not, sir. We will just follow it. ಇದನ್ನು Supreme Court ತಗೊಂಡೋಗಿ.
My lords, in that case, I have some submissions to make, my lords.
Please do, sir. Yes.
My lords, on the question of illegality, my lords, last time I had made some submissions regarding that the test is relevancy. My lords, your lordship was pleased to follow the American doctrine of poisonous tree, which was incorporated. That the
the fruit of the poisonous tree ಹೇಳಿದಿನ ಇದರಲ್ಲಿ ಇಲ್ವಲ್ಲ?
How, my lords, wiretapping is illegal ಅಂತ ಹೇಳಿದ್ರು.
Wiretapping is illegal. Whatever conversation you have made out of case that you have built up on wiretapping.
Please, my lords, that without requisite to Rule 419 was violated is what your lordship had held.
Yes.
My lords, there is one judgment, my lords, in Afzal Guru's case where, my lords, the Honorable Supreme Court held that 419 rule deviation is not ipso facto illegal. If please, my lords, the only difficulty is I am not keeping well today, my lords, otherwise I would have made submissions physically. May I request for a short accommodation? In that case, I'll place the judgment on record and make my submissions. Your lordship may take. A short date, my lords, I am.
As far as the merits of the matter also, lordship has
there was no trap at all. Even if you forget wiretapping, where is the question of proving it?
I understand, my lords. On merits, I may, my lords, my lords, I agree to the fact that on merits, I do not have a very good case, my lords. But on law, I would like to make some submissions. I bow down to the fact that I may not have a very great case on merits. I agree to that.
Yes. No, on wiretapping, you may say that it is and 419 permission was taken or otherwise.
Please.
That would not take you anywhere.
All I'm requesting is an opportunity to argue on law. That's what is short.
All right. Sorry.
There's an interim order of stay for the petitioners, my lords. Therefore, my lords, their interest is protected.
Interim order ಇದೆಯಲ್ಲ?
They have interim order.
Don't come, sir. I will only come here. List the matter on 8th. Interim orders at the request of the counsel Rahul Krishna Reddy, who submits that he is indisposed today to make submissions. List the matter on 8th. Interim order subsisting would continue till the next date of hearing.
Great.
What remains is 409, 420.
Please.
192A is out.
Please, my lords. Now, my lord, as far as these two sections are concerned, allegations admittedly, my lords, are that these are the public servants. As a revenue inspector, village accountant, etc. My allegations, without there being the documents, they have issued the Sagodi chit. Is the allegation, my lords. This, my lord, without going to other aspects, my lords, admittedly, in the discharge of the official duty, of course, the allegation would be, my lord, in excess or by misuse, etc., etc. Without the documents, also they issued the certificates, my lords. Admitted comes under the color of the duty, in excess of the duty, under the garb of the duty. They have done it, even if it is held. Please, my lords, that the allegation pertains to making entries in the revenue records without there being the original documents is the case, my lords. Therefore, my lord, 197 CRPC would come into play, my lords. In the absence of my lord, any such full charge, sanction being prosecuted, directly taking cognizance, my lords, is impermissible.
Where is the order of taking of cognizance?
Please, my lord, page number 16, first case. Say 16, please, my lords.
Order sheet ಕೊಟ್ಟಿದ್ದೀರಾ?
Please, my lord, please. That's internal page number 9. Chartered copy.
192 ಆದ್ರೆ ಬೇಕಾಗಿರ್ಲಿಲ್ಲ, ಬಟ್ ಇದೆರಡು ಇದೆಯಲ್ಲ.
ಹೌದು ಸರ್, ಹೌದು. IPC ಇದೆ.
ಏನ್ ಲಿಸ್ಟ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಷ್ಟೊಂದು ಹಾಕಿದ್ದೀರಾ?
ಅಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀನಿ ಅಷ್ಟೇ, ಎಲ್ಲ ಎಂಟೈರ್ ಹಾಕಿರ್ಲಿಲ್ಲ. ಅದು ರೆವೆನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್, ಮೈ ಲಾರ್ಡ್. ದೇ ಸೇ these are the revenue records, my lords, which wherein my lord Sagoli chit etc. has been issued, and the loans have also been obtained. These are all issued in the year 2012. And my lord,
ಇದು what's that sanction ಬರ್ದಿದ್ದಾರೆ ಏನಾದ್ರು
ಇದ್ರೊಳಗೆ subject to what my learned friend says, in the charge sheet, my lords, I did not find anywhere, my lords. PSI as Sub-Inspector Police has filed the charge sheet, my lord. It's all the, if I, your lords, please to permit me, my lord, the page number 8 in the final report, list of documents ಹಾಕಿದ್ರಲ್ಲಿ, all the witnesses, my lord, they speak about the documents, and all the witness number 15 onwards are the police constables.
ಈಗ ಎಷ್ಟು ಜನ ಪೆಟಿಷನರ್ಸ್ ಇಲ್ಲ? ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 ಮಾತ್ರನಾ?
ಎರಡು ಕೇಸಲ್ಲಿ ಇಬ್ರು, ಒಂದು ಅಕ್ಯೂಸ್ ನಂಬರ್,
ಎರಡು ಕೇಸ್ ಯಾವ್ದಿದೆ?
my lord, the one is accused number 1, my lord, and the accused number 2.
ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಕೊಡಿ.
Accused number 1 is
sanction judgments ಕೊಡಿ.
my lord, kindly permit me to at 2:30 I will get there.
No. What is this?
I do bow down, my lords. I do bow down. I will.
ಬರ್ಕೊಡಿ. Yes, sir. ಡಮ್ ಶರಾಡ್ಸ್ ಆಡ್ತಾ ಇಲ್ಲ ನಾವು ನನ್ನ. The petitioners in both these cases are public servants, are at the doors of this court calling in question proceedings in CC. ಅದರ ಗೊತ್ತಾ?
ಹೌದು ಹೌದು.
ಎಲ್ಲಿ ಉಂಟು?
CC ನಂಬರ್ 984/2022 in the prayer, my lords.
CC so and so registered for offences punishable under section 409 and 420 of the IPC. Heard so and so. Facts in brief germane are as follows. A complaint comes to be registered by the second respondent, a public servant, the Tahsildar, against several persons including these petitioners. While registering the complaint, the offences alleged were the ones punishable under section 192A, 409 and 420 of the IPC. The police conduct investigation and drop the offence under section 192A of the 192A of the Land Revenue Act,
Karnataka Land Revenue
of the Land Revenue Act, and sustain the offences under section 409 and 420 of the IPC. It is therefore the examination at the hands of this court at this juncture being whether the offences under section 409, 420 must be permitted to be continued. The learned senior counsel P.P. Hegde, appearing for the petitioner, would vehemently contend a threshold bar for the concerned court to take cognizance and proceed with the matter on the score that there is no sanction accorded by the competent authority to register to prosecute these petitioners as obtaining under section 197 of the CRPC. The learned senior counsel submits that it would cut at the root of the matter and would seek to place reliance upon the judgment of the apex court in the case of Srinivasan versus so-and-so, 2023 SEC Online SC page 951. The learned senior counsel further submits that if the cognizance was in place, it would have been open for the prosecution to continue it would be open for the respondent to prosecute the petitioners, not otherwise. As the concerned court has taken cognizance without there being a sanction in the case at hand, it would cut at the root of the matter therefore seeks quashment of these proceedings. Per contra, the learned additional SPP, B.N. Jagdish appearing for the respondent would submit that sanction, the plea of sanction can be taken anytime during the course of the proceedings is what is the law in the as held by the apex court in the case of B.S. Srinivasan versus State of Karnataka 2022 SEC page 233. In that light, the learned additional SPP submits that interference must not be made at this juncture as the petitioners have allegedly allegation have allegedly
the issuance of the Sagoli cheat in the absence
allegedly issued Sagoli chits without verification and have committed gross misconduct. I have given my anxious consideration submissions made by the respective learned counsel and have perused the material on record. In furtherance whereof, the threshold issue that falls for consideration at the outset is whether the concerned court was right in taking cognizance for offence punishable under section 409 and 420 of the IPC without a sanction being placed before it. The facts narrated here and above are beyond contest. The position of these petitioners are a matter of record that they are public servants. In the course of discharge of their official duties, are alleged to have issued certain Sagoli chits to several persons without verification of the records. Therefore, it cannot but be said that these petitioners, while discharging their official duty, have indulged in the aforesaid crime, aforesaid allegations. If regard is had to the fact that they are alleged of offences while discharging official duties, it becomes imperative for the prosecution. It becomes imperative for the concerned court to continue the trial only on a sanction being placed before it to prosecute these public servants. The law in this regard is too well settled, which would not, therefore, delving deep into the law as laid down by the apex court would not be necessary. The apex court in Srinivasan versus State of Andhra Pradesh has considered the entire spectrum of the law right from 1955 on the so with regard to the sanction. In that light, the petition deserves to succeed, albeit in part. The concerned court has now, if the law as laid down by the apex court in Srinivasan is pitted the facts obtaining in the case at hand, what would unmistakably emerge is the unsustainability of continuance of the trial, for the reason that the police, after investigation, drop 192A of the Karnataka Land Revenue Act and drop a charge sheet for offences punishable under section 409 and 420. The summary of the charge sheet as obtained in column number 17 reads as follows. Pursuant to the charge sheet being placed before the concerned court takes cognizance of the offence and issues summons to these petitioners. The order of taking of cognizance reads as follows. What is discernible from the aforesaid extract is that there is no sanction granted to these petitioners, sanction granted to prosecute these petitioners. In the light of the law laid down by the apex court, in the light of the law elucidated by the apex court in Srinivasan Supra, and the fact that there was no cognizance when the concerned court took, that there was no sanction when the concerned court took cognizance of the offence, the concerned court shall not now be permitted to proceed against the these petitioners for the aforequoted offences unless a valid sanction from the hands of the competent authority is placed before the concerned court. For the aforesaid reasons, the following order. The writ petition stands, these petition, criminal petitions stand disposed. The concerned court, which court is that? The concerned special court.
JMFC
JMFC. The proceedings before the concerned court stands quashed. However, liberty is reserved to the concerned court to revive the proceedings from the stage at it was earlier, if the state would place the sanction granted to prosecute these petitioners before the concerned court, Jagdish sir.
All contentions, my lords.
All contentions except the one that is urged will remain open.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ. It is there, my lord, your lord.
ಅಲ್ಲ, sanction ಇದ್ರೆ revive ಆಗುತ್ತೆ ಅಷ್ಟೇ.
If it is there, my lords.
Yes, if it is there.
That also, your lords, if it is there.
ಏನು?
If they produce it, my lords.
ಅದನ್ನ ಹೇಳಿದ್ದೀನಲ್ಲ. Yes. Stands quashed, the concern, ಹೇಳಿದ್ನಲ್ಲ ಅದಲ್ಲ? Yes. All other contentions except the one considered in the course of the order shall remain open.
Yes. In the event of their filing.
Shall remain open to be urged at the appropriate stage before the appropriate fora at the appropriate time. Yes.
So grateful.
Yes. Eradu.
Great.
Number 12.
Page number 14, 496, my lord. Covered judgment.
Yes.
Passed with.
ಅದೇ Carlton Towers.
ಹೌದು ಸರ್.
Page 496. Disposed. ಎಲ್ಲ ಮಾಡಿದೆ, ಎಲ್ಲದೂ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ. A1 ಇಲ್ಲ, A1 to A20 ಎಲ್ಲ ಆಗೋಗಿದೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಆಗಿತ್ತು, ಯಾಕಾಗಿಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಇದು?
ಅಷ್ಟೇ ಬಹು ಟೈಮ್ ತಗೊಂಡು ನೋಡ್ತೀನಿ ಅಂತ ಹೇಳಿ.
ಜಗದೀಶ್ ಸರ್ ನೋಡ್ಬೇಕಾ ಇನ್ನು?
ಚಾರ್ಜ್
ಏನಿಲ್ಲ, ಇಟ್ಸ್ ಕವರ್ಡ್. ಅಯ್ಯೋ, ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆದ್ಮೇಲೆ ಅದು ಮಾಡಿರೋದು. Because
My lord, appearing for
14 lakhs ಬಂತಾ?
ಬಂತು ಸ್ವಾಮಿ.
ಕೊಡಿ ಇದು ಮುಗಿಸ್ಕೊಂಡು. Complainant is served unrepresented.
Complainant, I am the complainant, my lord. Accused.
Sorry, accused is served. ಇದಾಯ್ತಲ್ಲ, ಮತ್ತೇನು ಉಳಿತಿಲ್ಲಿ? ಅಲ್ಲೇ ಮಾಡ್ಕೊಳ್ಳಿ.
ಹೌದು ಸರ್. Nothing, sir.
The petitioner is before this court seeking the following prayer. Owing to the prayer of the petitioner, hearing the petitioner, the complainant and the state, this court on 19/9/2025 had passed the following order. ಅದು 14 lakhs ಅವರು ವಾಪಸ್ ಕೊಡ್ತಾರೆ. The learned counsel for the petitioner submits that pursuant to the order dated 19/9/2025, amount of 14 lakhs is already returned.
Not 14 lakh, my lord, it is 18 lakhs ಬಂತು.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ?
18 lakhs ಬಂದಿದೆ ಸರ್.
18 lakhs is returned to the petitioner. In the light of the said amount being returned to the petitioner, the learned counsel for the petitioner submits that nothing further would survive for consideration in the hands of this court. In that light, the petition is disposed as having rendered infructuous.
Please.
Next.
Order.
14.
I give a respondent to my lord. My lord, on the previous occasion.
Yep.
My lord?
We have given.
Yes, ma'am. My lord needs. Lord, I apologize to him.
No problem. I've seen it, yes.
My lord, on the first occasion of the hearing, my lord had passed an order stating that the matter has been heard and the offences have been made out. My lord,
No, I have not passed an order. That was my opinion.
My lord, section 463 of IPC, all the ingredients have been satisfied. That is forgery for purpose of cheating. And section 420 cheating is also, ingredients are satisfied.
Let him come. Let 447, yes.
Yes, my lord. And 463 also, my lord, with enough documentary
No, you have
evidence.
lost in the suit. There is no injunction. And
No, my
you
lord.
challenge it in the MFA. There is nothing in your favor.
My lord,
You
we
show
have-
me one order of the civil court that is in your favor.
My lord, we have one in the civil court.
Which one?
IA number 2 and 4.
Regarding what?
OS
Possession?
counter claim. We
In the
received-
counterclaim, you have an injunction?
Yes, my lord. Which is when they filed an MFA 2081/2024
Huh.
and the other MFA
Hmm.
against IA number 4.
Forgery, I doubt. 447, yes, is sustainable, no doubt about it. 447, criminal trespass is definitely sustainable. Let him come. Hmm? Other offenses we'll see. Objection. ಅವ್ರು discharge ಹಾಕೊಳಕ್ ಕೇಳ್ಕೊಂಬರ್ತೀನಿ ನೋಡಿ. Yes.
15.
Petitioners. For the respondent. That's a sought for adjournment in the morning. Senior, there is an income. Senior is out of station.
ಇದರಲ್ಲಿ ಒಂದು offense against the husband or against the in-laws.
Yes.
ಒಂದು ಲೈನ್ ತೋರಿಸ್ಬಿಡಿ. ಒಂದು ಲೈನ್. Generally husbands say don't grant stay. I have granted stay quoting the summary of the charge sheet.
Next week, my lords.
Huh?
Next week, my senior will.
I vehemently argued ಅಂತ ಹೇಳೋಣ ಬಿಡಿ.
File is not with me. Plus, I don't have the file, my lords. Next week I'll.
ಆಯ್ತು. ಕೊಡೋಣ.
ಸ್ಟೇ ಲಾರ್ಡ್ಸ್ ಇದರಲ್ಲಿ ಒಂದು ಲಾರ್ಡ್ ಸಿನ್ಸ್ ದಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆರ್ ಸ್ಟೇಡ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಐ ಮೂಡ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್
ಪಾಸ್ಪೋರ್ಟ್ ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು ನೀವು?
he wants to travel to Japan on work, my lords.
You file an application here, I will consider
My lords,
in these proceedings.
Monday, my lords.
Whenever you want to, when Japan ಯಾವಾಗ ಹೋಗ್ಬೇಕು?
Lords, he's been like.
Or you file it before the court, I will direct the court to consider the application.
Yes, my lord, it is already filed.
Then I will direct the court to consider the application.
That order, my lords.
That I will.
Yes.
With travel itinerary being in place,
Yes,
tomorrow if it is dismissed.
Yes, my lords. I will produce all the documents.
Huh?
I will produce all the documents with the trial court.
The petitioners in the case at hand are the husband, Mill, Phil, ಇನ್ಯಾರಿದ್ದಾರೆ?
Brother-in-law.
Mill, Phil and Bill. This court on 5/8/2025 had passed the following order. The order extracted the summary of the charge sheet as obtaining in column number 17 to grant an interim order of stay even to the husband, holding that the allegations as found in the complaint or in the summary of the charge sheet was only minor skirmishes between minor skirmishes what would happen in a family between the husband and the wife. In the light of the law laid down by the apex court in the case of Achin Gupta, which is subsequently followed in the case of Shobit Kumar so and so 2025 SSC online SC 2059, the petition would necessarily meet its success unless the counsel for the complainant would demonstrate otherwise. The learned counsel for the petitioner now submits that he has filed an application before the concerned court to travel to Japan owing to his avocation. The concerned court is not considering the application due to the pendency of the subject petition and therefore seeks a direction at the hands of this court to the concerned court to hear the application and pass necessary orders thereon. It is made clear that pendency of this petition or the interim order that is granted and continued today would not come in the way of the concerned court considering the application on its merit. It is made clear that the petitioner shall place on record before the concerned court a travel itinerary of his leaving the shores of the nation and coming back to the shores of the nation Any deviation thereon would be viewed seriously. Viewed seriously.
Lords, now
List-
we have filed only for renewal of the passport, my lords. Once the
Passport renewal ಅವ್ರು ಮಾಡಕ್ಕಾಗಲ್ಲ.
travel itinerary ಬಂದ್ಮೇಲೆ ಅದನ್ನ ಕೊಡ್ತೀವಿ.
Passport renewal ಅಲ್ಲಿ ಮಾಡಕ್ಕಾಗಲ್ಲ. You'll have to file it here. You can't do that.
Yes.
ಅದಕ್ಕೆ ಇಲ್ಲಿ application ಹಾಕಿ everything I will grant here
I'll
only.
file, my lords, I'll file that.
Therefore, learned concern konbeda. Learned counsel with the petitioner submits that he would file a necessary application. Then adu beda. Ille haki alla will pass orders on that. Don't do that.
Interim order extension.
Interim order subsisting. First ಹೇಳಿದ್ನಲ್ಲ ಈಚೆಗೆ passport ವಿಷಯ ಬಿಟ್ಟು ಮಿಕ್ಕಿದ ಮುಂಚೆ ಹೇಳಿದ್ದು ಕಂಟಿನ್ಯೂ ಮಾಡಿ. Yes, ಯಾವತ್ತು ಬೇಕು ಸರ್?
Next.
We
2 weeks time.
ಏನಿಲ್ಲ ಇಷ್ಟೇ ಫೈನಲ್ ಆರ್ಡರ್. Yes. List on 9th. ಅಪ್ಲಿಕೇಶನ್ ಮಾಡಿ ಹಾಕಿದ್ರೆ ಮೂವ್ ಮಾಡಿ.
16. Lordship, for the first respondent in this matter, Lordship, we pray for a passover, Your Lordship.
Lord,
ಬಾಲನ್ ಸರ್ ಅರ್ಜೆಂಟ್ ಮಾಡಿ ಹಾಕ್ಸಿದ್ದು.
Lordship, yesterday he was under the miscommunication that will be held up, taken up at 2:30, Your Lordship. We humbly
2:30?
pray.
Correct. No, that was not, I was also under that miscommunication.
We apologize, Your
But
Lordship.
we are
Kindly
also
have-
engaged the senior counsel. He told me that
Lordship, the
2:30.
Asma
Not,
processor.
no, Sandesh Chowta is appearing in this case.
ಹಾಗಾದ್ರೆ ಇವತ್ತು ಒಳಕ್ಕೆ ಆಗಲ್ಲ ಇದು.
From Lord, any other date, not it
No
may
other
be,
date.
instead of considering the vacating, Lord, it may be disposed of on the next date.
What disposed of?
The petition may be finally,
306.
please. Any date, Lord,
ನಾನು ಅದರಲ್ಲೇ ಬರ್ದ್ಬಿಟ್ಟಿದ್ದೇನೆ ಎಲ್ಲ.
that is on the point of 187, not about on merits.
Not on merits, correct.
Request for a passover, Your Lordship.
ನೀವು ಹೇಳಿದ್ರೆ ಹೇಳಿ.
Lord,
2:30 ತಗೊಳ್ಳೋಣ?
no, Lord, any date in next week, Lord.
ಎಂಗೇಜ್ ಮಾಡಿದೆ ಅಂತ ಈಗ ಅಂದ್ರೆ.
ಹೌದು, but I have to, he is on the way from Dharwad, sir.
ಧಾರವಾಡಿಂದ ಒಂದು ವೇ. ಪಾಸ್ ಓವರ್ ಮಾಡಿ. They are in a hurry, sir. Interim order, you make out a case now for extension of interim order. 2:30. Is he coming online?
No, Lord, physically is appearing.
ಮತ್ತೆ ಹೇಳಿ. He is coming, right?
No, 2:30 he'll come, please.
2:30 he will come.
Please.
All right. Because the offense is grave.
But other offense is concerned, that is A1 and 2. 306 is concerned, there is no material for so far as these petitions.
Lord. These are the teachers, alva?
So,
Teachers in the masjid, ada ಇದು.
no, is a president of Waqf institution had a illicit relationship with the A1, and we are instigated A1 to extort money and.
All right, 2:30.
Happy for the petitioner. I pray for some time.
Complainant is served. What's the matter? 13:10 now. The complainant is served on 30/10/2025. 13, huh? 13/10/2025, therefore give to grant one more opportunity for representation of the complainant, less the matter on 9th interim order subsisting, we continue to the next day. ಅಲ್ಲಿ heard petitioner B.N. Jagdish sir.
Short adjournment.
Short adjournment.
Short accommodation.
ಅದು ಇಲ್ಲ, ಎಲ್ಲ ಒಂದೇ. Adjournment, accommodation ಎಲ್ಲ ಸೇಮ್. Covered.
My lords.
ನಾನೇ ಬರ್ದಿದ್ದೀನಿ. ಬೇರೆ
It's kindly be passed over, my lords.
Wait, madam.
Covered number wise. Number wise.
ಅದಕ್ಕೆ ಅವ್ರು ಕೇಳ್ತಾರೆ.
It may be passed over, my lords.
ಬೇರೆ accused dismiss ಮಾಡಿದೇವಲ್ಲ ಇಲ್ಲಿ. Same crime, page 173.
My lords, it may be passed over, my lords.
Pass over.
Stop.
I appear for the second respondent in this case, my lord.
ಯಾವ್ದು ಸರ್?
This is, my lord, second respondent is a lady. On her complaint, the first respondent.
ಅದೇ ಎರಡು ಬಿ ರಿಪೋರ್ಟ್.
ಹೌದು, ಇಲ್ಲ ಸರ್, ಎರಡು ಬಿ ರಿಪೋರ್ಟ್ ಇಲ್ಲ, ಆದ್ರೆ ಒಂದೇ ಆಗಿರೋದು. ಬಟ್ ಅವ್ರು ಎರಡು ಅಂತ ಹೇಳ್ಕೊಂಡಿದ್ದಾರೆ ಪೆಟಿಷನ್ ಅಲ್ಲಿ.
ಹೌದು.
ಅದು ಇಲ್ಲ ಸುಮ್ಮ ಆ ರೀತಿ ಆಗಿಲ್ಲ. Kindly permit me to.
ಹೇಳಿ.
Your lordship may kindly say, this respondent lady Menaka lodged a complaint with the first respondent, Rajajinagar Police. Rajajinagar Police registered a case under section 354, 504, 506, 509 and read with 149 IPC. Also under section 3, subsection 1, class
Atrocities
E,
Act.
H or
Atrocities Act.
Atrocities Act. Thereafter, my lord, case was investigated. Police filed a bay report before the London Sessions Court, wherein bay report was accepted. Against that, the petition approved this honorable court. This honorable court directed the London Session Judge to hear fresh. Thereafter, protest petition was filed. That was
They report.
ಒಂದೇ ರಿಪೋರ್ಟ್ ಎರಡಿಲ್ಲ ಅದೇನೋ ಸ್ವಲ್ಪ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಆಮೇಲೆ ಏನಾಗಿದೆ ಪ್ರೊಟೆಸ್ಟ್ ಪೆಟಿಷನ್ ವಾಸ್ ಹರ್ಡ್ 4 witnesses were examined. Trial judge took cognizance of the same, issued a summons to the accused. At this stage, the petitioner, who is working as a deputy director finance in ESI hospital, filed this 482 petition, used this petition as a tool to escape from the trial. The facts of the case is this, this lady is working as a housekeeper in ESI hospital, and this petitioner is also having official quarters in the ESI hospital. He used to call this lady for cleaning the house and also to do body massage, removal of body hair, and so many other sexual harassment, etc. Not only against this lady, several other ladies were also subjected for this. But this lady went.
He was running a spa.
No spa. That deputy director, who is a senior officer in ESIS,
carry on.
He has misused the position and exploited this second respondent. Therefore, she went to the police station, lodged the complaint, and the trial is pending before the London Session Judge. At this stage, your lordship has granted interim order of staying the proceedings of the court. My submission to your lordship is there is sufficient material to show that they have done this crime, and there are records, there are exhibits, there are witnesses. Therefore, I
Where is the order of the court taking cognizance?
Yes, it is there. My lord, it is at ink page number 26. May I read, my lord?
One ನಿಮಿಷ. Page of the petition objections ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ, ನಾನು objection ಹಾಕಿ.
26.
26. Orders.
One moment.
Ink page.
I'll read it.
On going through the material.
ನಾನೇ ನೋಡ್ತೀನಿ.
Sir.
ಓದಲಾಗದು ಎಲ್ಲ ಇರುತ್ತಿಲ್ಲ ಅದಕ್ಕೆ. ಇದೇನು CD ಪೆನ್ ಡ್ರೈವ್ ಎಲ್ಲ ಇದೆ.
Please, my lord. ಮೊಬೈಲ್ ಫೋನ್ ಸೀಸ್ ಆಗಿದೆ. ಆಮೇಲೆ 4 ಜನ ಸಾಕ್ಷಿಗಳನ್ನ ವಿಚಾರಣೆ ಮಾಡಿದ್ದಾರೆ.
ಯಾವುದಕ್ಕೆ?
ಈ ಪ್ರೊಟೆಸ್ಟ್ ಪೆಟಿಷನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ
ಗೊತ್ತಾಯ್ತು.
ಆಮೇಲಿಂದ ಕಾಗ್ನಿಸೆನ್ಸ್ ವಾಸ್ ಟೇಕನ್.
Where is the statement? 164 statement ಇದೆ.
Page 84.
Oh, ಎಲ್ಲ. How was interim order granted then? ಅದೇ 2B ರಿಪೋರ್ಟ್ ಇದೆ ಅಂತ.
ಓದ್ಲ
ಬೇಡ, ಪ್ರಶ್ನೋತ್ತರ ಮಾತ್ರ ಓದ್ಬೇಡ.
Page 93 more particular. Page 93 is the complaint.
ಬಂದಿಲ್ಲ. Horrible ಆಗಿದೆ.
ಹೌದು ಸರ್. My humble submission to your lordship is.
No, they should trial ಆಗ್ಲೇಬೇಕಿದೆ.
ಹೌದು ಸರ್. is a question of trial. So ಮತ್ತೆ evidence can't be appreciated at this stage
No, no,
under
that's
section
482, that
House.
you are for stage and our stage change
House.
now, but this case definitely requires.
ಇವ್ರೊಬ್ರೇ ಅಲ್ಲ ಸ್ವಾಮಿ, ಸುಮಾರು ಜನಕ್ಕೆ ಹೀಗಾಗಿದೆ.
ಅಲ್ಲ, ಅದೇ ಅದಕ್ಕೆ.
ಅಸೋಸಿಯೇಷನ್ ಆಕ್ಷನ್ ಕಮಿಟಿ ಮಾಡ್ಕೊಂಡು.
No, this is very horrendous. ಅದು interim order 2 ಬಿ ರಿಪೋರ್ಟ್ ಇದೆ ಅಂದ್ಬಿಟ್ಟು ತಗೊಂಡು.
They've taken a contention earlier that the sessions court took cognizance, but the sessions court in the cognizance order did not say for what offense it's taken.
ಅದೇ some technical ground ಅಲ್ಲಿ ಆಗಿರುತ್ತೆ. Let me see.
So admittedly, petitioner hails from Madhya Pradesh, he is not in service there and is trying to escape the trial. Therefore.
No, don't worry about it. We'll definitely send it for trial, but the petitioner's counsel should come. Pass over ಮಾಡ್ತೀನಿ. Pass.
20.
7, the respondent.
7A.
7A, so on the objection file ಮಾಡಕ್ಕೆ objection ready ಇದೆ.
Complainant ನೀವು objection ಹಾಕಿದ್ದೀರಾ? ಹಾಕ್ತೀರಾ? Learned counsel appearing for the complainant and the Lokayukta in unison seek time to file statement of objections. List the matter on 9th objections, if any, by then. Interim order subsisting will continue to the next date of hearing.
Good.
Take notice. Again, first time. Oh, learned counsel, so and so undertakes to enter appearance for Hakidira. Learned counsel submits his entered appearance for the second respondent, registry to print the name of so and so is appearing for the second respondent.
21.
For the petitioner.
364A.
64A, my lords. At the stage of FIR itself, we had filed a petition before this honorable court. If my lords would kindly see.
Discharge ಆಗಿದೆಯಾ?
ಇಲ್ಲ, ಇದರಲ್ಲಿ they have taken a contention by showing the photographs. That photograph itself shows that there is no kidnapping.
Photograph ಅಲ್ಲ, kidnapping video ಅಲ್ಲಿ ಗೊತ್ತಾಗತ್ತೆ.
In fact, it was there, my lords. Page 52 may kindly be seen, my lords. From the earlier petition.
Yes, sir.
Otherly, our prayer may kindly be seen, my lords. But in fact, he was, all through the police have been harassing him by filing multiple rowdy sheeters, externments, everything has been quashed. And in the petition which we had filed then, we had taken these contentions as to in what way the police were cautioning him, threatening him. Our prayer may kindly be seen, page number 71 early. We have specifically said how this FIR came to be falsely registered against him. In addition to that, my lords, at that stage, we had even alternatively sought for transfer of the investigation, knowing that this FIR was malafidly registered against us. Now, in this. No, sorry.
Charge sheet ಆಗಿಲ್ವಾ?
Charge sheet ಆಗಿದೆ ಈಗ. I'm at a stage of charge sheet itself. In fact, we had then withdrawn the petition at that stage.
Correct.
Filed earlier for the reason that we had no proper instruction. This person was not available for us at all. It was only his family. Now,
where is the order taking cognizance?
Order taking cognizance is at page number 32. It's a short order, minutes. Though one of the provisions mentioned there is 142(2), it ought to be 140 subsection 2.
BNS. Yes.
BNS out. 142 subsection 2 ಅಲ್ಲ 140 subsection 2 ಆಗಬೇಕು.
ಅದು ಇನ್ನೂ ಟೀಚಿಂಗ್ ಪ್ರಾಬ್ಲಮ್ಸ್ ಇದ್ದೇ ಇರುತ್ತೆ. ಅವರು ರೂಢಿ ಆಗ್ಬೇಕಲ್ಲ IPC ಇಂದ CRPC ಇಂದ BNS.
It's not that is only typographical.
That's a typo.
Please, my submission is whatever is the allegation here, the allegation. My only concern is 364A, which is punishable with death. That is what is not attractive. There may be other allegations as such. Now, despite we having the CCTV recordings, including video, the police come to the scene of occurrence to conduct a mahazar.
You mean to say I will remove A and retain 364?
Even 364 kidnapping as such would not attract me. In fact, the CCTV recordings would specifically indicate the presence of the complainant in the house voluntarily. They come on a bike, they come in a car, they go voluntarily. The photographs may kindly be seen, which we have produced. The photographs indicate they are going voluntarily on their own. But our difficulty, is even let's say for a moment, there were some cases against him earlier. For the past almost 7 to 8 years, absolutely no cases at all.
ಅಂದ್ರೆ ಇರಬಾರ್ದು ಅಂತನಾ?
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಈಗ ಅವನ ಮೇಲೆ against the respondent too, there is a check bounce case filed about 3 years back. That is pending.
So
I'm prosecuting that case. Now, for what reason I have taken him home, my lords, they say that you return my money. I'm prosecuting the check bounce case in the court. Now, to that extent, my lords, the allegations of 364A, my lords, kidnap as such, that is something which is not attractive. Moreover, my lords, the investigation ought to have been done. Now, the reason what they say as far as the CCTV is concerned, they say they issued a notice to the wife of this petitioner asking her to produce the CCTV recordings. She has not produced, and that is the reason we do not have evidence. Page number 160, my lords, is the
whose wife?
That is the petitioner's wife, accused wife. I am protected under Article 23, though I don't intend to take that contention. But it was the bounden duty of the investigating agency to investigate as to what actually has transpired in the house. Page number 318 for a moment may kindly be seen, my lords. 318 is the date when the police, on the next date of the incident, they have come to my house. 23rd is the incident. 24th, the police come to the house. But the CCTV recording indicates even their presence. So if the incident, my lords, was captured on CCTV, it was their duty to conduct an investigation to rule out not only whether the complainants, my lords, whether the allegations are made out or not, or even for that matter, the accused also had a say to specifically indicate that there is a false implication. So, given this, maybe the investigation, the charge sheet may sustain as far as the allegations are concerned. But 364A as such, given that there is a death as a punishment. Given this, my humble submission is no factual allegations are made out to attract 364A as such. And in addition to that, 201 to file a charge sheet for 201, which is 238 BNS. On the score that
destruction of evidence.
On the score that the accused wife has not produced the CCTV recordings on our notice.
You also did not produce.
I am protected under 23 minutes. I am protected to the extent that I need not produce any evidence which is either in my favor or against me. Even if it was in my favor, the police have actually not even made attempts to come and to collect the evidence.
Article 23.
So they cannot now file a charge sheet to say that 201 here is attracted, and for that reason, 364A as well. So my submission is, even for that matter, if at all the allegations here wouldn't attract basically 364A. Is the primary reason sought for caution of the charge sheet. Even the background may kindly be seen, my lords.
What background?
To
His background.
The rowdy sheeters on 2 occasions, they had taken out the rowdy sheet against him. That came to be quashed. Then 2 externment orders, even that, my lords. So by some means, my lord, the police want to ensure that his name remains as a criminal element as such.
Remains in circulation.
CCTV
CCTV, whether I should give it or not, whether the investigating agency has to collect it. I have given the photographs.
Photographs will take you nowhere, sir. It's neither here nor there.
So CCTV, I cannot even. In fact, presently we don't have that because of the overwriting.
DVR's overwriting.
In fact, page 186 and page 220, 220 was issued to him only. He received it.
Our evidence avare kodtara neevenu. He is protected under Article 23. Yes.
364 ne escape agaki 201 serkandide. The entire incident is recorded by CW.
Discharge haktira? Alva? Yes. Learned counsel arguing the matter. Seeks leave of this. Why do you invite a finding? Please. Yes. After arguing the matter at length, seeks leave of this court to withdraw the petition and avail the remedy.
Arguing the matter at length, madam, otherwise I wouldn't even give a hearing.
The learned counsel for the petitioner, Amar Korea, submits that he would avail the remedy of filing a discharge before the concerned court. ರಿಸರ್ವಿಂಗ್ ಸಚ್ ಲಿಬರ್ಟಿ ದಿ ಪೆಟಿಷನ್ ಸ್ಟ್ಯಾಂಡ್ಸ್ ಡಿಸ್ಪೋಸ್ಡ್. ಮತ್ತೆ ಇಲ್ಲೇ ಬರ್ತೀರಾ? Yes.
22.
Petitioner, my lord. Appearing for respond number 2, my lord. We have not filed wakalat yet. We'll file in counter, my lord.
ಇದರಲ್ಲಿ
Respondent 2 has made us accused number 3, my lord.
No, he has to make the victim as an accused.
ವಿಕ್ಟಿಮ್ ನ ಪಾರ್ಟಿ ಮಾಡಿ.
Victim ಬರಲ್ಲ ಇವರು.
ಯಾರು ಬರಲ್ಲ?
ಯಾಕೆಂದ್ರೆ
ವಿಕ್ಟಿಮ್ ಪಾರ್ಟಿ ಮಾಡ್ತೀರಾ ಇಲ್ಲ ಮಾಡ್ಲಾ?
ಮಾಡ್ತೀನಿ.
ಮತ್ತೆ
ಯಾಕೆಂದ್ರೆ ಫಸ್ಟ್ ಲೈನ್ ಅಲ್ಲಿ ಯಾರು ಇಲ್ಲ, ವ್ಯವಹಾರ ಮಾಡಿದ್ರೆ ಯಾರು
ಯಾರು ಇಲ್ವಾ? ವಿಕ್ಟಿಮ್ ತೋರಿಸ್ತಾ ಇದೀವಿ.
ವಿಕ್ಟಿಮ್ ನಮ್ಗೆ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಇಲ್ಲ.
ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಬಿಟ್ಟಾಕಿ. You are drawn into these proceedings because of that complaint. First ಇವ್ರು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರು. Now he has been transposed as an accused. The other complainant is the victim.
ವಿಕ್ಟಿಮ್ ಕಂಪ್ಲೇಂಟ್ ಬರ್ತಾರೆ, ಬಟ್ ಏನಂದ್ರೆ ನನ್ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಏನಂದ್ರೆ ನಾನ್ ಕೆಲಸ ಮಾಡೋರು.
ನೀವು ಕೆಲಸ ಮಾಡೋರು, ಕೆಲಸ ಮಾಡದೇ ಇರೋರು, ಅಕೌಂಟ್ ಬೇರೆಯವ್ರದ್ದು. ಆ ವಿಕ್ಟಿಮ್ ಕಂಪ್ಲೇಂಟ್ ಇಂದ ಇವರು ಡ್ರ್ಯಾಗ್ ಮಾಡ್ಲೇಬೇಕಲ್ಲ.
ಇಂಟ್ರಿಮ್ ಸ್ಟೇ ಮಾತ್ರ.
ನೆನ್ನೆ ಮಾಡಿದ್ರಿ, ಇವತ್ತು ಸ್ಟೇ ಕೊಡ್ತಾ ಇದ್ದೆ. ನೆನ್ನೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರಿ.
ಇಲ್ಲ, ನಾನು ಮಾಡ್ತೀನಿ, ಈಗಲೂ ಮಾಡ್ತೀನಿ.
ಆರ್ಗ್ಯುಮೆಂಟ್
ಇಲ್ಲ, ಪಾರ್ಟಿ ಮಾಡ್ತೀನಿ. ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ ರೆಡಿ ಇದೀನಿ. ಯಾಕೆಂದ್ರೆ ಅವ್ರ ಕಂಪ್ಲೇಂಟ್ ಕೊಡಕ್ಕೆ.
ಯಾಕೆಂದ್ರೆ
ಇಲ್ಲ, ಯಾಕೆಂದ್ರೆ ಅವ್ರ ಅಮೌಂಟ್ ಜಾಸ್ತಿ ಇರೋದ್ರಿಂದ ಕ್ಲೈಮ್ ಬಂದ್ ಮಾಡಕ್ಕೆ ಬರಲ್ಲ. ವಿಕ್ಟಿಮ್ ಬಂದು ನನಗ್ ಕಳ್ಸಿಲ್ಲ, ಅಕ್ಯೂಸ್ ಕಳ್ಸಿಲ್ಲ.
ನಿಮಗೆ ಯಾರು ಕಳಿಸಿದ್ದಾರೆ ಮುಖ್ಯ ಅಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ, ಯಾರು ವಿಕ್ಟಿಮ್ ಅದು ಮುಖ್ಯ. ನೀವು ಪಾರ್ಟಿ ಮಾಡದೆ ಹೋದ್ರೆ ನಾನು ಸ್ಟೇ ಕೊಡಕ್ ಆಗಲ್ಲ.
ಇಲ್ಲ, ಪಾರ್ಟಿ ಮಾಡ್ತೀನಿ. ಇಂಟ್ರಿಮ್ ಸ್ಟೇ ಮಾತ್ರ. ಆಲ್ರೆಡಿ ಕ್ಲೈಮ್ ಮಾಡಿದ್ದಾರೆ. ಅಕ್ಯೂಸ್ 3 A3
ಅವ್ರನ್ನ ರೆಸ್ಪಾಂಡ್ ಮಾಡಿದ್ದೀರಾ?
ಅವ್ರು ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ ಡಿಫ್ಯಾಕ್ಟ್ ಕಂಪ್ಲೇಂಟ್ ಇನ್ FIR ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ A3. ಅವ್ರ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ.
Charge sheet in the IO report it is clearly mentioned that money belongs to CW1.
CW1 is the victim. CW1 ನ ಪಾರ್ಟಿ ಮಾಡಿದ್ರೆ ಸರಿ, ಇಲ್ಲ ಅಂದ್ರೆ I will not wash.
ಖಂಡಿತ ಮಾಡ್ತೀನಿ.
ಮಿಜೋರಾಂ.
ಹೌದು.
ಇಬ್ರು ಕರ್ಕೊಂಡೋಗಿ ರೈಸ್ ಸಪ್ಲೈ ಮಾಡಿ ಹೇಳಿ.
ಕರೆಕ್ಟ್ ಆಗಿದ್ದೀರಾ ಇಬ್ರು? ಆ ಕಡೆ ಒಬ್ರು, ಈ ಕಡೆ ಒಬ್ರು ಅಕ್ಯೂಸ್ಡ್, ಇಬ್ರು ಅಕ್ಯೂಸ್ಡ್ ನಾನೆಲ್ಲ ಅಂತ ಕೂತ್ಕೊಂಡ್ರೆ?
ಇಲ್ಲ, ಅವ್ರು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ ಥರ್ಡ್ ಪಾರ್ಟಿ ವಿಕ್ಟಿಮ್, ಅಲ್ಲಿಂದ ಇನ್ನೊಬ್ರಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ.
ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ as well.
ಇಲ್ಲ,
ಈಗ ಹೆಸರು ಕೊಡಿ, ವಿಕ್ಟಿಮ್ ಹೆಸರು ಹೇಳಿ.
ಲಿಂಡಾ ಐ ವಿಟ್ನೆಸ್ 1 ಪಾರ್ಟಿ ಮಾಡ್ತೀನಿ.
ಮಾಡಿ.
ಇಂಟ್ರಿಮ್ ಸ್ಟೇ. ಯಾಕೆಂದ್ರೆ ಕ್ಲೈಮ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅವ್ರು ಆಲ್ರೆಡಿ.
ಮಾಡ್ಲಿ ಬಿಡಿ.
ಅವ್ರದ್ದು ಅಮೌಂಟ್ ಇಲ್ಲ, ಅವ್ರದ್ದು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ ಯಾರಿಗೋ, ಅಲ್ಲಿಂದ ನನಗೂ ಬಂದಿಲ್ಲ. ಬಟ್ ನನ್ನ ಅಕೌಂಟ್ ಇಲ್ಲೋದು ಕ್ಲೈಮ್ ಮಾಡ್ತಾ ಇದಾರೆ.
ಎಷ್ಟು ಲಕ್ಷ?
1.5 ಕೋಟಿ.
ಮತ್ತೆ ಲಕ್ಷ ಅಲ್ಲ, ಕೋಟಿ.
ನನಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿಲ್ಲ, ಅವ್ರು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ ಯಾರಿಗೋ, ನನ್ನ ಅಕೌಂಟ್ ಅಲ್ಲಿ ಇರೋ ಅಮೌಂಟ್ ಕ್ಲೈಮ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ನಿಮ್ಮ ಅಕೌಂಟ್ಗೆ ಎಷ್ಟು ಬಂದಿದೆ?
ನನ್ನ ಅಕೌಂಟ್ ಅಲ್ಲಿ ಬಂದಿರೋದು ಬೇರೆಯಿಂದ ಬಂದಿದೆ.
ಬಂದಿದೆ ಎಷ್ಟು? ಎಲ್ಲಿ ಬಂದಿದೆ?
30,000 ಬಂದಿದೆ.
30,000? ಹೌದು. ಫೀಸ್ ಅಲ್ಲ,
ಟ್ರಾನ್ಸಾಕ್ಷನ್. ಎಂಟೈರ್ ಅಮೌಂಟ್ ಫ್ರೀಸ್ ಮಾಡಿದ್ದಾರೆ. ಅಕೌಂಟೇ ಫ್ರೀಸ್ ಆಗಿದೆ, ಅಮೌಂಟ್ ಮಾತ್ರ ಇಲ್ಲ, ಎಂಟೈರ್ ಅಕೌಂಟೇ ಫ್ರೀಸ್ ಆಗಿದೆ.
ಗೊತ್ತಿಲ್ಲ ಹಂಗಾರೆ ಎಷ್ಟಿದೆ ಅಂತ.
1.5 crore ಇದೆ ನಮ್ಮ ಅಕೌಂಟ್ ಅಲ್ಲಿ. ಆಕ್ಚುಲಿ ಅವ್ರು ಲಿಟಿಗೇಷನ್ ಮಾಡ್ತಾರೆ 1.5 crore. ನನ್ನ ಅಕೌಂಟ್ ಅಲ್ಲಿ 1.98 lakhs ಇದೆ.
ಅದಕ್ಕೆ ಕೇಳ್ತಾರೆ ಅದು 1.5 crore.
ಅದು ನನ್ನ ಅಕೌಂಟ್ ಬಂದಿಲ್ಲ, ಕಳ್ಸಿರೋದು ಯಾರಿಗೋ ಅವ್ರು ಅಂದ್ಕೊಂಡಿದ್ದ.
ಯಾರು ಕಳಿಸಿದ್ರೆ ನಿಮಗೆ?
ಬಂದಿಲ್ಲ. ಇಲ್ಲಿ ನೋಡಿ,
ಎಲ್ಲಿ ನೋಡೋದು? ಎಲ್ಲೂ ಇಲ್ಲ.
ಪಾರ್ಟಿ ಮಾಡ್ತೀನಿ.
ಪಾರ್ಟಿ ಮಾಡಿ. ಪಾರ್ಟಿ ಅಂದ್ರೆ ಪಾರ್ಟಿ ಇಲ್ಲಿ ಮಾಡಿ. ನೀವು ವೀಕೆಂಡ್ ಅನ್ಬಿಟ್ಟು ಪಾರ್ಟಿ ಮಾಡ್ತೀನಿ ಅನ್ಬೇಡಿ.
ಇಲ್ಲ, ಇಂಟ್ರಿಮ್ ಸ್ಟೇ
ಮತ್ತೆ ಇಂಟ್ರಿಮ್ ಸ್ಟೇ. ನೀವು ಇಂಟ್ರಿಮ್ ಸ್ಟೇ ಕೊಟ್ರೆ ಪಾರ್ಟಿ ಮಾಡ್ತೀರಾ?
ಖಂಡಿತ ಮಾಡ್ತೀನಿ. ಇಲ್ಲ, ಅದ್ ಮಾಡಿರಂದ್ರೂ ಮಾಡ್ತೀನಿ.
ಕೊಡಲ್ಲ. ಪಾರ್ಟಿ ಮಾಡಿ. ಅಕೌಂಟ್ ಇಂದ ಡೋಂಟ್ ವಿಡ್ರಾ ದಿ ಮನಿ unless we decide it.
It's been frozen, madam.
It is already frozen. We will
ಕ್ಲೇಮ್ ಮಾಡಿದ್ದಾರೆ.
ಫ್ರೀಸ್ ಆದ್ಮೇಲೆ ಎಲ್ಲಿ ಎತ್ಕೊಂಡು ಹೋಗಕ್ಕಾಗತ್ತೆ ದುಡ್ಡು?
ಇಲ್ಲ, ಅವ್ರು ಕ್ಲೇಮ್ ಮಾಡಿದ್ದಾರೆ.
ಕ್ಲೇಮ್ ಮಾಡ್ಕೊಳ್ಳಿ ಬಿಡಿ. ಫ್ರೀಸ್ ಡಿಫ್ರೀಸ್ ಮಾಡಿದ್ರೆ ದುಡ್ಡು ಹೋಗಕ್ ಸಾಧ್ಯ.
Application is filed before trial court.
451 ಅಪ್ಲಿಕೇಶನ್ ಏನಾಯ್ತು?
ಅವ್ರು ಮಾಡಿದ್ದಾರೆ, ಪೆಂಡಿಂಗ್ ಇದೆ.
ಪೆಂಡಿಂಗ್ ಇದೆಯಾ? Let the trial court not decide it. We'll see.
ಆರ್ಡರ್ಸ್ ಇದೆ.
ಅಲ್ಲ, money is not belongs to him. That lady has ಬಿಸ್ನೆಸ್ ಮಾಡಕ್ಕೋಸ್ಕರ ತಂದು ಇವ್ರ ಕೈಯಲ್ಲಿ ದುಡ್ಡು ಕೊಟ್ಟು 1.59 crore.
ನೀವು ಈ ಕಡೆಗೆ ಬಂದ್ಬಿಡಿ, ನೀವು ಅಕ್ಯೂಸ್ಡ್ ಈಗ.
ಇಬ್ರು ಸರ್ಕೊಂಡೋಗಿ ಆಂಧ್ರದಲ್ಲಿ ಹೋಗಿ ಯಾವ್ದೊಂದು ಗೋಡೌನ್ ನಮ್ದೇ ಅಂತ ತೋರಿಸಿ
ಹಾ
ಅದರಿಂದ ಸಪ್ಲೈ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿ 1.9 crore rupees ಹಾಕ್ಸ್ಕೊಂಡು
ಅದು ಯಾರಂತ ಕೇಳಿದಾರ? ಕಂಪನಿ ಇರೋದು ನನ್ಗಲ್ಲ, ನಾನು ಕೆಲಸ ಮಾಡ್ತಾ ಇರೋರು, ನನ್ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಬರಲ್ಲ.
ಆಯ್ತು, ದುಡ್ಡು ಅವ್ರ ಅಕೌಂಟ್ ಇದೆ, ದುಡ್ಡು ಅಲ್ಲೇ ಇರ್ಲಿ.
ಅದೇ ಅದಕ್ಕೆ ಫ್ರೋಸನ್ ಮೋಡ್ಲೇ ಇರ್ಲಿ ಅದು. ಫಸ್ಟ್ ವಿಕ್ಟಿಮ್ ನ ಪಾರ್ಟಿ ಮಾಡಿ.
ಆರ್ಡರ್ಸ್ ಟ್ರಯಲ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
The petitioner is directed to implead the victim.
I witness one.
ಸ್ವಲ್ಪ ಇರಿ ಸರ್. Directed to implead the victim as a party respondent to these proceedings. The learned counsel for the petitioner seeks to contend that the present second respondent was the first informant. After the police investigated into the matter, the first informant has had a role reversal. He is now accused number 3, standing along with the present petitioner. Therefore, the petitioner will have to now implead the real victim, who's the informant now after the filing, who's now shown as the informant after filing of the charge sheet, as the victim has lost
48 lakhs.
1 crore
48 lakhs.
1 crore 48 lakhs. 1 crore 48 lakhs according to the petitioner. According to the prosecution, it is 1 crore 94 lakhs. The amount, the said amount is lying in the account of the present petitioner. The account is frozen. An application is filed by ಯಾರು ಹಾಕಿರೋದು?
ಕ್ಲೈಮೇಟ್ ಹಾಕಿದ್ದಾರೆ.
ನೀವು ಹಾಕಿದ್ದೀರಾ?
ಅಪ್ಲಿಕೆಂಟ್.
ನಿಮ್ಗೆ ಯಾಕೆ ಹೆಂಗ್ ಸರ್ ದುಡ್ಡದು? The application.
Victim has filed.
Victim has filed ಅಂದ್ರೆ
ಇಲ್ಲ ಇಲ್ಲ, ಅಕ್ಯೂಸ್ A3 ಮಾಡಿದ್ದಾರೆ, ವಿತ್ಡ್ರಾ ಮಾಡ್ಬಿಟ್ಟು ಅವ್ರು ಮಾಡಿದ್ದಾರೆ.
The learned counsel for the learned additional SPP is directed to secure instructions as to who has filed the application seeking withdrawal of the amount before the concerned court. Is it the accused, the newly added accused number 3, who was the first informant earlier, or the victim?
ಅವ್ರು ಮಾಡಿ ವಿತ್ಡ್ರಾ ಮಾಡಿದ್ದಾರೆ.
ಇರಿ ಸರ್. Till such information comes about, the concerned court shall not permit withdrawal of the amount to any of the persons. List the matter on 5th. 5th in the fresh matters list. Party ಮಾಡಿ. ಸಾಯಂಕಾಲ ಅಲ್ಲ, ಈಗಲೇ.
He appeared for the respondent.
Vajan sir.
Yes, we have completed our arguments. Your lordship said that you'll pronounce orders. With regard to the review.
Pass. We'll do it in the afternoon, sir. 2:30.
2:30, my lord?
2:30, sir.
Yes, my lord.
Yes.
B group 24.
Brings the petitioner.
Appear for respondent number 2.
We taken up serial number 26 months.
Santosh Hospital. Oh, Santosh.
Yes.
Hospital.
26 ಅಲ್ಲಿ ಅದು ಆರ್ಡರ್ ಚೇಂಜಸ್ ಆಗಬೇಕು.
ಆಯ್ತು, ಅದು ಮಾಡ್ತೀನಿ. ಅದೇನಿದೆ ಅದು ಮಾಡೋಣ. ಇವರು ಇದಾರಲ್ಲ?
ಎಸ್.
ಆಯ್ತು. ನೆಕ್ಸ್ಟ್.
25.
25.
25.
ಹಾ, ಕೊಡಿ. Promise to marry.
25. SC/ST ಅಲ್ಲ. SC/ST ಅಲ್ಲ.
ಇದೆ. But emanates from promise to marry.
School teacher.
ಗೊತ್ತಾಯ್ತು. ಯಾವಾಗಿಂದ ನೋಡಿ? 2007 ಇಂದ.
ಇವ್ರಿಗೂ ಮದುವೆ ಆಗಿದೆ. Victim is also married.
Both of them are married. ಇದ್ಯಾವ ಪ್ರಾಮಿಸ್ ಟು ಮ್ಯಾರಿ ಆಗುತ್ತೆ ಇಲ್ಲಿ? ದಿ ಪೆಟಿಷನರ್.
The copy is not served on the
ಇದು ಕಾಪಿ ಇದೆಯಾ?
complainant. Notice is not.
ನೋಟಿಸ್ ಆಗಿಲ್ಲ, ಗೊತ್ತು. ನೋಟಿಸ್ ಮಾಡ್ಬೇಕು ಈಗ. ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾರೆ. The learned additional SPP is directed to accept notice for the first respondent. Emergent notice to the second respondent complainant returnable by the 9th of January 2026. The petitioner, the sole accused, is before the court calling in question registration of, calling in question proceedings in CC in special case 62 of 2024 registered for offences punishable under so and so. Illide ಏನು ವಿಜಯ್ ಇದ್ರಲ್ಲಿ page 15 prayer. A perusal at the complaint would indicate that the petitioner and the second respondent complainant were known to each other since 2007 and have had several transactions. The allegation is ಹಣ ವಾಪಸ್ ಪಡೆದ ಮ್ಯಾರೇಜ್
Church father. Church father.
ಫಾದರ್ ಗೋಪಾಲ್ ಅಂತ ಇದೆ.
Rajshekhar. 25 man.
ಇಲ್ಲ ಸೇಮ್ ರಾಜಶೇಖರ್ ಅದೇ ಅದೇ.
Priest. He's
But-
a priest.
Huh?
He's a priest.
ಗೊತ್ತಾಯ್ತು. ಸ್ವಲ್ಪ ನೋಡ್ಬೇಕಾಗುತ್ತೆ. ರಿಟರ್ನಬಲ್ ಏನು ಬರಿಬೇಡಿ. ರಿಟರ್ನಬಲ್ ಬೈ ದಿ 9th, ಲಿಸ್ಟ್ ಆನ್ 9th in the fresh matters list. Yes. Next.
26.
An application for modification.
ಏನೇನು ಮಾಡಿಫಿಕೇಶನ್ ಹೇಳಿ ಸರ್.
That's the test.
ಎಂಟೈರ್ ಆರ್ಡರ್ ಮಾಡಿಫಿಕೇಶನ್ ಕೇಳಬೇಕು.
ಇಲ್ಲ. There are only 2 points, my lords. Para numbers 9 and 22. It is stated that the Santosh Hospital test reports were not filed along with the charge sheet.
It is.
It is, my lords. The FSL report is not filed.
ಆಮೇಲೆ.
And the second aspect, my lords, is that they had filed a set of objections, my lords. In the set objections, they had even produced a brochure of this test. But where it is very clearly stated that it is just a presumptive test, not a conclusive test.
ಅದೇನು ಕರೆಕ್ಷನ್ ಆಗ್ಬೇಕು?
My lord, it's not stated anywhere. If in case it goes on appeal, that's the reason, my lord, because it's an admitted fact.
ಅಲ್ಲ, what would come back?
My lord, this test which was conducted by Santosh Hospital, also just takes the.
It's a presumptive test.
It is very clearly stated and admitted by the respondent number 2.
What have I said?
ಅದೇನು ಹೇಳೇ ಇಲ್ಲ ಸುಮ್ಮನೆ.
ಹಾಗೆ.
In fact, I have not filed objections. I filed a memo with all the details.
Correct. That was taken as your objections. That's all right.
That is considered as a part of the order, my lords.
Yes. The subject petition was heard and disposed on 29/4/2025. The learned counsel for the petitioner has filed an application seeking modification of the order. Modification qua certain inadvertent errors or omissions that had crept in, which had in fact been submitted. The learned counsel submits that, which paragraph is?
Para number 9 and 22.
9 and?
22.
9 and 22. The observation is that the test reports of Santosh Hospital, the second respondent, was not appended to the charge sheet. It was in fact appended. What was not appended is the FSL report. Therefore, the correction, the said correction will have to be done by incorporating the words not appended the FSL report in place of not appended the test report of Santosh Hospital. The learned counsel would further submit that the test, that the brochure of Santosh Hospital or the admitted fact is that the test conducted by the hospital is only presumptive and not conclusive. Therefore, the conclusive, the said submission had been made, which has been omitted, is the learned, submission of the learned counsel for the petition, which is accepted by counsels appearing for the respondent and the state. Adella
It has to be.
so and so. We'll see.
Yes,
The said paragraph is to be incorporated between 24 and 25. The first certified copy be issued.
That's the serial number 24, my lords.
They, no?
Consumers, my lords, covered already, my lords.
Yes, Jagdish sir. Same order. 24 ಅಲ್ಲಿ covered. ಇದು correction ಮಾಡಿ
Placing the
ಈ order ನ covered ಅಂತ ಮಾಡಿ.
Placing the certified copy of the order.
ಇಲ್ಲ ಇದನ್ನ correction ಮಾಡಿಸಿ ಇದನ್ನ covered ಅಂತ.
Yes, my lords.
Much
Yes.
Grateful, my lords.
ಅದಕ್ಕೆ ಅದು ಇಲ್ಲಿದ್ರೆ ಸರಿ ಅಂತ ಅಲ್ಲಿಗ.
Obliged.
27.
Apologies for non-appearance
Sunil
in
Kumar.
first matter, my lords.
First matter, dismiss
matter,
ಮಾಡ್ತೀನಿ.
my lords. I was in division bench, my lords.
ಏನ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಂದ್ಬಿಟ್ರೆ ಸುಮ್ಮನೆ ಇರ್ತೀನಿ.
My apologies for that. I was ready, my lords, that matter is adjourned.
ಅಲ್ಲಿ ರಾಹುಲ್ ಕೃಷ್ಣ, he was not well. We'll take it on 9th only. ಅರ್ಜೆಂಟ್ ಮಾಡಿದ್ದೀನಿ.
Apologies.
9th ಹಾಕಿದ್ದೀನಿ. ಇದೇನು?
Similar extension of parole. Is a convicted prisoner for, he served 7 years of imprisonment. His father is suffering from 4th stage of cancer, my lord. And he needs
Same 60 days. Extension.
much.
IML allowed. Next.
Apologies, my lord, non-appearance in 2 matters.
Okay, ಕೊಡಬಾರ್ದ ಪರವಾಗಿಲ್ಲ.
No, no, my lord, in the 2 matters, my lord, I was seeking apologies. Because yesterday, my lord, your lordship directed me to conclude the arguments.
Today,
Yes, my lord.
Rahul was not well, so I have adjourned.
Yes, my lord. So,
28.
For petitioner in this matter, my lords. The
There's an
respondent
IA
has filed a IA to withdraw the deposit amount, my lords. We have no objections for withdrawal of the amount.
The subject petition was heard and disposed on 8th September 2025. Amount and deposit illidiya?
Yes, ma'am.
While granting an interim order, this court had directed a deposit of rupees
That's 5,40,700.
5,40,700
700.
to be 10% of the amount claimed in execution to be deposited, which works out to 5,40,700. Since the petition is disposed, the respondent has filed a subject application seeking withdrawal of the amount. The counsel of the petitioner has no objection. In that light, the registry is directed to return the deposit to the hands of the respondent after due verification without broking any delay.
Obliged, ma'am.
Ordered accordingly.
Obliged.
Yes.
Other reading. 29.
Connected matters, my lord, your lordships have reserved it.
ಇದಾ ಅದೇ ಇದು
Connected, ಹೌದು.
ಯಾವುದು ಮಲ್ಟಿಪಲ್ FIRs.
ಲೋಧಾ committees.
ಇದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆಯಾ ಇದನ್ನು? ಶುರು ಮಾಡಿ.
Okay.
ರೆಡಿ ಇದ್ದೀರಾ? ಗೌತಮ್ ಭರದ್ವಾಜ. I will take it on ಯಾವ ವರ್ಷದ 9th. Yes, interim order subsisting would continue to the next date of hearing. ಏನ್ ಇಷ್ಟೊಂದು ಮ್ಯಾಟರ್ಸ್ ಇದೆ ಇದು? ಎಲ್ಲ ಅದರದೇನಾ? ಅಲ್ಲ 9 matters are there.
Another 2 matters, my lord, pertaining to the ED, my lord, that also other accused have filed.
ಯಾವ್ದು ಅದು ಕೊಡಿ, ನಂಬರ್ ಕೊಡಿ.
It has been tagged.
Already tagged. Madhukar Deshpande ಇದ್ದಾರೆ. Yes. Next.
Okay, for the petitioner.
30.
Accused number 1 is the deputy tahsildar, your lordships.
Depoy case. Covered a depoy case.
Depoy, correct. Depoy ಮೇಲೆ ಇತ್ತಾ?
Like he accepted.
Recovery,
then he got
recovery is there,
suspicious.
your lordships. But my contention is once the khata is rejected, they only have to file an appeal. The question of deputy tahsildar changing the revenue entries.
Why
is
was
not-
money found in your house? ಅಷ್ಟೇ. ಬೇರೆ ಏನಿಲ್ಲ. If money had not been found, is it? I have distinguished in all those cases. ಎಲ್ಲಿ ಇಲ್ಲ, ಎಲ್ಲಿ ಇದೆ, ಸಪರೇಟ್ ಆಗಿ ಬರ್ದಿದ್ದೇನೆ ಎಲ್ಲ. ಕೊಡಿ. ಕೊಟ್ಟಿದ್ದೀರಾ ಅನ್ಸುತ್ತೆ. ಇಲ್ಲ ಕೊಡಿ. We'll close it, Varun.
Please.
He knows his case well. The petitioner is before this court seeking the following prayer. The petitioner is accused number 1. The second respondent, the complainant. A complaint comes to be registered against the petitioner on 21/8/2023 which becomes a crime in crime number 3 of 2023 for offences punishable under section 7 and 7A.
Crime number 8. Crime number 8.
8 3 ಯಾವ್ದು ಮತ್ತೆ
8 of 20.
crime number 8 ನೀವೇ ತಪ್ಪು ಬರೆದಿದೆ. Crime number 8 of 2023 so and so for offences punishable. The police then conduct investigation. Pursuant to the registration of the crime, a trap is laid against the petitioner, in which the petitioner was found in possession of the tainted money, and therefore the prosecution proceeds with the crime, conducts investigation. Charge sheet ಆಗಿದೆಯಾ?
ಇಲ್ಲ.
Conducts investigation. The petitioner at that juncture is before this court calling in question the registration of the crime against the petitioner. The learned counsel appearing for the petitioner submits that there is no proof of demand or acceptance in the case at hand. Neither there is any conversation between the complainant and the petitioner. He would further submit that the allegation of rejection of khata is an appealable order and an appeal ought to have been preferred. The petitioner had nothing to do after the rejection of the khata, and therefore there is no warrant for any demand or acceptance of the amount. The learned counsel submits that on this score the petition should be allowed. Per contra, the learned counsel B. Latif, representing the respondent Lokayukta, would vehemently refute the submission contending, taking this court through the documents appended to the statement of objections, contending that the the conversation between the petitioner and the complainant are all recorded and are placed while drawing up a pre-trap mahazar, and when the trap was laid, the petitioner was found in possession of the tainted money. Therefore, this court should not interfere in such cases. The learned counsel would seek to place reliance upon a judgment rendered by this court in criminal petition 8776 of 2024, disposed on 2nd June 2025. The afore narrated facts linked in the chain of events are not in dispute. They would not require any reiteration. The issue is whether the offence under section 7A is met in the case at hand or otherwise, for which it is necessary to notice the conversation between the two and the recovery of money as drawn in the mahazar on the date of the trap. Elli the page.
Trap mahazar at page 28.
Trap Panchanama.
Yes. Page 30 is the portion where
trap
acceptance.
Page
30.
Currency.
Please.
Ella 500s.
ಹೌದು 30,000 total.
The hand wash phenolphthalein test.
Yes, page 31 they bought.
Madam, ಇಲ್ಲಿವರೆಗೂ ಮಾಡ್ಬಿಡಿ. Page 28 to 32. The trap mahazar clearly indicates that the petitioner was caught in possession of the currency, and the currency notes are also indicated in the trap mahazar. Therefore, it was a case of a successful trap, and the hand of the petitioner also would turn pink, which would mean that the phenolphthalein test was positive, qua the petitioner. In these circumstances, whether this court should entertain the petition under section 482 of the CRPC need not detain this court for long or delve deep into the matter. This court in so and so para 7 to end, in the light of the identical issue being dealt with by this court as quoted supra, is also the fact that the petitioner was found in possession of the cash, which was in possession of the cash. The petition does not warrant any interference. Lacking in merit, stands rejected. Next.
Lords, appearing for the respondent, my lords.
ನೆನ್ನೆದ
ಇಲ್ಲ Millards, it's a case of disproportionate assets, Millards. The only sole ground on which I am before this court is exoneration. Once again, the exoneration. Millards,
Comparative chart has been produced, comparative chart produced.
comparative chart has been produced.
And objection is also produced, your lordship, filed, your lordship.
disproportionate asset case departmental inquiry.
Millards, the prosecution has examined 21 witnesses, but in the DE, they have examined 30 witnesses, 180 pages exhaustive, Millards, the report. In detail.
Date may fix, your lordship, for final disposal.
ಈಗೇನ್ ಮತ್ತೆ ಮಾಡ್ತಾರೆ?
So senior is engaged at court hall 25, your lordship.
Relying on this.
Millards.
ಹಂಗೆ ಇದೇನಾಗಿದೆ ಸ್ವಲ್ಪ ನೋಡಿ. ಇದು ಸ್ಟೇ ಆಗಿದೆಯಾ?
Millards, now Millards, what transpired in this case is, when the matter came up for the first time for the admission, I did not file any application for stay, but this court granted stay. Then I brought it to the notice of the court that I had not filed application, it is inadvertently passed. Millards, then Millards said they clarified and no application, no stay. Millards, now thereafter what transpired is, Millards, the matter was going like a lightning speed. I filed another application, a fresh application for stay.
To cut the speed.
Millards, now I was cross-examination start agide.
2024 matter stay illa, one date fix madidre for final disposal.
But ಅಲ್ಲಿ ಮುಗಿದೋಗುತ್ತೆ ಅಷ್ಟೇ.
Next week.
The petitioner is before this court. Application ಇದೆಯಾ ಇಲ್ವಾ?
ಇದೆ. Millards,
petitioner is before this court, calling in question the proceedings in special case 407 of 2020. 16. ಯಾವಾಗ ಹಾಕಿದ್ರಿ petition ನೀವು?
Millards, it is filed on Millards 27/4/24.
At what stage?
Millards, after departmental exoneration. Exoneration is done in February 2023.
That's the reason.
Charge frame ಆಗಿ ಎಲ್ಲ ಆಗೋಗಿದೆ, ಭಾರಿ ಕಷ್ಟ ಈಗ ಮಾಡೋದು.
ಅಲ್ಲ, I ಓದ್ cross ನಡೀತಾ ಇದೆ. If that terminates, then Millards, the petition becomes infructuous.
Your judgment where once charge is framed, you can intervene.
I have not intervened in any case charge.
Please, lordship. Once charge is framed.
DE ನಿಜ, but argumental ಮಾಡಿ ಅದನ್ನ ಅಲ್ಲಿ.
Millards, now the trial court, Millards, they are not accepting, Millards, the departmental exoneration as one of the ground for
argumental. It's not that you have to. ಅದಕ್ಕೆ evidence ಏನ್ ಬೇಕಾಗಲ್ಲ. I'll observe ಬೇಕಾದ್ರೆ ಅದನ್ನ ತಗೊಳ್ಳಿ ಅಲ್ಲಿ. Let the court answer that. Charge frame ಆದ್ಮೇಲೆ 2016 not correct.
ಅಲ್ಲ, ನನಗೆ exoneration ಆಗಿದೆ 23 ಅಲ್ಲಿ.
Maybe, but
exoneration ಆಗಿದೆ 23 ಅಲ್ಲಿ.
ಏನು? I will direct the court to consider it. ನೋಡಿ, think it over. I'll take it on 9th ಬೇಕಾದ್ರೆ.
Millards, may kindly.
Because ultimately ನಾನು ಅದೇ ಮಾಡಕ್ಕಾಗಲ್ಲ. Charge frame ಆದ್ಮೇಲೆ I'm not interfering.
Millards, may kindly dispose of with.
I will direct it. The petitioner is before this court seeking the following, calling in question proceedings in special case 407 of 2016, registered for offences punishable under section 13(1)D, read with 13E. 13(1)E, or read with 13D of the Prevention of Corruption Act. The learned counsel should be or the The learned counsel appearing for the Lokayukta would submit that the proceedings before the concerned court have advanced to a large extent and is now at the stage of recording of evidence. The charges have been framed long ago, and the matter is at the stage of recording of evidence. In that light, there is no warrant of interference at this stage in exercise of jurisdiction under section 482 of the CRPC. The learned counsel for the petitioner has a justification for approaching this court. At this stage, the learned counsel submits that on the same set of facts, two proceedings had sprung, one on the departmental side and the other, the criminal law, being set into motion. In the departmental inquiry, on the same set of facts, same documents, or even the same witness, almost the same witnesses being examined, the petitioner has been exonerated. And the exoneration of the petitioner, is, has become final as a disciplinary authority, accepts the said exoneration and closes the proceedings against the petitioner. These are admitted facts. In the light of the matter being pending at the stage of evidence and there being no warrant at this stage to interfere with the proceedings, I deem it appropriate to direct the concerned court to hear the petitioner on the issue of the departmental inquiry, exoneration in the departmental inquiry in the light of the judgment of the apex court in the case of Ashu Surendranath Tiwari, 2020, 9 ACC, page 636. With the aforesaid observation, while directing the concerned court to hear the petitioner on the said issue while passing the orders, the petition stands disposed.
Please.
I think that should protect.
Please.
Grateful.
32.
32, I appear for the proxy, my lords, for the petitioner
You
counsel.
appear for proxy?
I appear proxy
Appear
for the
proxy.
petitioner counsel, my lords.
Ah.
I apologize. My lords, kindly pass over, my lords. He's held up in another court.
30?
My lords, short date may be given.
ನಿಮಿಷ. Objections ಹಾಕಿದ್ದೀರಾ?
Next date ಅಲ್ಲಿ ಹಾಕ್ತೀನಿ.
This court on 23/10/2025 had passed the following order. The learned counsel for the respondent now, complainant now seeks 2 more weeks' time to file statement of objections. In the light of the order so passed, in the light of the order quoted supra, list this matter on 9th.
Lords, interim order may kindly be extended, my lords.
Yes, sir. Extended.
Grateful.
33.
Lord, I appear for 33.3, my lord. I request for 2 weeks' time, my lord. There's some
The
office objection which
misappropriation of
needs to be
funds, your
completed.
lordship.
ಕೊಡಿ.
Objection is filed.
Interim order ಇದೆ?
ಇದೆ. Your lordship has granted interim order in 2024 June.
Not to file charge sheet.
Please.
ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ?
I need to seek instruction regarding this, your lordship. 10 lakhs grant has been misused, your lordship.
ಚಾರ್ಜ್ ಶೀಟ್ ಆದಂಗಿಲ್ಲ ಇನ್ನು.
Lordship?
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ಲ ಇನ್ನು.
ಇನ್ನೂ ಆಗಿಲ್ಲ.
The learned counsel appearing for the Lokayukta is directed to secure instructions with regard to the stage of the proceedings before the concerned court at the time when the interim order was granted. List the matter on 9th.
Please.
Yes. Interim order subsisting.
34.
That's,
This
this
case-
is yesterday's matter regarding, my lord, the sanction. Whether the sanction without, if the person, after the post amendment, even if, my lords, the offense is committed earlier to the pre-amendment and the post amendment, the charge sheet has been filed. I retired after post amendment. The sanction was earlier granted, it was withdrawn. After about waiting for a year, they filed a charge sheet without the sanction. Whether the amendment has been, my lords, discussed. Not regarding, my lords, the stage to decide the relevancy of the, my lords, the sanction. In fact, the matter was taken up before the apex court. That matter was taken up before the apex court. During the pendency of the special leave, my lords, the appellant passed away.
No decision is rendered.
Then decision is not taken. However, it is needless to say that all the question of law are left open. Lord's mechanism.
Here is the issue, my lord. The charge was framed in the year 2022. They in the year 2024, they filed this petition raising a ground that the sanction was not obtained. And he was retired. As on the date of taking cognizance, he was retired from the service. Now, my lord, after 2 years, 11 witnesses have been examined and 39 documents are marked. At this stage, my lord, he has filed a petition seeking quashing of the proceedings.
Then judgment kodi.
I have already given.
ಅಲ್ಲ
The
ಯಾವ್ದು
sec-
ಇನ್ನೊಂದು ಜಮೀರ್ ಇಲ್ಲೇ ಕೊಟ್ರಲ್ಲ.
The second judgment, my lord, this honorable court, in the similar issue, my lord, while deciding whether the amendment is prospective or retrospective.
Yeah.
In a case, my lord, in T.N. Bettaswamy versus State of Karnataka, the second judgment I given, my lord, in the compilation. Yes. Para 22, 23 and 24.
This will have to answer. Yes.
The third judgment plot, I place it at page number 27. In a case of State of Rajasthan versus Tejmal Chowdhury.
State of Telangana antiದೆ.
Third plot, page
all right.
27. Please. That is also similar issue plot, whether about the PC Act, whether it is a prospective or retrospective. In the last judgment plot is the State of Telangana versus Managipet in para 35 and 35 to 37. Please,
Paragraphs ಹಾಕ್ಕೊಡಿ.
Please, happen. Now, my lord, it is posted for evidence of CW. Already 11 witnesses have been examined. And as per the Nanjappa case, it is Supreme Court says that if it is sanction, issue of the sanction has to be challenged at the earliest. He has not challenged that issue from the 2022, and he has faced the trial and the witnesses have been examined. The question is, my lord, whether sanction is required or not. My lord, it was answered by the apex court. My lord, once it is retired from the service as per the
lapsing.
Lord, here the explanation offered by the investigation has to answer it in the he has to post a defense in the cross examination. He has having an explanation in the writing, Lord. Here I ready to place it. Lord, after obtaining the sanction, Lord, the accused come up with a representation saying that some of the properties was added in the assets and liabilities where belong to his brother has been calculated as a disproportionate asset. And that representation was considered and positively the charge sheet was filed and deleting those properties from the schedule. Then, Lord, when the time of filing the charge sheet, he was retired from the service. Therefore, the charge sheet was filed without the sanction.
Legal question that is my answer. Yes.
Yes.
Heard reserved. Please. Interim order subsisting will continue to the disposal of the petition.
45.
My lord, ದೇವರವರ ಕೊಟ್ಟರು ಪೂಜಾರಿ ಕೊಡಲ್ಲ ಅಂದಂಗೆ ಆಯ್ತು.
ಏನಾಯ್ತು ಈಗ?
I go to the bank and try to deposit 25 lakhs as ordered by this court.
ಏನು ಸರ್ಫೇಸ್ ಏನ?
ಇಲ್ಲ ಇದು ಕೇಸ್ ಆಫ್ ಚೀಟಿಂಗ್ ಮೆಮೋ ತಗೊಂಡು.
ಓ ಡೆಮಾನ್ಸ್ಟ್ರೇಟ್ 25 lakhs ಅದಾ? ಟು ದಿ ಕಂಪ್ಲೇನೆಂಟ್.
ಹೌದು, ಅದು ಕಂಪ್ಲೇನೆಂಟ್ ಅಕೌಂಟ್ಗೆ ಸಬ್ಜೆಕ್ಟ್ ಟು ದ ಸ್ಟೇ ವಾಸ್ ಗ್ರಾಂಟೆಡ್ ಸಬ್ಜೆಕ್ಟ್ ಟು ದಟ್ ಆರ್ಡರ್ ಆಫ್ ಡೆಪಾಸಿಟ್.
ಯಾವಾಗ ಹೋದ್ರಿ ಬ್ಯಾಂಕಿಗೆ ನೀವು?
We immediately approached the bank, my lord. Very next day we approached the bank. Then we have written emails to the bank subsequently requesting them to permit us to deposit that amount in accordance with this order and to transfer the same to the account of the complainant.
RTGS ಮಾಡಕ್ಕೆ ಪರ್ಮಿಷನ್ ಬೇಕಾ?
ಅಲ್ಲ, ಅವ್ರು ಇದು RTGS ಮಾಡಕ್ಕೆ ನಾನು ಡೆಪಾಸಿಟ್ ಮಾಡಬೇಕಾಗಿತ್ತು ಅಕೌಂಟ್ಗೆ. So, my lord, the bank now says on 25th November 24, that's the last communication, saying that, you go to the police and ask for temporary defreezement of the account.
Yes, Jagdish. No, the learned, this court on 18/9/2024 had passed the following order. Counsel for the petitioner has filed a memo along with documents of an email trail which indicates that indicates a correspondence between the bank and the petitioner, seeking to enable him to produce enable him to deposit the amount The amount is not deposited on the score that the account is frozen. The learned learned additional people to secure instructions and make and submit with regard to the status of the account and why the bank has not permitted the deposit despite the aforesaid order.
My lord, one more submission, my lord. My lord, in the orders, while passing of the orders, I think there's been one small issue, my lord, wherein it has been recorded that the offense of criminal breach of trust anta record the order alli. ಅದು ಆರ್ಡರ್ ಡೇಟೆಡ್ 6/11/2024 ಅಲ್ಲೂ ಇದೆ, ಆಮೇಲೆ ಅದ್ರ ಮುಂಚಿನ ಆರ್ಡರ್ ಅಲ್ಲೂ ಇದೆ. My lord, offense 406 ಇಲ್ಲ, 420 ಮಾತ್ರ ಇರೋದು. ಚೀಟಿಂಗ್ ಮಾತ್ರ ಇರೋದು.
The interim orders granted or continued from time to time has an inadvertent inclusion of an offense of criminal breach of trust, while it had to be cheating as obtaining under section 420 of the IPC. Therefore, the criminal breach of trust be deleted from the interim orders and the offense of cheating be included.
My lord, one last submission then, my lord. The whole issue,
the merits mela barli. Yes. Right. List the matter on 9th.
Please.
36.
36 ಇಲ್ಲ pass over.
In special court matter.
ಅಲ್ಲ. Doctor the department.
Doctor departmental.
Yes.
It has been done. I'll place it in.
Agidya.
That's what I've been informed. 2:30 ಗೆ ಅಂತೇಳಿ 2:30 ಬರಕ್ಕೆ. 2:30.
37.
Yeah, madam. Further.
Yeah. Earlier counsel, unrecorded counsel mother has admitted in the hospital 2 weeks time.
The learned counsel for the petitioner submits that the arguing counsel's mother is hospitalized. List this matter on 9th. Interim order subsisting. Krishna, anything?
Well, the 82, 86 equation is entire proceedings now they are challenging.
Interim order is granted. Why interim order is granted now?
Well, it was earlier before at the time of
ಮುಂಚೆನೇ ಆಗಿದೆ. 22 ಇಂದ ಇದೆ.
Everything is completed ಮೇಲೆ even sites are also formed and allotted ಮೇಲೆ long back ಮೇಲೆ.
ಮತ್ತೆ ಏನು interim order ಇದರಲ್ಲಿ? ನಿಮಗೆ ಗೊತ್ತಿಲ್ವಾ? Seriously?
Just call ಮಾಡಿ ಹೇಳಿದ್ರು.
I also filed the synopsis and the citations already filed.
The learned counsel for the petitioner submits that the arguing counsel's mother is hospitalized. As a last chance, he lists this matter on 9th. In the event no submission would be made, the interim order would stand automatically vacated. Next.
30. Sorry, 38.
30?
38.
Submission for a petitioner, my lords. We have already submitted the.
One ನಿಮಿಷ ಅದು ಬಸವರಾಜ್ ಸರ್ ಬೇಕಿದೆ.
This can be closed. We drafted the representation and gave it to my friend. It appears they have submitted to the government. The act.
Government ಏನ್ ಮಾಡಿದ್ರಿ ಅದ್ರ ಮೇಲೆ?
Appointed as amicus curiae. Now, ಅದಕ್ಕೆ advocate on record ಕಾಣಿಸ್ತಾ ಇಲ್ಲ. ಬೇಕಾಗಿಲ್ಲ.
Fresh direction may be issued.
What fresh direction?
Can I make the submission? Now they've already made a submission statement before, sorry, representation to the government that section 27 requires amendment, making a provision for separate stamp for the clerks, apart maybe 10 rupee or 5 rupee. If the act is amended, apart from this cost and other things the government grants, a substantial amount can be generated.
So what is the government doing?
The government will have to take a step within the limited time. With that observation.
We will ask the law secretary to be present now.
It can be disposed of with a direction to.
ಮತ್ತೆ ಮಾಡಲ್ಲ ಅವರು dispose ಮಾಡಿದ್ರೆ government will not.
It has to be monitored. There is no doubt.
Otherwise, these people will not get anything. What? ಯಾವ ಕಾಪಿ ಕೊಡ್ಬೇಕು ನಿಮ್ಗೆ? ಬಸವರಾಜ್ sir is saying they have communicated to government.
Government. It's already submitted to the.
ಮತ್ತೆ?
Already submitted.
ಒಂದು ಕಾಪಿ.
ಅದು ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ. Last time.
In Telangana and other places, your lordships are aware, there is a provision for separate stamp, maybe 5 rupees. But in other cases, entire amount itself is collected and some portion.
Amend ಮಾಡಿದ್ರೆ ಆಯ್ತಲ್ಲ.
Yes.
ಮಾಡ್ಬೇಕು government.
Maybe 5 rupee, 10 rupee.
ಇದು I will grant you 3 weeks finally. If not, we'll keep the law secretary present here. The petition,
No, there is one more,
correct, ಏನ್ address ಯಾರಿಗೆ?
government that is addressed to the chairman of law commission, one more is given to the government.
This court, from time to time, has passed slew of orders. The orders are passed in order to grant protection to the advocates clerks who are the petitioners, the advocates, Karnataka State Level Advocates Clerks Association. After due deliberations between the parties, a solution was arrived at, and a communication has now emerged from the hands of the petitioners and even the bar council as submitted as submitted by the learned amicus, senior counsel S. Basavaraj. The communication has remained a communication till date. The communication is with regard to making a provision in the rules for collection of in the act for collection of fee by way of a stamp separately, as is done in other high courts. The amicus would quote illustration of High Court of Telangana and
Andhra Pradesh
High Court of Andhra Pradesh. Since the communication is in the is at the doors of the state, and the state is yet to take a decision on it, I deem it appropriate to direct the state to take a decision upon the communication and make way for funds to be collected for the Advocate Clerks Association by bringing in the necessary amendment as is sought for. Finally, list this matter on 9th January 2026. In the event no steps are taken by the state to remedy the grievance of the petitioners, the presence of the law secretary would become imminent.
We have also been making representation. Now today, if a advocate touchwood passes away, the maximum is only 8. We have sufficient funds. We said at least increase to 15 lakhs, at least 12 lakhs, because it's our amount, it's advocate's amount. At least they can also bring amendment. Simultaneously, it can be taken. Adralli now separate representation ಮಾಡಿದೆ ಬೆಳಗಾವಿ ಸೆಷನ್
ಫಸ್ಟ್ ಇದೊಂದು ಮಾಡ್ಬಿಡ್ಲಿ.
ಬೆಳಗಾವಿ ಸೆಷನ್ both can be taken up.
ಮಾಡಿದ ತಕ್ಷಣ ಎಸ್ ಗವರ್ಮೆಂಟ್ in the event no reply comes, yes Nataraj, in the event no reply comes about, the law secretary shall be present. List the matter on 9th at 2:30 p.m. Yes, ಏನಾರ ಒಂದು ಮಾಡ್ಬೇಕು, ಇಲ್ಲಾಂದ್ರೆ you can't keep the clerks in lurch. Yes sir, I heard the learned counsel of the petitioner, the learned amicus and the state. Yes, and Janet and transfer the bar council. Yes,
I'm sorry.
Yes sir.
39.
Serial number 39. There's some difficulty. My senior is not in patient. I request some other thing.
Yes. Can be taken up on a convenient.
39.
39, my lords, that amendment to the registration of births and deaths, my lords, the executive magistrate.
Supreme Court has directed expeditious disposal.
Expedite the process.
No, Supreme Court has directed it should be disposed immediately. Don't take time. Hegde sir, ನೀವು ಹೇಳಿ, what is there?
My lord,
because some other high court, it has gone to the Supreme Court.
Yeah, that's
and
yes,
the
please.
Supreme Court, there is a reference. You have not seen the order of the Supreme Court?
Meenakshi Chandulal, my lords.
You have not seen the order of the Apex Court?
Yeah, yes, it's
then
it should be, my lords.
yes. I think time ಹೇಳಿದಾರೆ ಇಷ್ಟೊಳಗೆ ಮಾಡಬೇಕು ಅಂತ.
ಇಲ್ಲ, time ಹೇಳಿಲ್ಲ.
ಇಲ್ಲ, Supreme Court.
We request the High Court of Karnataka to take up rate petition number so and so now stated listed on 28/9/2020. Meanwhile, Union of India may file status report with
That's all right. See the High Court of Karnataka to be listed on 28/9/2025.
Now reported. Now it was on 28.
ಆಯ್ತು, 28/1/2025. Meanwhile, status report so and so. Then again, if it goes before the Apex Court, ಕಷ್ಟ ಆಗುತ್ತೆ.
Please,
ನೀವು ಹೇಳ್ಬಿಡಿ.
Please.
What's the matter?
Now, my lord, the subject matter is amendment to the birth and registration of birth and death.
Yes.
So section 13(3), my lord, as it stood Now, initially, my lord, there was an attempt by the Karnataka state, my lords, to substitute the words of judicial magistrate with the word executive magistrate.
I quashed it.
Your lordships quashed it, my lords. And thereafterwards, now they amend the provision by a central amendment, my lords. By the amendment, what they say is the executive magistrate, the judicial magistrate shall be substituted by the word executive magistrate. The whole grievance is this, my lord, as far as the executive magistrate is concerned, he can venture to the administrative or quasi judicial function, etc., my lords, even as a tahsildar, as a revenue head, etc. But here is a function, a decision making process is involved. A decision making process. Please.
Objections.
Next date.
No next date. I'm going to give you a week's time.
1 week's time.
Matte apex court mundu hodre it will be a problem.
I will file it.
Only a week's time I'm granting. If you file objections, file. Otherwise, I will take it as no objections and pass orders.
We will file it.
2023 in the pending 2 ವರ್ಷ ಬೇಕು objections ಹಾಕಕ್ಕೆ central amendment.
Next date.
ಎಲ್ಲ ಹಾಕಿದ್ದೀರಾ ಎಲ್ಲಿದೆ
ಸ್ಟೇಟ್ ನವರದು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಬೈ
ಫೈಲ್ ಇಲ್ಲ
ಮೇ ಬೆಕ್ ಟು ಸಬ್ಮಿಟ್ ಮೈ ರೈಟ್ ಒನ್ ಕೇಸ್ ಯೂನಿಯನ್ ಒಂದಿದೆ
ಯೂನಿಯನ್ ಇದೆಯಾ
ಒಂದು 20106 of 2024 if they want to file additional or in all the cases differently
ಒಂದು ಹಾಕಿದ್ರೆ ಅಷ್ಟೇ
please in 20106 I have been served with
ಉನ್ನಿ ಕೃಷ್ಣನ್ ಹಾಕಿದಾರಲ್ಲ
ಒಂದು ಕೇಸಲ್ಲಿ
ಅಲ್ಲ ಅದು ನನಗೆ ಸಿಕ್ಕಿಲ್ಲ
ಬೇರೆ ಎಲ್ಲ ಕೇಸಲ್ಲಿ
ಎಸ್ ಸರ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ದೀರಾ ಸರ್
the state wants to
state also is filed yes come on merits
please my lord
you adopt
next week ನಾನು ನೋಡ್ಬಿಟ್ಟು ಹೇಳ್ಬಿಡ್ತೀನಿ
no because it is before apex court is 28/9/25 ಮುಗಿಸಬೇಕು ಅಂತ ಹೇಳಿದ್ದು ಇನ್ನು we have come to November ಅದು ಮುಗಿಯುತ್ತೆ ಡಿಸೆಂಬರ್ ಗೆ ಬಂದ್ವಿ no sir because I'm sitting there it's a problem otherwise avate ಮುಗಿತಾ ಇತ್ತು
please my lords
you filed your objections ಎಲ್ಲ ಎರಡರಲ್ಲೂ ಹಾಕಿದ್ದೀರಾ
ಅದೇ ಎರಡರಲ್ಲಿ ಹಾಕ್ತೀನಿ
ಮತ್ತೆ we will go by the objections ನೋಡ್ಕೊಂಬಿಡಿ ಲಂಚ್ ಅವರ್ I'll take it at 2:30
Malas president to next year
your senior is not well sir
president to next year point
because involving the all the
where is the president sir
involving the advocates my lords advocate association is also
ಎಲ್ಲಿದ್ದಾರೆ
working out of session
ಎಲ್ಲಿದ್ದಾರೆ ಅಲ್ಲಿಂದ ಬರಕ್ಕೆ ಹೇಳಿ ಆನ್ಲೈನ್ ಬರಕ್ಕೆ ಹೇಳಿ yes no it's only 3 months over supreme court is fixed deadline is not
it's only because my lord sitting was not here
ಅದೇನಾಗಲಿ then it will be on me
yes and
2:30 ನಾನು ಇದು ಯಾಕೆ ಬಂದಿಲ್ಲ ಮ್ಯಾಟರ್ ಬಂದಿದೆ yes
please
password
some difficulty I have, my lord. My instructing counsel, her aunt was not well, so my lord, she left for.
ಬೆಳಿಗ್ಗೆ somebody moved the memo. Construction is going on and all that.
They have barricaded the disputed property, basically.
Not, they file an application day before yesterday, I give it to me. I'll have to file my objections, I'll file it. Your lordships have passed an order earlier saying that all construction is subject to the result of the writ petition.
No.
Not now, my lord, long back. And your lordships had heard the matter.
Yes.
He had not completed, I have to complete. My problem is only this, my instructing counsel, her aunt is 90
because
years.
ಬೆಳಿಗ್ಗೆ they moved the matter. Then I said in his absence, I will not take it out of turn or whatever. Let them come on.
Our issue is only this one. Apart from, I have almost completed my arguments. There's only one decision which follows super.
That's all right. Let them complete it. I'll my lord reply.
Let me allow me to.
Sorry. My apologies. My apologies.
No, our time ಕೇಳಿದ್ರು because he has some difficulty
I'll make
ಕೇಳಿದ್ರು
my
ಅಷ್ಟೇ.
submissions, then your
Otherwise,
lordships
where
may-
will sir interfere?
Of course, my learned friend is entitled to ask for time because yes, Monday or so we served the applications because of the barricadation that is being put. Now the point is this. Our grievance is that some portion of our property has been released by the BDA and given to the developer, and he has merged it with another development, adjacent development, and constructing. Now the prayers we sought initially were stay of the sanction plan given to the adjacent developer, which this honorable court said let construction go on at their risk. Now what has happened is construction has come to the disputed area which is in our possession. Our entire submission was this is not a case where modification of the plan is sought before the sale deeds are executed when it was in allotment stage and all that. Modification of a 2001 plan done in 2017. 17 years later, after rights have been.
No, that's on the merit of the matter.
That's
Now,
right.
if.
I am only on our portion. Let them construct on the
one
undisputed portion. Yes.
Sir, if what he says is correct or not, subject to verification, tav nodi adna. But this should not be rendered fait accompli by putting
No,
up
the building is complete. He says.
The adjacent
Can I, please, you don't mind.
Yes.
Building is complete. He says, don't put up the construction. Building is complete. ಅದಕ್ಕೆ ನಾನು objections ಎಲ್ಲ ಹಾಕ್ತೀನಿ. ಅವ್ರಿಗೆ application 2 ದಿವಸದಿಂದ ಕೊಟ್ಟರೆ ನಾನು objections ಹಾಕ್ಬೇಕು. And it was main ಮೇಲೆ argument ಆಗ್ತಾ ಇರ್ಬೇಕಾದ್ರೆ.
My lords,
I
I
don't
don't
want
see
to
the
say anything more.
photographs that we have filed with the, if they say building is complete, that is in the adjacent site where it is the property is undisputed, let them construct. Barricades are being put last week. We have filed photographs. How can they say building is complete? This barricades being put in our own property, in our property.
I'll file my objections.
How can access to our own property be restricted? That's all I'm
sorry.
saying.
I don't think he will.
That's what.
Access to your
All
own
this,
property.
my lord, is all.
My lords, may kindly see the barricades that are being put. I filed photographs along with my application.
I'll, my lord, explain those photographs. ಎಲ್ಲಿದ್ದು photograph ತೆಗೆದು ಇಲ್ಲಿ ಹಾಕಿದ್ರೆ I'll point
Let
out
them
all
not
that.
make
I'll
those
take
kind
out,
of
my lord, the recent photographs and show it. No difficulty about
So
it.
there is no barricade, there is no, in the sense, there is no
If they say
blocking of
there is-
access.
If they,
There
let
is
them
no-
undertake that there is no barricade and there is no this thing, then
No,
we-
blocking, not barricade.
yes,
There
Blocking
is
of
no
access.
blocking of access to their houses, my lord.
not to their houses,
ಮತ್ತೆ
alla.
clubhouse ಈಗ.
The area which was meant for clubhouse.
Now, my lord, it's
and
all, now something
has
else
been
is coming up.
barricaded,
Yeah, look at it.
Which has been released.
This is the thing.
clubhouse ಗೆ ಹೋಗಿ ತೊಂದ್ರೆ ಆಗ್ತಾ ಇದೆ.
ಎಲ್ಲ.
Not clubhouse. Clubhouse has not been even constructed by them because
Then
they have
it is
sought
still
release
worse.
of that land. That's our grievance. There were, your lordships will recall,
No, I remember.
6 out of 4 tower,
Towers.
4 out of 6 towers have been constructed. 2 towers and the clubhouse have not been, the clubhouse land and the parks area.
No,
which
I
have been
will,
relinquished.
I will only record sir's undertaking that access to your places will not be.
Access not to our flats, my lord. This also belongs to us.
That,
Because
my lord,
we
is
have
a-
undivided interest in our,
Sorry.
in these lands. That has been illegally released by the BDA. They have put up
That-
construction
no,
in their
that-
land,
whether-
that is
Whether
okay.
it is released illegally or not is a decision that has to be rendered in this case.
My lord, until then, my lord, let there be some protection as far as the disputed area is concerned. Let them construct in the undisputed portion of the lands. Let them construct in those lands which they have title over. We are not coming in the way. Like my learned friend said, there is a building which has come up adjacent to our property, which is undisputed land. We are only asking for protection as far as the disputed portion is concerned.
Yes, sir.
My submission is, we have not, my lord, barred any access to their property. That, my lord, your lords may record.
My lords may otherwise hear the matter in the afternoon on merits itself.
Our objection, merits
ಇಲ್ಲ,
ಬೇಕಾದ್ರೆ ಕೇಳ್ತೀನಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. If you want the application to be heard, then.
No,
we-
your
objection.
lordships may hear the matter today itself. Since
Yeah,
that
sir has some problem today. ಅದಕ್ಕೆ.
I have, my lord, my
either,
instruct.
either the matter be heard on merits or some interim protection.
No, I will
One-
record sir's
Yes.
submission that access to your property will not be denied at all.
Including the released property by the BDA. Aste.
That will see
My
whether,
lord, otherwise, my lord.
is that
where-
not,
where-
is that not a final decision to be taken in the case?
No, interim protection, my lord. Where is the final decision, my lord?
No.
We are
Is-
saying
is
not to
our-
put up construction until the matter is decided.
Want to
It's
put
just
up
a-
construction, no problem.
Oh,
So
that's
what construction is being undertaken now?
They are putting up barricades and undertaking construction.
My lord, ಒಂದ್ ಸರ್ತಿ ಹೇಳ್ತಾರೆ access deny ಮಾಡ್ತೇನೆ. ಇನ್ನೊಂದ್ ಸರ್ತಿ ಹೇಳ್ತಾರೆ ನಮ್ಮ ಇದಕ್ಕಲ್ಲ club house construction ಆಗಿಲ್ಲ ಅಂತ ಇನ್ನೊಂದ್ಸಲ ಹೇಳ್ತಾರೆ. Look at the, my lord, the varying stand that he has been taking. Please look at it.
Varying stand.
No, I will
Ultimately, my
record
lord, I am
sir's
saying, I am making that statement.
That they are not putting up any construction. If
ಅವ್ರಿಗೆ
that
ಹೇಳಕ್
undertaking-
ಬಿಡಿ sir, what is this?
Yes.
Yes.
I am making a solemn undertaking, my lord, giving your lordship, my lord, a solemn undertaking and making a statement that, my lord, access to their property is not, my lord,
The
anyway, my
petitioner,
lord, obstructed.
the petition, an application is preferred, appending to it certain photographs alleging that the petition respondents have now begun putting up construction by putting a barricade which has stopped the access of the petitioners to their property. The learned senior counsel, Shri Uday Holla, representing the respondents, would undertake that no access to the property belonging to the petitioner will be stopped by any means by the respondents during the pendency of the subject petition. The said undertaking is placed on record. Place this matter on 8th January.
8 Jan.
8th January, I'll be here only.
Please, matter may be decided, my lord, on merits. Otherwise,
On merits, I will decide on that 8th
but
January.
today, my lord,
8th January at 2:30 PM.
we should have disposed of this matter.
I have no problem. I will sit till 7 o'clock also and decide.
That's
But,
why, my lord.
Sir, some problem. ಏನು ತೊಂದ್ರೆ ಇದೆ ಅಂದ್ರಲ್ಲ sir? ಏನಿಲ್ವಾ?
ಈತಲ್ಲ 12th ಇನ್ನೊಂದು ಹಾಕೊಂಡಿದ್ದೀರಿ ಅವತ್ತೇ ಆಗ್ಬೋದಾ?
ಆಯ್ತು, ಅದಾಗ್ಬೋದಾ? ಇಲ್ಲ, ಅದ್ ತೊಂದ್ರೆ ಇಲ್ಲ. But what is the problem to ಮಧ್ಯಾಹ್ನ?
ನನ್ನ ಇನ್ಸ್ಟ್ರಕ್ಟಿಂಗ್ ಕೌನ್ಸಿಲ್, ಹರ್ ಆಂಟ್ ಮುಲಾಡ್ is 90 years, she is not well, ಪಾಪ ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. ನನಗೆ ಐ ಆಮ್ ಹ್ಯಾಂಡ್ ಫುಟ್ ಅಂಡ್
All right. Yes. We'll take it on that day.
12th
8th or 12th ಯಾವ?
12th ಆಗ್ಬೋದಾ?
ಅವ್ರಿಗೆ ನನಗೇನಿಲ್ಲ. ಬಂದ್ಮೇಲೆ ನಾನು ಇಲ್ಲೇ ಇರ್ತೀನಿ.
The earlier the better, my lord, because it's the residents who are suffering. That's all I can say.
I know. Now this undertaking is given.
They are putting up construction. They have got a 2,000 crore investment. They are going ahead. It's the residents, 140 residents who are suffering. That's all I can say.
That's all right. Now construction is not being. You will not be troubled access to any of your things. That is undertaking is given. If there is anything, you move the matter.
We'll not have it on 8th itself, my lord. Why higgle over, my lord, 4 days time?
Not
All
about
right.
8th or 12th. All that
All
I am
right, my lord,
requesting
have it
is
on
that the
8th,
matter
my
be
lord.
heard and
This,
decided,
my
my
lord,
lord, because
with the greatest respect to my learned friend, as seniors, we will never, my lord, ever start, my lord, saying we higgling over, my lord, dates. Please have it on
I am
8th.
not on
That's all I am
dates.
saying. Please
My
have it.
learned friend is, I am not on 8th or 12th. I am only saying that the matter may be finally heard and disposed of at the earliest. That's all I am saying. Because residents, it's the residents who are.
Definitely, sir, will do.
He did not complete his arguments. ನಾನ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
ಇಬ್ರು ಮಾಡಿದ್ರೆ
ಮಾಡಕ್ಕೆ
ಅಲ್ಲ,
ನಾನು
ಆಯ್ತು,
ready ಇದ್ದೀನಿ.
ಇಬ್ರು ಮಾಡಿದ್ರೆ ಕೋರ್ಟ್ ಹೆಡ್ ನೋ ಟೈಮ್.
That's
the
I understand. ಕೋರ್ಟ್ಗೆ we will come and move your lordship's blood with 100 matters in the morning.
No, because positive of time, I have heard you twice or thrice, but it could not get complete because of want of time.
No, I'm
And
not,
now I am
I'm
there,
not on
that's the
that.
problem.
Only because today, my lord,
Because I'm coming back on the 6th, my lord, from US. My brother-in-law's this thing. Then there will be this. ಹಾಗೆ ಹೇಳಿದೆ, ಆಯ್ತು, ನಾನು 8th ಬರ್ತೀನಿ, ಏನಾಯ್ತು?
no, it's not about, I'm not on 8th or 12th at all. I'm only saying the urgency that, that's all. 8th or 12th, if my learned friend wants, your lordship may have it on 12th itself.
We'll 12th at 2:30 PM.
Great.
And remind me at 2:30, I will take it sharp at 2:30 and
Very
finish it on that.
Very good.
41.
For petitioner. Number 2.
Yes, sir. ಅವ್ರದ್ದಾಗಿದೆ. 2:30 ಕಂಟಿನ್ಯೂ ಮಾಡೋಣ?
Yes, lordship, kindly have it on 8th.
ಅವ್ರದ್ದು ಮಾತ್ರ ಇರೋದು. Yes. ಮೇಡಮ್ ಯಾರಿಗೆ?
Next one, 42.
ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್. ಹಾ,
42.
ನೀವು ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲ?
Lordship, this is a matter wherein your lordship had mentioned to the petitioner that they could probably take some amount what was already given to the landowners. It is up to them to decide on that. Otherwise, your lordship, if you could argue the matter, in view of the fact that your lordship, they do not have a right. It is ultimately an agreement that doesn't
My
hold
judgment itself.
true, your lordship. And therefore, what we are stating is, if all the respondents.
ಎಲ್ಲರದ್ದು ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ವಾ?
So all the agreement holders, if all of them say that whatever is as per the agreement, the amount, that they can take back lump sum, they will get something. That is the best that can be said.
Law is goaded against you.
Let your lordship to decide. They are not acceptable to that.
What's not acceptable?
100% sale consideration is paid. Therefore, Madam, I step into the shoes of the landowner in so far as recovery of the compensation is concerned. These are all registered agreement of sale. 100% sale consideration is paid. Along with the agreement of sale, they have also executed general power of attorney because there was an acquisition proceedings in respect of Trinity House Building Cooperative Societies. They did not execute the lease deed. The matter was set aside by the Honorable Supreme Court.
Yes.
Thereafter, the Bangalore Development Authority issued a notification acquiring this property. Therefore, for the purpose of the compensation, I step into the shoes of the landowners.
That is a new, this is something unheard of, that they're stepping into the
It's all
shoes
right,
of the
if my
land.
learned senior wants to argue the matter, I'm
Shall
ready to argue the matter. Your
Please.
lordship may hear. Absolutely. Only thing is now, my lord, some other respondents are not served. Some LRs are required to be brought on record.
See, this is where, your lordship, continuously with an interim order, they have been continuously doing that. None of us are able to take our compensation. We are left in the lurch, your lordship. None of this for this
They have
many
no right.
years.
They have received
How-
100% compensation.
No, nobody's just.
How can they be? In fact, your lordship, these are all registered agreement
my
of
interim
sale.
order.
Please, your lordship.
There's an
Interim.
interim
No, no,
order
not your
directing
lordship.
that.
Not yet.
Because I have written something against.
Please, your lordship, and they have no right. They've gone up to Supreme Court, they've lost, and now they want to step into, this is something new, step into.
Let Supreme Court order is more misinterpreted than interpreted. Let the Supreme Court order is, I filed an application for impleading. Supreme Court said you have no right because you are not a party before the High Court.
They go on.
How
further
can they?
beyond that.
I'll
Please.
read the order of the
Please,
Supreme
please.
Court.
My
today.
allow.
Kindly see the order of the Supreme Court.
Then judgment. Kodi.
It's gone beyond saying that.
Where is my judgment? Wait, madam. We'll come to Trinity later.
Look at that, Supreme Court.
Wait.
Supreme Court order.
Supreme Court order. This is file? Rekha ma'am, it's filed on 12/9/2025.
ಯಾವುದು ಇದು ಹಾಕಿದ್ದೀರಾ?
Memo of R33.
I have not received any.
It's your own judgment. It's okay. We'll give it to you.
No, no, where is my order which?
Your
passed in
lordship's
identical
order is also there.
circumstance?
Please.
That I have not received that order. I just.
Judgment.
Yeah, copy on the. Your lordship's order is at page 35.
Can I have a copy of the order, please, at least?
He says it is served.
I have not received it.
Parvati,
Where is
like
it? Show me the acknowledgement.
Just give one more.
What? Siddhananda sir.
Yeah. I'm sorry.
Lunch hour ಆಯ್ತು ಅಂತ ಗೊತ್ತಾಯ್ತು.
ಇಲ್ಲ ಇಲ್ಲ ಆ ಥರ ಏನಿಲ್ಲ. I am not hungry.
Don't get agitated. We'll all go.
ಅಲ್ಲ ಅವರು ಕೊಟ್ಟಿಲ್ಲ ಅದು ಕೊಟ್ಟಿದ್ರೆ
ನಾನೇ ನೋಡ್ತಾ
let me
ಇದ್ದೀನಿ.
have the privilege of reading my lordship's order on that. That's only thing.
ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಇಲ್ಲಿ ನೋಡ್ತಾ ಇದ್ದೀನಿ. ಕೊಟ್ಟಿದಾರ ಏನು? ಇರ್ಲಿ ಮಧ್ಯಾಹ್ನ ತಗೋಣ.
Please.
Trinity will hear later. No problem. On what? Yeah. We'll see. Let us begin. We'll begin. Daughter marriage. No, don't worry, madam. We will hear you. Afternoon we'll start.
Please.
Very.
One request. Serial number 18 passed.
18 passed over.
Pass over ಆಗಿದೆ.
ಏನು ಅಡ್ಜರ್ಮೆಂಟ್ ಬೇಕಾ?
ನೀನು ವಜಾ ಮಾಡ್ತೀರ ಅಂತ ಈಗ ಇವತ್ತೇ ಬೇಡ ಅಂತಷ್ಟು.
ಒಂದ್ ನಿಮಿಷ 18 ಅಲ್ಲವೇ?
18
ಮಧ್ಯಾಹ್ನ ಬನ್ನಿ.
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಮಾಡೋ.
ನೋ ಅದ್ರಲ್ಲಂತೂ ಇಲ್ವೇ ಇಲ್ಲ.
ತಮ್ಮ ಮುಂದೆನೆ ಬರ್ಬೇಕು.
ಅಲ್ಲ ಪರವಾಗಿಲ್ಲ, ಅದ್ರಲ್ಲಂತೂ ಇಲ್ವೇ ಇಲ್ಲ.
My lord, serial number 48.
ನೀವು ಫಾದರ್
ಅಲ್ಲ
ಇಲ್ಲ, ಅದು ಹೋಗಿದೆ ಬಿಡಿ, ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಅಲ್ಲ ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿರೋದೇ, ಇದು ಹೋಗುತ್ತೆ.
ಕ್ರೈಮ್ ಸ್ಟೇಜ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು.
Serial number 48.
ಮೇ ಸಿಕ್ ದಿಸ್ ಇಂಟೆಲಿಜೆನ್ಸ್
ಎಲ್ಲ ಬರ್ದು ಬಿಟ್ಟಿದ್ದೀನಿ ಅದರಲ್ಲಿ.
ಅದಕ್ಕೆ ವಿತ್ ಲಿಬರ್ಟಿ
ಟೈಮ್ ಬೇಕಾ? ಯಾಕೆ?
New office bearers have come.
ನೀವು
Office bearers. So the matter is being reconsidered on 6th in the executive committee meeting.
ಅದು ರೆಕಾರ್ಡ್ ಮಾಡ್ಲಾ?
Even fact, I have to inform the other side also. They are also agreeable.
ಆಲ್ ರೈಟ್. ಒಂದ್ ನಿಮಿಷ ರಾಜ್. ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್ ಏನದು?
48.
The learned counsel appearing for the respondent institution submits that the new management is in place and the management is now wanting to reconsider the termination orders that were passed against these
No,
petitions.
they are placing it before the executive committee.
The management is of the opinion that the orders are to be reconsidered and are placing it before the executive committee on the 6th of December 2025. In the light of the said submission, list this matter on ಯಾವತ್ತು ಹಾಕ್ಲಿ ಸರ್ ತಮಗೆ?
Beyond 13th, because I will be going to Ayodhya on the 8th.
Oh.
For 1 week I will not be here.
Yes, sir. 9th. 9th January ಗೆ ಹಾಕ್ಬಿಡ್ತೀನಿ.
Supposing they.
In the event there is nothing, you can move the matter.
In that event, both of.
In the light of the said circumstance, list this matter on 9/1/2026. The petitioners, the parties are at liberty to move the matter in the event there is a resolution of the grievance, or if there is no resolution of the grievance, the petitioners are at liberty to move the matter in the interregnum. Yes.
Serial number 47, my lords. Matter pertains to Koramangala and Indiranagar shopping complex.
Koramangala and?
Indiranagar shopping complex.
Okay.
I request for 2 weeks' time, my lord, I want to file objections. Petitioners counsel, my lord, have informed. 47.
BDA ga ನೀವು?
I pay for the private respondent, I informed the BDA counsel, my lord. And the petitioners counsel also is present before your lordship.
I appear for the petitioner's counsel.
Sir is here.
My friends are also here.
Idhar, yes sir.
2 weeks, my lord, sir.
I'm okay.
First week, Jan.
Please.
Same 9th. Objections, if any, at the request of the council appearing for the respondent, list the matter on. The demolition ಕೊಟ್ಟಿದ್ವಲ್ಲ permission ಖಾಲಿ ಆಯ್ತಾ?
That we are in the process of doing it, my lord.
Yes. So list the matter on 9th. Interim order of any kind modified from time to time, or interim order of any kind subsisting as on date shall stand extended till the next date of hearing.
Please, my lords.
18th.
ಮುಗಿಸ್ಕೊಳ್ಳೋಣ ಯಾಕೆ ಗಿರಿ?
After vacation month.
ಯಾವ್ದು 18?
18.
All right. Interim order ಇಲ್ಲಲ್ಲ?
ಇದೆ.
ಹಂಗಾರೆ ಮಾಡ್ಬೇಕು. Wait, yes.
ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ಒಂದು ಡೇಟ್ ಆದ್ರೆ ಅಲ್ಲಿ adjournment ತಗೋತೀನಿ.
List on 9th.
Interim order to
Serial number 45, my lord. This is with respect to that RE policy, my lord. Karnataka RE policy.
ಇರ್ಲಿ, renewable energy.
It was specifically set down to be heard at 2:30, my lord.
2:30, sir.
Interim order. Interim order.
Tabas Hussain ಇದ್ರಲ್ಲ, ಅದೇ ತಾನೆ? She was there here.
Great.
Serial number 49.
New space.
Set down for your.
Viewer? ನೋಡಿಲ್ಲ.
Password matter number 2.
First, we got may observe your worship that while your worships cost these proceedings, the worship place relies on the bail order. And we got the worship's understanding of the bail order, the extent of the what was
Erroneous.
so therefore, not my first endeavor is to pursue your worship that if I may quickly take your worship to that order. Please turn to page 11 of the order which is sought.
Last time ಹೇಳಿದ ನೆನಪಿದೆ. Yes, yes.
Just 2 sentences, just to set a premise for my.
Yes, yes.
Page 11.
Of the bail order.
No, of your worship's order.
All right.
Where your worships have extracted the bail order.
Yes.
Bottom, got the last 5 lines. Page 11.
Yes.
However, since the NCP officers have not complied with the mandatory requirements of 50A, before undertaking the exercise of control delivery, the report of the control delivery on these matters has been placed with the prosecution cannot be considered. What follows is important. Since the exercise of the control delivery gets initiated for non-compliant. So what his lordship said was, the exercise of control delivery gets initiated. But now can you see the next page? In the, your lordship took it as the entire process. So that's where the error has.
No, one clarification. If the very exercise of control delivery is vitiated, would it not take away the entire thing?
No, because control delivery is one of the investigative tools for me. I have got other evidences.
But true, review.
Control delivery definitely stands, I concede. It was without approval. Control delivery goes. But how will the entire crime be shared? I have got evidences with me. There should be a trial.
It should go there and come back.
Then I understand.
No, I would have, but for the latest judgment of the apex court.
On that note, my second submission would be, when your lordship passed the Inayatullah judgment.
I know that is the child pornography ಬಗ್ಗೆ ಬರ್ದಿದ್ರು. There's a reason. No, that is, I understand why I wrote that. No, I understand why I wrote that. Correct, but now with the latest judgment of Supreme Court, problem is that my hands are tied. Otherwise, definitely what you say may be accepted.
May make this submission. While passing the order in Dinatala, your lordships noticed that if the circumstances so require, the court will have to answer the judicial conscience. Now, Lord makes that in the second case, Lord, now that your lordships are aware of what error crept into.
ಅದು ರಿಸರ್ವ್ ಆಗಿದೆ ಏನಾಗಿದೆ? Then we'll see.
In that, Lord, at least your lordship can.
Let me see. Yes, let me see.
If the law
recalling this is.
Then at least in the subsequent.
That power we always have.
Because in my respect submission, that he says now we are in a circumstance which requires answering the judicial consent. Because otherwise what happens is, wherever there is a.
Correct, what you say is right, but ASG sir, idರಲ್ಲಿ recalling al ಕಷ್ಟ. That will answer.
The subsequent order.
That I will, ಅದಕ್ಕೆ ಅದು ಕೇಳಿದೆ ರಿಸರ್ವ್ ಆಗಿದೆ ರಿಸರ್ವ್ ಆಗಿದೆ I will answer that. This orders, I will pass orders on this side. The subject petition stood disposed by an order dated 10/1/2025. Hello, 10/1/2025, whereby proceedings stood quashed against the present petitioner, the accused number 2. The Union of India, or NCB, the NCB has preferred the subject application seeking recall of the order on the score that the order proceeded on an erroneous presumption that the vitiating of the controlled delivery would vitiate the entire proceedings by following the judgment rendered by the coordinate bench while granting bail to these accused. The learned Additional Solicitor General, Shri Arvind Kamath, would take this court through the order in the bail and the order passed by this court to buttress his to contend that it is on the face of it an error, and therefore the court should exercise its jurisdiction to recall the order and rehear, restore the, recall the order, restore the file and rehear the matter. The submission of the learned counsel for the the counsel for the petitioner would submit that recalling of the order is not permissible in law in the light of a specific bar under section 362 of the CRPC. Therefore, the recall of the order is impermissible. He would further contend that the order passed by this court would not necessarily need any recall even on its merit, as there was nothing found against the petitioner, and therefore this court had proceeded to pass the following order, pass the order that is order while disposing. The submission of the learned additional Solicitor General could have merited consideration, at least if the proceedings had not been culminated in the allowing of the petition by quashing the proceedings qua the said accused. Section 362 of the CRPC poses a specific bar on the courts to review or recall the order. Section 362 of the CRPC reads as follows. The interpretation of Section 362 need not detain this court for long or delve deep into the matter. The Apex Court in two of its recent judgments in 2025 SCC Online, SC page 1783, has held as follows. Quote para 34. Para 34 is. In 2020, yet another judgment, the Apex Court in 2025 SCC Online, SC 2184, has held as follows. Para 26. The Apex Court holds that it is only clerical errors that can be corrected in an application for recall invoking Section 362 of the CRPC, and the court cannot sit in appeal over its order in the garb of an order seeking a correction of an error, that is crept in while passing the order. Error could be going to the root of the matter even. Therefore, it is the learned ASG relies on a judgment rendered by this court in Inayatullah so and so. The reason for rendering the said judgment was recalled on a different circumstance altogether, as it was concerning a burning topic then of child pornography. Therefore, in those facts and circumstances, the said judgment stood recalled. The findings rendered therein, or the reasons for recall rendered therein, cannot be paraphrased to the subject order, for the reason that the Apex Court clearly holds in its latest judgment that only clerical errors can be corrected under Section 362 of the CRPC and not the entire judgment. In that light, the application stands rejected.
Professor.
ಅದಕ್ಕೆ ಅದರಲ್ಲಿ we will see what's to be. Next.
Hi.
That Valmiki case, my lord. Again, Jagdeep.
Number 5.
It may be pass over, my lord.
Pass.
Number 8.
Please, my lord. Please, my lord, sir, filed an application, modify the order. My lords, what was dictated was
No. Allah, the respondents, what is that, Siddharth?
My lord, I had made a clarification. What my lords, so what they had said is that we will not alienate any of the properties. I then came back and made a clarification saying that there's nothing in his name. It'll have to be as far as the other respondents are concerned. My lords, insofar as that is concerned, okay, that he has made a submission after the matter was dictated. My lords, the respondent not to precipitate the matter before the concerned court was dictated before this honorable court.
That is not there, is it?
That is not there. That was again subject to, my lord, them having paid all the arrears insofar as maintenance is concerned. That is not correct, my lord. As well as, my lord, the fact that they are supposed to pay the tuition fees, all of it, my lord.
It's a video is it's live. I'll see and then pass out.
Because my lords,
whatever correction is there, we'll do it.
Please, grateful, my lords. Yes. Whatever arrears are there, both of us have to pay, my lord. Now today he's refusing to pay the tuition fees.
Anyway, it's already fully paid. Nothing remains.
May I just make one submission
made after we had.
My lords had
the
also
order was already passed.
One second.
No, not one word extra than what I have said there.
Please.
Yes.
Very well. May I just make one submission? My lords, it said that it's a conditional order subject to them having paid all of this. Now, my lords, it
Whatever
said
I
that-
have
please.
said on that.
Now, today there are arrears, my lord, which he still not
There
paid.
is a different scenario. You can agitate it before the
My lords,
other
I said
court.
because the order is conditional to say that if they do not pay the arrears, it will be dismissed.
That will see.
Some order ಇದೆ. It's
ಅಲ್ಲಿ
recorded.
ಏನಿದೆ ಅದ್ ನಾನ್ ಮಾಡ್ತೀನಿ.
ಅಲ್ಲ ಅದಲ್ಲ my lord, it's recorded in the order itself.
Then it's leave it. If
ಅದಕ್ಕೆ
it's in the order, it will be in
it
the
ought
order.
to be dismissed today, my lord, because today he's not paid the arrears.
That will see. You are on modification.
Modification ಮಾಡಿದ್ದಾರೆ because in fact he was also asked to take notice on the other respondents. He has not taken
Different
notice on the
thing.
other
It's on
respondents.
modification. We will answer.
Please, please, please. Grateful, ma'am.
I'll
Please,
look into it and pass.
please, please. Obliged.
So
Yeah,
this is that matter
validity.
regarding, my lord, so far as the first of the petition, my lord, Tahsildar has to be appointed.
My submission is
Hello.
only one this much, madam. Their memo of instructions, trajectory ಹುಡುಕ್ಬೇಕು, measurement ಹುಡುಕ್ಬೇಕು, path ಹುಡುಕ್ಬೇಕು. Tahsildar
My lord,
can just go and
my
look
sub-
at physical look
Tahsildar is
ಆಗುತ್ತೆ.
already appointed by the
Measure
trial court.
ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ.
Has been appointed, then they file a application to seek modification of that order. That application gets dismissed, that is under challenge here. Please,
ಅಲ್ಲೇ.
my lords, it is up to the court commission, no, my lords, it's up to the trial court to decide who is the competent authority.
No, my lords, this is not that scenario, my lords. The scenario is there is a violation of Kaludari and a construction put up by default. That has to be trajectory, has to be identified, measurement. ತಹಸೀಲ್ದಾರ್ ಚೈನ್ ಹಿಡಿಯೋದು ಅವ್ರಿಗೆ ಎಷ್ಟು ಲಿಂಕ್ ಇದೆ ಅಂತಾನೂ ಗೊತ್ತಿರಲ್ಲ ಸ್ವಾಮಿ. ವಿತ್ ಗ್ರೇಟ್ ರೆಸ್ಪೆಕ್ಟ್.
Since he has already been appointed, my
ADLR
lords, there
will know all
cannot
this.
be.
That is the reason for which it is sought. This is not ADLR.
My lords, Tahsildar has already been appointed, court commissioner warrant was issued.
It's already in some challenge.
My lords, what is challenged here is the dismissal of his modification application. Now under 226, how can he seek, I mean, have a challenge against the modification application order? My lords, but the reasons provided therein will not support his case, my lords. I'll leave it to your lords, my lords. My lords, that confusion, I have not created any such.
I was ready with any bench. I was ready with any bench. I don't want to make an allegation after what has happened, who stressed, who vehemently argued. I am not the person.
That is.
I am not the person.
ಇಲ್ಲ ಬರ್ಬೇಕಿತ್ತು ಸ್ವಾಮಿ ಅಷ್ಟೇ ನನ್ನ point.
I am not the person. Who vehemently argued, ಇಲ್ಲ ನಿಮ್ ಮುಂದೆ ಬೇಡ, ಇನ್ನೊಬ್ರು ಮುಂದೆ ಬೇಕು ಅನ್ನೋದು. I am not that person.
My lords, my submission.
ಮುಂದೆ ಬರ್ಬೇಕಂತ ನಾನಂತೂ ಆರ್ಗ್ಯೂ ಮಾಡಿಲ್ಲ. I was ready with any 40 courts of this honorable court. Yes, man. I was ready because there should be a misunderstanding on me on this part.
Please, my lords.
And insofar as second aspect, accordance with law ಅಂತ ತಾವು ಹೇಳಿದ್ರೆ, ಅವರು ನೀವು ಹೇಳಿದ್ದೆ ಡೈರೆಕ್ಷನ್ ಇದೆ, ಹಂಗಾಗಿ ನಾನು ಮೆರಿಟ್ ಎರಡಿದೆ ಸ್ವಾಮಿ, ಎರಡಿದೆ ಚಾಲೆಂಜ್ ಮಾಡಿ. ಮಚ್ ಒಬ್ಲೈಜ್. ಅದು ವಿಡ್ರಾ ಮಾಡ್ತೀವಿ, ಅದು ವಿಡ್ರಾ ಮಾಡ್ತೀವಿ. I will withdraw both the things. I will file a memo if required. My client, petitioner. Prasad is petitioner. Now, I'll that I will by tomorrow.
Number
1 of 25. Much, sorry. Recall. It's dated 17th October.
Further undertake that the petitioner withdraw communication dated 14/10/2025.
Great.
14.
Ah, yes, sir.
For orders, madam. From yesterday,
Discharge better. ಹಾಕ್ಬಿಡಿ ಆಮೇಲೆ ಒಟ್ಟಿಗೆ ಎಲ್ಲ ಕೇಳ್ಬೋದು. ಇಲ್ಲೇ ಬರುತ್ತೆ ಹೆಂಗು. Will direct the concerned court to dispose it within 8 weeks. File an application.
Please.
The learned counsel appearing for the petitioner submits that he would avail the remedy of filing a discharge before the concerned court. In the event the application is preferred, the concerned court shall, within an outer limit of 8 weeks, decide the application seeking discharge and pass necessary orders in accordance with law. It is needless to observe that while considering the application seeking discharge, the concerned court will bear in mind the law or the observations made by the courts in plethora of cases, ordered accordingly.
16.
One, yes.
I appeal for the respondent number 1, my lord.
Need some time in this matter, my lord.
Balan sir ಹೇಳಿ ಅವರು need some time, why?
I'm not fully ready in the matter, my lord. So.
Sandesh Shota is saying not ready in the matter.
Dying declaration is their last note. Before death, he records his voice and forwards to everyone. There is an, that is subjected to expert opinion also. If date is required, kindly have it next week.
We'll fix it next week. Because there is urgency. First week January ಆಗ್ಬೋದಾ?
What happens, my lord, in this case, there is a huge social media that police are filing false cases. Idralli. Entire Mangalore it is running around. And many YouTubers, so fake cases against police, allegations, counter allegations. Therefore, I feel it's an urgent, it has to be set at rest.
We'll have it on 5th.
Please, my lord.
Yes, at the request of the learned senior counsel, Sandesh Shota. This the matter on interim order subsisting will continue till the next date of hearing. Yes.
Please.
December.
19.
When my lords is here, my lord.
Yes,
so
sir.
I pay for the second as file.
My lord, serial number 19, I represent the petitioner, my lord.
Yes, sir.
This is a case wherein a complaint has been filed on 11/2/22. Based on that complaint, a claim case came to be registered on claim number 16/22 for the offence under section 354, 504,
Yes, sir.
506, 509, read with 149 of IPC, and also section 3131, 31H and 31R of the SC/ST Prevention of Atrocities Act. Later, my lord, in this case, the matter has been referred to the police have registered a case and the investigation has been taken up by Assistant Commissioner of Police, and a B final report has been filed. Subsequently, the Honorable Court has rejected the B final report and further referred under 173(8) for further investigation to other police station headed by another ACP. Even after review investigation by the another ACP, also again he has filed the B final report. There were two B final reports have been filed before the.
Which is the first B report? Which is the first B report?
I will just tell you. The first B report filed on 18/8/22. Your lordship will find at page 43.
18/8?
23. Sorry, 22.
Yes.
Your lordship will find at
The
page
second-
43.
The second one?
Second B report was filed on 24/11/2023. Your lordship will find page 59.
The protest memo for the second B report?
Has been filed, protest memo.
79.
Page?
79.
Page 79 to 83. Protest memo has been filed. Question and
answers 57. The second one.
Page?
79.
Second
Page
protest
79
memo.
to 83.
Yes, sir.
If your lordship turn to page 57, The
Ah.
investigating officer has recorded the statement on question and answer. Page
Ah.
57.
Yes, sir.
Your Lordship may kindly see on the fourth line, page 57, fourth question. Yenanta, fourth question. Yenanta, my lord, ಏನಂತ ಮಾತನಾಡಿರೋದು ಹಿಂದಿಯಲ್ಲಿ ಮಾತನಾಡಿರೋದು ನನಗೆ ಹಿಂದಿ ಏನು ಏನ್ ಬರ್ತಿತ್ತಾ ಅವರು ಬರೀ ಹಿಂದಿಯಲ್ಲೇ ಮಾತನಾಡೋರು ಇಂಗ್ಲಿಷ್ ಹಿಂದಿನಲ್ಲೇ ಮಾತನಾಡುವರು ನೆಕ್ಸ್ಟ್ ಕ್ವಶನ್ ಅವರ ಮನೆ ಅವರ ಪ್ರೈವಸಿಗಾಗಿ ಇರ್ತಾರೆ ಏನು ಕೆಲಸ ಮಾಡ್ತೀರಿ ಅಡಿಗೆ ಮಾಡುವುದು ಬಟ್ಟೆ ಒಗೆಯುವುದು ಅಂಡ್ eighth question if your on comes into the middle of the page eighth question ನೀವು ಆಮೇಲೆ ಬೇರೆ ತರ ಕಂಪ್ಲೇಂಟ್ ಜಾತಿ ಬಗ್ಗೆ ಕೊಟ್ಟಿದ್ದೀರಿ ಆನ್ಸರ್ ಹಿಂದಿಯಲ್ಲಿ ಮಾಕಿಚೋದ್ ಅಂತ ಮಾತನಾಡಿದ್ದು ನನಗೆ ಅರ್ಥ ಆಗಲಿಲ್ಲ ಬೇರೆಯವರ ಹತ್ರ ಮಾಕಿಚೋದ್ ಅಂದ್ರೆ ನೋಡ್ರ
ಆಯ್ತಾಯ್ತು ಬೇಡ ಬಿಡಿ
ಅಂದ್ರೆ ಅದು ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ kindly turn to page 58 page 58 in the middle no question I was put a question ನೋಡಮ್ಮ ನೀವು ಯಾವ ಜಾತಿ ಅಂತ ಗೊತ್ತಿರುತ್ತಾ ಅವರಿಗೆ ಇಲ್ಲ ಗೊತ್ತಿರಲ್ಲ
ನೀವು ಜಾತಿದ್ ಬಿಡಿ ಬಾಡಿ ಮಸಾಜ್ ಯಾಕೆ ಮಾಡಿಸ್ಕೊಂತ ಇದ್ರಿ
ಅಲ್ಲ ಅದೂನು concocted version ಯಾಕೆಂದ್ರೆ
what concocted version consistent version of this lady is used to call her harasser for body massage
ಅಲ್ಲ that is the allegation made by the complainant why she has made such allegation with the background ಇದೆ a charge sheet has been filed against her and also some association people for having extracted the money from the what is that company from the global management housekeeping agency by name global management. They have deputed about 2,500 people to ESI Rajajinagar. They are not attending to the office properly to cleaning and other purposes. When they remained absent, the management used to tick absent. Then the accused number, the petitioner accused number 1 is the
so absent na presence convert madak idella na absent na present convert madak
trade union they have extracted money from the management. The accused number 1 being a deputy director finance used to go according to the rules. ಯಾರು absent ಇದ್ರು ಅವ್ರಿಗೆ absent ಅಂತ ಕೊಡ್ತಿದ್ರು ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅವರು
ಮಸಾಜ್ ಯಾವ ರೂಲ್ಸ್ ಅಲ್ಲಿ ಇದೆ
ಅಲ್ಲ ಮಸಾಜ್ they have added all those things to bring 354 they have added all those things. There are so many statement of the witnesses. None of the witnesses have alleged anything. 2,500 people are working
4 years delay
and complaint itself is 4 years delay. There is no mention in the complaint. In fact, a case has been registered against this complainant and also one of the organization member in
96
page 96. They have been charged sheeted.
That what to do? Offense is the best force of defense.
And that apart, there is no speaking order. Even if your lordship turn to the order passed by the learned trial court, there is no
speaking ಬೇಕಾ ಸರ್
ಅಲ್ಲ ಅದರಲ್ಲಿ ಅಲ್ಲ ಅವರು ಕಾಂಗ್ರೆಸ್ ತಗೊಂಡಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. For what offense your lordship may kindly turn to page 28.
And ಎರಡೆರಡು ಸರಿ ಬಿ ರಿಪೋರ್ಟ್
It's not second B report. First B report was submitted. Second one is the report.
What report?
Court wanted further investigation. That report has placed.
ಅಷ್ಟೇ ಬಿ ರಿಪೋರ್ಟ್ ಇರೋದು ಒಂದೇ
report.
ಅಲ್ಲ ಎರಡು ಬಿ ರಿಪೋರ್ಟ್ ಇದೆ. Second B report, your lordship will find at page 50.
I've seen the entire records. There is only one B report.
Wait.
Two B reports.
There is wait.
Sorry.
Page 15. Page 59 ತಗೊಳ್ಳಿ ಸರ್. ಅಲ್ಲ ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಅಂತ ತಗೊಳ್ಳಿ.
59 ಅಲ್ಲೇ ಇದ್ದೀನಿ.
59 ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್. ಇಂದಿನ ತನಿಖಾಧಿಕಾರಿಗಳು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಬಿ ಅಂತಿಮ ವರದಿಯನ್ನು ಸಲ್ಲಿಸಿದ್ದು ಸದರಿ ಮಿರಿಯಾದ ಮೇನಕಂಬವರು ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಅಲ್ಲಿ ಅಂಗೀಕರಿಸಿರುವುದಿಲ್ಲ. Then he has also recorded the statements of witnesses. Thoroughly he has examined the statement of witnesses again.
That's a report, not a B report.
Not a B report.
Protest petition is filed even for this.
No, yeah, against this protest petition has been filed. It's a
Correct.
report.
Hmm.
Your Lordship can kindly turn to page 78, that the last page. ತಾರನಾಶಿಟಿ ಹಣ ನಿರಾಕರಿಸಿದ ರವಿ ಶೆಟ್ಟಿ ಬೈಂದೂರ್ ಎಂಬುವರು ಠಾಣೆಯಲ್ಲಿ ಆರೋಪಿತರ ವಿರುದ್ಧ ಬಿಮಲ್ ಕುಮಾರ್, ತಾರನಾಥ್, ವಿಶಾಲಾಕ್ಷಿ, ಕೃಷ್ಣಮೂರ್ತಿ ವಿರುದ್ಧ ಜಾತಿ ನಿಂದನೆ, ಲೈಂಗಿಕ ದೌರ್ಜನ್ಯ, ಪ್ರಾಣ ಬೆದರಿಕೆ ಹಾಗೂ ಅವಾಚ್ಯಬ್ದಗಳಿಂದ ಬೈದು ನಿಂದಿಸುತ್ತಾರೆ ದೂರು ಕೊಟ್ಟಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಆರೋಪಿತರ ವಿರುದ್ಧ ಆರೋಪ ದೃಢಪಡಿಸುವಂತಹ ಯಾವುದೇ ಸಾಕ್ಷ್ಯಾಧಾರಗಳು ಲಭ್ಯವಾಗಿರುವುದಿಲ್ಲವೆಂದು ಘನ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ವರದಿಯನ್ನು ನಿವೇದಿಸಿಕೊಳ್ಳುತ್ತಿದ್ದೇನೆ. ರಿಪೋರ್ಟ್ ವರದಿಯನ್ನು ನಿವೇದಿಸಿಕೊಳ್ಳುತ್ತಿದ್ದೇನೆ. ಯಾವುದೇ ಸಾಕ್ಷ್ಯಾಧಾರಗಳಿಲ್ಲ.
ವರದಿ ಅದು. It's only a report.
Yes, report.
It's only a report. You can't draw support.
Yes, even if it is a report. Entire statement of all the witnesses were examined, thoroughly examined and filed the report. And against them, your Lordship will find at page 96, charge sheet has been filed for extortion, wherein this petition, wherein the second respondent is also arraigned as accused, joining with one Ravi Shetty Baindur, who wanted to form the union and to stand against the ESI hospital.
ಇದಕ್ಕೆ ವಿಟ್ನೆಸಸ್ ಇದ್ದಾರೆ. Anyway, ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ. If your honor peruses that charge sheet filed, corporate charge sheet filed in CC 31/924/2022.
We will see. Yes, sir.
At page 96. And also, Kindly see, 506, 504 is different. SC/ST Act does not attract, for a simple reason. She claims that within the house, she was doing some, when she was cooking, etc., he was doing some abusing her by taking caste and all. Your Lordship has come across the latest judgment. I have not produced that. Reported in 2025 SEC online, SC 215. Korupudiyar versus state. There, the Lordship has observed the apex court has been they have differentiated what is public place and public view. I would like to.
ಇದು ಮನೆ ಒಳಗೆ ಮಾತ್ರ ಆಗಿರೋದು ಅಂತ.
ಮನೆ ಒಳಗಡೆ ಆಗಿರೋದು. It is not within public view. Even otherwise also the offense will not survive.
Obviously, sir, allegation is body massage ಆಚೆ ಅಂತೂ ಮಾಡಲ್ಲ ಅದು.
SC/ST ಬರೋದೇ ಇಲ್ಲ.
Yes. Heard reserved. Yes.
Interim order may be extended till then. Interim order may be extended.
One submission.
ಹೇಳಿದ್ರಲ್ಲ.
My lord, 4 witnesses has been examined by the trial judge.
ಬೆಳಗ್ಗೆ ಹೇಳಿದ್ರಲ್ಲ.
ಅದೇ ಮತ್ತೆ there are sufficient material. ಆಮೇಲೆ ಮೊಬೈಲ್ ಇದೆ, ವಿಡಿಯೋ ರೆಕಾರ್ಡ್ಸ್ ಇದೆ, ಅದು ಬಾಡಿ ಮಸಾಜ್ಗೆ ಮತ್ತೆ ಪರ್ಸನಲ್ ಇರೋದು.
ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಬೇಡಿ, ವಿಡಿಯೋ ಎಸ್ ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಆದಾಗ ಆಗ್ಬಿಡುತ್ತೆ.
Okay. This decision I will leave it in the office tomorrow.
ಅದು ಕೊಡಿ ಸರ್, ಪರವಾಗಿಲ್ಲ. ಪೆನ್ ಡ್ರೈವ್ ಇರೋದು ಪೆನ್ ಡ್ರೈವ್ ಇರಲಿ.
Please.
Yes.
23.
Review. I have my job to pass the order. On the review, Allah.
Yes.
We'll take it as reserved and pass. Yes. Vadinath sir ಹೇಳ್ಬಿಡಿ. ಮೇಡಮ್, ರಿವ್ಯೂ ಮಾತ್ರ ಏನಾಯ್ತು? ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎನ್ಕ್ವೈರಿ
ಗೌರ್ಮೆಂಟ್ ಕಳಿಸಿದಾರ ಅಂತ ಇನ್ನೊಂದು.
ಗೌರ್ಮೆಂಟ್ ಕಳಿಸಿದಾರ ಏನಕ್ಕೆ?
ಸೆಕ್ರೆಟರಿಯೇಟ್, ಬಿಕಾಸ್ ಡಿಸಿಪ್ಲಿನರಿ ಆಕ್ಷನ್.
ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಿಲ್ವಾ ಇನ್ನು? ಸಾರಿ, ಚಾರ್ಜ್ ಶೀಟ್ ಮಾಡಿಲ್ವಾ?
ಡಿಸಿಪ್ಲಿನರಿ ಆಕ್ಷನ್ ಅದ್ ಮಾಡಿದ್ದಾರೆ, ನೋಟಿಸ್ ಕೊಟ್ಟಾಗಿದೆ. ಆಕ್ಷನ್ ಗೆ ಐ ಬಿಲೀವ್ ದ ಗವರ್ನಮೆಂಟ್ ಹ್ಯಾಸ್ ಟು.
ಏನ್ ಆಕ್ಷನ್ ಗೆ?
An affidavit was also filed
by the commissioner.
Commissioner was present.
Yes, he has filed an
Then we
affidavit.
will direct the secretary to be present now. If you don't know how a departmental inquiry should be conducted, who is this man?
Assistant administrative officer.
ಏನ್ ಮಾಡಿದಾರೆ ಈಗ?
They want 3 more weeks time.
3 more weeks time for what?
Because the report has placed to the government and the government has
Which
to take
report?
about the departmental inquiry report.
Inquiry ಆಗಿದೆಯಾ?
Inquiry.
ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
ಅನುಬಂಧ ಎಲ್ಲ ಕೊಟ್ಟಿವ್ರಿಗೆ ಆಗಿದೆಯಲ್ಲ? ಆಗಿದ್ರೆ ಐ ವಿಲ್ ಗಿವ್ ಇಟ್ ಟೈಮ್. ಪೆನಲ್ಟಿ ಇಂಪೋಸ್ ಮಾಡಿ ಬರ್ಲಿ, ಆಮೇಲೆ ನಿಮ್ ಬಗ್ಗೆ ತಿಳ್ಕೊಳ್ಳೋಣ. This court from
ಆಗಿದೆಯೋ ಇಲ್ವೋ ಗೊತ್ತಿಲ್ಲ ನನ್ಗೆ.
ಇಲ್ಲ ಆಗಿದೆ.
ಗೊತ್ತಿಲ್ಲ ಏನು ಅಂತಾನೆ, ಏನು ಮಟೀರಿಯಲ್ಸ್ ಪ್ಲೇಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ, ಬರೀ ಹೇಳ್ತಾ ಇದಾರೆ ಅಷ್ಟೇ. ಬಿಕಾಸ್ ಕಮಿಷನರ್ ಸೆಟ್ 2 months ಅಲ್ಲಿ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದಾರೆ.
ಅವ್ರು ಮಾಡಿ ಕಳಿಸಿ ಆಗಿದೆ.
ವಿಚಾರಣಾ ವರದಿ ಆಗಿದೆ.
ಆಗಿದೆ.
ವೆರಿ
OPD ಸ್ಲಿಪ್ ಮಿಸ್ಟೇಕ್ ಜನರೇಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ.
And it has been now inquiry says it has been proved. It's only for departmental action.
This court on 6/2/2020, this court initially on 9/12/2024 had passed the following order. The doctor who had examined the victim 12 hours before the second doctor examining had indicated that there was no bruise on the body, no injury of whatsoever nature. The complainant, as observed, travels from Chittigeri District Hospital to, travels from Bhadravati to Davanagere. In the next 12 hours, the next report is generated, next wound certificate is generated, which depicts complete bruise on the body, bleeding injuries, and other bleeding injuries. This is placed before the court, due to which the petitioner's case was prejudiced and was not bail kodilla.
ಅಲ್ಲ ಅಪಿಯರ್ ಆಗಿಲ್ಲ, ಇಲ್ಲೇನೆ
And
ನಾನು
so-
ಚಾರ್ಜ್ ಶೀಟ್ has been filed.
And charge sheet was filed on the strength of the said wound certificate. Therefore, there were 2 wound certificates, one no injury and one only injury, full of injuries. Therefore, the doctors were directed to be proceeded departmentally for having drawn a report contrary to the earlier report. The preliminary inquiry is said to have been complete, and the doctors are now found guilty of preparing a false report or a false wound certificate and place the same before the court. The file is now said to have been transferred to the secretary for appropriate action against these doctors. Therefore, the action taken against the doctors pursuant to the report be placed before this court on the next date, list on 6th January at 2:30 PM.
Please.
In the event no action is taken or no proceedings further are drawn pursuant to the report, the secretary, health,
Commissioner.
the commissioner so and so, ಮುಂಚೆ ಮಾಡಿದೀವಿ, commissioner so and so shall be present before the court. Yes.
Please.
Next.
39.
Short adjournment, my lord, any day, Monday is also okay for me.
Advocates Association.
Please, this is the pertaining to registration of person, direction by the
ಎಲ್ಲಿ ಇವರು?
Supreme Court, my lords.
Where is the president?
He's, he called me,
Out of country
he has,
na?
no, he's out of Karnataka, out of Karnataka onto Delhi.
ಯಾಕೆ ಅಲ್ಲಿಂದ ಹೊರಗೆ ಅಪೇರ್ ಆಗಕ್ಕಾಗಲ್ಲ?
He was on the, he was on the journey, he said, my lords.
No, because Supreme Court is
I
directed,
can see,
not-
my lords. If my lord permits, I can.
ನೀವು ಮಾಡಿ.
So my learned friends will continue.
All other members are there.
They will continue on Monday.
Monday?
Or whichever your lords is pleased to accommodate us.
I'll take this on Tuesday at 4 PM. Tuesday at 4 PM, that is 2nd December.
Second ಬಿಟ್ಬಿಟ್ಟು fourth ಆಗ್ಬೋದು.
ಆಯ್ತು, next week ಅಲ್ಲಿ ಮುಗಿಬೇಕಿತ್ತು.
Fourth.
No problem. 4th December, but next week ಅಲ್ಲಿ Supreme Court has directed closure.
Please.
Yes. Because if report is sought, what is happening here, there is nothing has happened here except adjournments. Yes, sir. List
Lordship, please.
Finally, list the
please.
matter on, for the learned, at the request of the council appearing for the parties, list this matter on December the 4th, 2025 at 2:30 PM. It is made clear, no further adjournment would be granted on whatsoever ground it is. Interim order subsisting will continue to the next date of hearing. Objection, ನೀವು objection ಹಾಕಿದ್ದೀರಾ ಎಲ್ಲಾದ್ರಲ್ಲೂ? State ಅಷ್ಟೇ, ಇವರು ಅಷ್ಟೇ, ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ. Union is also filed. Yes. Ask Vivek Reddy not to go anywhere that day.
Please, my lords. I would be probably, my lords, there are other parted matters before my lord on that day in the road bench, my lords. So I will physically present. Please, my lords, in fact, at the initial stage when your lords granted the interim order, that was absolute, my lords. But subsequently we ourselves went on asking for extension, then we did not.
It can't be still next date because I have stayed the act.
Ananತರ ಕೆಲವೊಮ್ಮೆ next
date. Interim order subsisting continues till the disposal of the petition.
We are grateful, my lords. Because many advocates are practicing on this side, my lords.
No, I am aware of all that. That's the reason why I have stayed it. Because
we are grateful.
It was helpful to advocate, so
Please.
I had stayed it. But we can't go on like that.
Please.
We have to answer it on its merit.
Only point which we will be canvassing is this one. The executive magistrate can decide this, or the judicial magistrate.
That's exactly the
Your
point.
lordship, in fact, had held that's on the Karnataka
Oh,
rules.
there I had held the tail cannot wag the dog.
Yeah, exactly.
Because the central rules, the state rules could not have
Exactly.
been contrary to the main rules.
Please, my lord.
That's why.
Now, my lord, decision making process it involves
We'll see
drastic
about
steps.
it. Anyway,
Please.
argue ಮಾಡದ್ ಮಾಡಿ.
Please.
ಇಲ್ವಾ?
Grateful. Very good.
4th December. 4th December.
Please.
This sixth matter, my lord, interim order, my lord, requires to be extended because it was extended till further orders. Last date ಅಲ್ಲಿ till next
ನೀವೇ
date ಅಂತ
ಕೇಳಿರೋದು.
ನಾನು ಕೇಳಿರಲಿಲ್ಲ.
Absolute interim order until previous matter ಅಲ್ಲಿ
36.
that is interim order extends till the disposal of the petition.
Please.
Next.
Much.
41.
Jagdish sir. Yes. Is Monty sir waiting?
That one matter is there.
ಒಂದೇ ನಿಮಿಷ. Let him not waste his ತಗೊಂಬಿಡಿ ಅದು.
Please.
Is
Serial number. 49.
ಯಾವುದಕ್ಕೆ? ಒಂದು ನಿಮಿಷ, ಅದಲ್ಲ. The officer is waiting, so I didn't want to. Yes, that I have seen.
Yes.
Now, you should take it to its logical conclusion.
Yes.
On that, I will pass orders.
Yes.
Need not be here. You want to make some submissions?
49.1, Lord.
49.0, which is now tagged. Yes,
It's now tagged.
That bail matter.
Yes, ma'am. The cancellation of bail. I'll require about 25 minutes. Ma'am.
Cancellation of bail.
Yes. There's a direction of the Supreme Court, if your lordships has.
I know direction of the Supreme Court to consider it, but is serious about cancellation of bail?
No. The state as well as the accused have taken an objection that the petition has been rendered infructuous. Because now, my lord, I had given an undertaking before the previous bench that since even according to my computation, that the 90-day period will start from the date of reinvestigation, the charge sheet has not been filed. The lordships has the order sheet. No?
You can sit. Yes.
Yes, ma'am. If your lordships. Lord, so even according to our computation, within the period of 90 days, the charge sheet has not been filed, admittedly. Now, because of which, my lord, before your lordship's predecessor bench, we had given an undertaking that the question of cancelling the default bail may not arise. That has been recorded, but there's a question of law frame. Now, they've taken an objection that the petition has been rendered infructuous since our prayer is for setting aside of that common order passed on application for custodial interrogation as well as application for cancellation of default bail. why the petition is not rendered infructuous is this. Lord, there's a judgment of the Supreme Court 2023 4 SEC. I've asked the learned court officer to produce that copy as well, not for your lordship's reading, where the court says that even if the accused is on default bail, if I cannot persuade your lordship that the default bail was erroneously granted, once the charge sheet is filed before your lordships, I have a right to challenge the bail on merits. Since not, I have a right to challenge the bail on merits once the charge sheet is filed, and since the accused is now enjoying liberty on the basis of default of the investigator, Lord, therefore, my submission to your lordship, the petition does not get rendered infructuous simply because in this challenge, Lord, the bail may not get cancelled. But if I were to persuade your lordship that the default bail was erroneously granted based on an incorrect computation, Lord, then ultimately when the charge sheet is filed, I have a right to challenge it on merits. Therefore, Lord, your lordship will have the memo that I've submitted. My entire case, Lord, will be submitted in the form of 8 propositions with the support of 4 principles of interpretations and 3 citations.
Then we'll not ask the officer to wait. We'll take it a little later.
Yes.
Yes, Monty sir. You need not wait. The report I have gone through, what orders have to be passed on that I will pass. In far as this is concerned, we will take it later, or you want time?
No.
Senior counsel will.
They're ready.
Then come. How do you know that?
Just sit down today. They're ready. This.
All right.
I'm led by a senior counsel.
I will not take
If
more
it's
than.
possible,
I will
we'll
not take more than 15 minutes.
No, we'll take it at 4:15. Yes, 4:15 or 4:30.
Yes.
Continue the list.
41.
ಹೊರದೆ ಅಲ್ಲ ಒಂದ್ ಹೇಳಿ, ಇದೆಲ್ಲ ಚಾರ್ಜಸ್ ಹೋಗಿರೋದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕನ್ಫರ್ಮ್ ಆಗಿದೆ. ಅದ್ರ ಮೇಲೆನೆ ಮತ್ತೆ ನಡೆಯಕ್ಕಾಗತ್ತ? ಅಷ್ಟೇ ಸಿಂಪಲ್. ನಾನು ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಫೈನಲ್ ಆರ್ಡರ್, ಅದನ್ನೇ ನಡೆಸ್ಬೋದಾ? ಮತ್ತೆ ನೀವು ಹೇಳಿ ಅಷ್ಟೇ. ನಾನು ಚಾರ್ಜಸ್ ಐ ಹ್ಯಾವ್ ಸೆಟ್ ಅಸೈಡ್ ಸೋ ಮೆನಿ ಚಾರ್ಜಸ್.
Yes, with that I will not, I will consider with regards to that.
ವಾಟ್ ಎಲ್ಸ್? ಅಷ್ಟೇ.
There's
ಅಲ್ಲ, ಅದ್ರ ಮೇಲೆ ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ ಮೇಲೂ ಅದನ್ನ ಮತ್ತೆ ನಾನು ಮತ್ತೆ ಅದನ್ನೇ ಮಾಡಕ್ ಬರಕ್ಕಾಗತ್ತ ಹೇಳಿ? ಅಷ್ಟೇ ಬೇಕು. ಈಗ ಈ ಟ್ರಯಲ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
Pending, stay ಆಗಿದೆ. So my submission is this, my lords. Time bound matter agli, let him be in custody until main evidence.
Custody? Why?
My lords.
ನಾನು ಕಸ್ಟಡಿ ಕೊಟ್ಟಿದ್ದ ಮುಂಚೆ?
My lords,
ನಿಮ್ಗೇನ್ ಯು ವಾಂಟ್ ಟು ದಟ್ ಸ್ಯಾಟಿಸ್ಫ್ಯಾಕ್ಷನ್ ದಟ್ ಹಿ ಇಸ್ ಇನ್ ಕಸ್ಟಡಿ ಅಷ್ಟೇನಾ?
My lords, that ego is not
ಮತ್ತೆ
question, my lords.
Yes. See,
I'm seeking for that because
Srinivas,
this is the thing, my lords.
the only thing is my interim order I have granted in detail. While so saying, I have said the charges that were already set aside in the case, which it's impossible to allege anbale, adanna ಮತ್ತೆ ಇದರಲ್ಲಿ ಆಡ್ ಮಾಡಿ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ.
My lords,
That's all the issue.
My submission is this, my lords, because this is a case where they have also filed a counter case against the complainants as well as few other witnesses. My lords, there's a chance of them trying to influence these witnesses ಅನ್ನೋದ್ರಿಂದ I am seeking
that charge is difficult. Those charges which I have already Supreme Court confirm ಮಾಡಿದ್ಮೇಲೆ ಮತ್ತೆ ನಾನು ಇದರಲ್ಲಿ ಯಾವ್ದನ್ನ ಮಾಡಿ ಅಂತಂದ್ರೆ ಅದು ನೀವು ಕೇಳೋದು ತಪ್ಪು, ನಾವು ಅದು ಮಾಡೋದು ತಪ್ಪು.
Yes, with that regard I consider.
Yes, sir.
Senior counsel has already addressed arguments.
Already
ಇದ್ರಲ್ಲಿ and we are seeking a short accommodation.
Already addressed can short accommodation.
To further clarify, my lord, with regard to a case has not been made out for 376. ಹೌದು ಸ್ವಾಮಿ.
And one more thing, my lords,
on 8th
the charge sheet that has been filed against the complainant as well as few other witnesses, that has been squashed by the coordinate bench of this court. My lords, that I'll submit in the next date, my lords. I have been informed.
ಈ ರೀಸೆಂಟ್ ಆಗಿ
ನಮ್ಮ ಮೇಲೆ ಹಾಕಿದ FIR squash ಆಗಿದೆ.
ಹೌದಾ? ಈ ರೀಸೆಂಟ್ ಆಗಿ
the stand that they have taken, the contention that they have taken in this writ petition, my lord, it goes out of the window.
we have already preferred an appeal and the case has been admitted before Supreme Court, and a notice has been issued. They have to file their objections.
I will look
at it. I will take it in the first week. Yes.
8th.
List the matter on 6th January.
8th.
ಅದೇ ಅಷ್ಟೇ ಇಲ್ಲ, ಇನ್ 3 ವಾರ ಇದೆ ಅಷ್ಟೇ.
Yes.
Interim order subsystem will continue to the next date of hearing. I have order produce ಮಾಡಿ ನಿಮ್ದು against squash ಮಾಡ್ತಾರೆ.
My lords,
already placed. Yes. ಇದು ಗೊತ್ತಿರಲಿಲ್ಲ, ಅವ್ರ ಮೇಲೆ ಹಾಕಿದೆಲ್ಲ ಹೋಗಿದೆ.
then the contention that they take against us that there was a conspiracy is out of the window.
We have preferred an appeal and it has been admitted.
For the appeal, as of now, my lords, it is.
We'll see. Aye, sir. Next.
42.
I appear for the petition. And I have prepared some short list of dates.
Short time alle short notes, sir. Kudi. Vaidyanathan, sir. You need not wait. I've reserved it. I will pass orders on review.
Yes, madam. Much obliged.
Is short again illa idu?
Just a minute. The 35/1988, the preliminary notification was issued acquiring all these properties for the benefit of Trinity House Building Cooperative Society.
Yes.
Let the final declaration under section 6(1) was issued on 18/3/1989. Let all these landowners, they challenge those petitions in the year 1989 itself. Then when the writ petitions were pending consideration, the landowners have entered into a registered agreement of sale. That registered agreement of sale recites that the entire sale consideration has been paid to the landowner.
After the preliminary notification.
Yes, after the preliminary notification. Then thereafter, they also executed a general power of attorney in favor of the petitioner. But since the land acquisition proceedings were not disclosed, it came to the knowledge of the petitioner that there was a land acquisition proceeding. Therefore, they did not execute the lease deed, sale deed. This court quashed the land acquisition proceedings of these lands on 11/7/1996. Then this was writ appeal was filed. Writ appeal 7557 of 96. Writ appeal confirmed. The matter was taken to the division bench. When the division bench, the Supreme Court, when the matter was Supreme Court, the Bangalore Development Authority issued a preliminary notification. And thereafter, the final notification was not issued under section 19. This court quashed, and the matter was taken to the Supreme Court. Supreme Court quashed orders of this court and directed that the land acquisition of Dr. Sivaram Ram get paid. After coming to know the final notification, that is dated 30/10/2018, the petitioners filed the document before the land acquisition officer stating that this entire lands have been sold to the petitioner by way of an agreement and also power of attorney. 100% sale consideration has been received. The paper publication was issued. Pursuant to the paper publication, the petitioners filed.
Now the only question is who is entitled to compensation?
Yes, that is a question. My respectful submission, I saw your lordship's order, Kindly see that order. It was in a different context where agreement of sale was entered and it was cancelled. And in that background, your lordship said that there was a cancellation of that agreement of sale. Therefore, they are not entitled to the compensation.
No, that's not the only background.
Kindly see, the order I have this thing. They have made available the copy of
correct.
that. Yes. Para 10 of the judge. The entire fulcrum of the present revolves around the aforesaid two dates. The date of issuance of preliminary notification 30/12/2000, date of issuance of final notification. Instances that had happened during the year 10 years is that what required to be noticed. Earlier delineated preliminary notification came to be issued on 30/12/2008. The subject did not form part of the notified land notified for acquisition is admitted fact. Notwithstanding the same, the petitioner fully cognizant of the acquisition process nevertheless enters into two agreements so and so. That agreement of sale is accepted. Yes, I've just third respondent, fourth respondent. Yes. The agreement of sale encompass two parcels of the land for a total consideration of rupees 1,18,80,000, towards which the advance of 40 lakh was paid. The said agreement reads thus, that entire agreement has been extracted. Then, the para, page 25. In terms of the clauses of the agreement, the petitioner, who is the agreement holder, had to pay the balance consideration of 78,80,000 within 6 months. Since the agreement holder failed to pay the balance amount within the stipulated period, third respondent said to have caused a legal notices seeking cancellation of the agreement dated 5/1/2012 and forfeiture of the advance amount. Two legal notices were caused, identical words, a few paragraphs of the legal notice caused to the on the petitioner, so and so. That legal notice has been extracted, Miller. Then cancellation agreement, the page 27, Miller. The legal notice mentions both third and fourth respondent. This said to have received by the petitioner as evidenced by the acknowledgement of registered post, which is appended objection. The agreement is said to have been cancelled the later, and the petitioner takes back the advance amount so paid. The cancellation agreement so far as
that's an added circumstance. The ratio there is,
yes,
after, if you enter into an agreement after the preliminary notification.
But I have not entered into in this particular case. The preliminary, that was a case where it was acquired for a Trinity House Building Cooperative Society. So Malad, that was quashed, and by virtue of case Malad, that the title restored back to the owners of the property way back in 1996 itself. This acquisition is totally different, Malad. It is acquisition by the BDA. Malad 30/10/2012. Yes, 2018 or 8 Malad is the notification. My agreement is prior to this preliminary notification.
ಇದನ್ನ ನಾನು ಇಟ್ಕೊಂಡು ಮಾಡಿದ್ದು ಯಾಕೆ ಅಂದ್ರೆ ಏನಾದ್ರೂ ವಾಪಸ್ ಕೊಡಕ್ಕಾಗತ್ತಾ ಅಂತ ಕೇಳಕ್ ಅಷ್ಟೇನೆ.
Malad, now my respectful submission, Malad, if I take your lordship the provisions of the law, Malad, see I am the person interested.
If it is not possible andre, let it come before the regular court.
Your lordship has already spent considerable amount of time on this.
That I wanted to know whether
Malad,
able for any settlement ಅಂತ ಅಷ್ಟೇ.
100% payment has been made, Malad. Therefore, I stepped into the shoes of the landowner.
ಯಾವಾಗ ಆಗಿದ್ದು?
Yes.
ಯಾವಾಗ 100% payment ಮಾಡಿದ್ದು?
Malad, once the final notification is issued by the Bangalore Development Authority.
Your lordship, 1995 he enters into the agreement.
Yes.
Prior to that, in 1989 itself, the final notification is there.
Yes.
Now, what his contention is that
Because it is set aside, goes to the Supreme
it goes
Court.
to Supreme Court, but when Trinity is set aside, next is the Shivram current layout comes in. So we as owners, after Trinity is quashed, we don't get it back because Shivram current comes in. So now what they seem to think is, in the midst of it, can we sneak in as the
and take compensation.
Yes, and that would probably be permissible because he's trying to say I paid the entire sale consideration. Is not true. If that was the case, sale deeds would have been entered into. Only sale agreements were entered into. So if there is a possibility for him to even claim that he could step into the shoes,
even that happens. Even that happens after the final notification.
Final notification. So in fact, or if any leeway could be given, it is only for those people who are unaware or any of those circumstances, probably some consideration could be given.
Your client has taken the risk of entering into an agreement after the final notification is over.
Yes.
Final notification was issued in favor of Trinity House Building Cooperative Society.
Whosoever it is.
Which was quashed by the Honorable Supreme Court.
You don't worry about that, sir.
Please, Malad.
You have entered into an agreement with the landowners after the landowners have lost the lands.
Yes. It's
They
a
are not-
it's an
one
agreement
second.
void ab initio. So all I'm saying is when the agreement itself cannot
Once the
sustain and
agreement,
doesn't
once
have
the
legal
land
legs to
acquisition
stand on.
proceedings are set aside by this honorable court, the ownership restored back to the
To whom?
owners of the property.
To whom?
To the owners, because
Who are the owners?
who are the present respondents? Malad?
As simple as that.
Like this, that's the reason, Malad. I have seen, kindly see, Malad. The dates.
Your
ಇಷ್ಟೇ ಇರೋದು
lordship,
ಕೇಸು.
at this stage, your lordship to release it would not, your lordship, because we're all.
BDA notification is subsequent to my agreement. Malad. Now we are required to take into consideration section 17 notification issued by the Bangalore Development Authority, which is admittedly.
Sir, even according to you, once everything is set aside, it goes back to the owner.
Yes.
Which we'll see whether it is. They are the owners.
Yes.
Compensation ಈಗ ಅವ್ರಿಗೆ ಬರ್ಬೇಕಾಗಿರೋದು ನಿಮ್ಗಲ್ಲ.
They have entered into an agreement of sale with me. They have received.
That is void because after final notification, just ಈಗ ಒಂದ್ ನಿಮಿಷ ಈ ಕ್ವಾಶ್ ಆಗಿರ್ಲಿಲ್ಲ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ, ಏನಾಗ್ತಾ ಇದೆ?
Malad, if the quash is not made, then Malad, I was required to proceed against him recovering that money, Malad. So now here is a case where doctrine of feeding by estoppel will apply. Once they become the owners of the property.
Feeding by estoppel will see. Yes.
Here is a case that they want to say that they step into the shoes. Actually too big for the shoes.
I'll take, Malad, few
Here
provisions, Malad, if your lordship.
ಅಲ್ಲ ಅವ್ರ ಶೂಸೇ ಇಲ್ಲ, ಯಾವ ಶೂಸ್?
Shoes.
Which shoes are you wanting to step into? No shoes.
And even in that judgment that they say they're only the impleading applicant, Honorable Supreme Court not only holds against Trinity, holds against this impleading applicant, and
question is,
also
my lord,
says in
whether-
3 different acts they do not
Whether
have a
land
right.
acquisition officer,
One nimsha. If I go into all those things, I will be entering into what the apex court has already decided.
my lord, apex court, my lord, may I submit, my lord? Before the apex court, we filed an application for impleading. The Supreme Court rejected our application saying that you have no right to come on record. The reason is, I
ಅದಕ್ಕೆ
am
ಅವ್ರಿಗೆ
not,
ಕೇಳಿದ್ದು ಅಗ್ರಿಮೆಂಟ್ ಮನಿ ಅವತ್ತೇನ್ ತಗೊಂಡಿದ್ರು ವಾಪಸ್ ಕೊಡ್ತಾರ ಅಂತ ಅಷ್ಟೇ. ಅದಕ್ಕೆ ಮಾತ್ರ ಮೆಟ್ಟಿದ್ದ ಬೇರೆ.
they are not interested.
You are not interested. You are very good. No.
My lord, we will argue the case, my lord. Your lordship will
Absolutely,
hear.
sir. Argue the matter.
They have just now argued, Your Lordship.
ಅದ್ರಲ್ಲಿ
I have lot of
Trinity
things to
ಮಾಡ್ಬೇಕಂತ.
argue.
ನೀವು ಒಬ್ರು, ಇನ್ನೊಬ್ರು, 3 ಟ್ರಿನಿಟಿ ಆಯ್ತು. ಇನ್ಯಾರಿದ್ದಾರೆ?
I do not know, my lord.
Your Lordship, our difficulty is none of us are able to seek a
No,
compensation.
no, I'm not going to adjourn it beyond next week.
Please.
Yes, yes. ಯಾವತ್ ಬೇಕು?
Anytime, yeah, convenient to the court, my lord.
December, no December. December, but not second week. List the matter next Friday.
5th, Your Lordship.
I'll give, engage, senior counsel engage ಮಾಡಕ್ಕೆ ಒಂದಿನ ಸಾಕು. ಯಾವಾಗಿದೆ? Sunday. We'll take it next Sunday, after next Sunday. Yes, list the matter on.
Please.
ಅಲ್ಲ 5th, no, December ಇಲ್ಲ.
My lord, when your lordship sitting here, yeah.
That's 5th January.
Mhm. Your Lordship. then-
December.
No, if
Because,
we are ready to argue online, Your Lordship, we don't want any further excuses. That is all we're saying.
They won't take
Please.
any
Don't take- we have not
Are
taken
you in
any
the
time anyway.
idea of taking excuse ಇಲ್ಲ ಅಲ್ಲ?
9th, please.
9th, yes. 9th at 2:30. No excuses, madam.
Your lordships will be hearing,
ನಿಮ್ಗೆ ಎಕ್ಸ್ಕ್ಯೂಸ್ ಬೇಕಾ?
your lordships will be hearing it, Bangalore.
I'll be hearing it. Where ಅಂತ ಗೊತ್ತಿಲ್ಲ.
If it is ideal if court could hear it, Bangalore.
ನಿಮ್ಮ ಆಫೀಸ್ ಚೆನ್ನಾಗಿದೆ ನೆಟ್ವರ್ಕ್. We'll see. 2:30 p.m.
Please.
9.
43.
Appeal for petitioner's fault. Burning of
Correct court,
refugees.
Yes.
January.
This was
January, FTV ಬರ್ತಾರೆ January.
burning of refugees, my lord.
Right. Then
An
interim
entire
order is final order.
Yes, my lord.
Interim order will get executed.
But in fact, my lord, the protest was conducted in front of the police. Lord, despite that, my lord, they registered FIR in the evening. 11 ಗಂಟೆಗೆ
ಯೋಚನೆ ಮಾಡ್ತಾರೆ ಯಾವಾಗ ಮಾಡೋದು.
And half kilometer distance.
Police have to think. ಕೆಲವು ಕೇಸಲ್ಲಿ police think a lot.
And it is their own case that the police were present and they have given security, everything.
I take this. January. Yes.
Interim order.
Interim order subsisting will continue to the next date.
Judgments are then on my place.
ಅವತ್ತು ಬರ್ನಿಂಗ್ ಎಫಿಗೆ ಇದೆ
ಅಲ್ಲ ಅದ್ರದ್ದಿಲ್ಲ. So far as right to protest is concerned, not.
ಆಯ್ತು ಅದನ್ನೆಲ್ಲ 15 ಡಿಸೆಂಬರ್ ಆದ್ಮೇಲೆ ತೀರ್ಮಾನ ಮಾಡಿರ್ತೀವಿ. ಅದು ತಂದ್ಬಿಡಿ ಜೊತೆಗೆ. ಗೊತ್ತಾಯ್ತಲ್ಲ. ಅಲ್ಲಿ heard the learned senior counsel Arun Sham appearing for the petitioner and learned additional SPPB and Jagdish. List the matter on 9th and further hearing January. ಅವತ್ತು ಮುಗಿಸ್ಕೊಂಡು.
54.
Lord, my colleague is not well, my lord. I pray for.
Who is not well?
Dilip Kumar.
It was heard on the last occasion. My lord directed the state to verify if there are any other WhatsApp messages or other communications which was contended by the respondent. In fact, my lords, while in Taiwan, the relationship developed, the respondent who is in Bangalore.
Promised to marry her.
How-
Any date may be fixed, my lord, next
For
week.
what? Marriage?
We'll argue.
Nothing?
In fact,
We'll
our records disclose, my lord, that some of the charge sheet material was placed. The petition, the respondent has fabricated the dates and given to us. And subsequent to filing of charge sheet, we have inquired with the person who issued, and he has given the dates, and they are all
Sir, promised to marry ಇವೇ ಆಗೋದೆಲ್ಲ.
ಇದರಲ್ಲಿ dates ನಾವು ನೋಡಿದ್ರೆ ಇದರಲ್ಲಿ
ಕೊಡಿ charge sheet material ಕೊಡಿ.
the same document has been
Dilip Kumar is not well, so is the case.
same document has been produced, but the dates your lordship may see are different.
Oh, this pregnancy though.
ಹೌದು. Same
Lord,
document.
even WhatsApp messages are there, my lord.
ಸರ್ ಗೂಗಲ್ ಅಲ್ಲಿ ಇಮೇಜ್ ತೆಗೆದ್ಬಿಟ್ಟು ಪ್ರೆಗ್ನೆಂಟ್ ಆಗಿದ್ದೀನಿ ಅಂತ ಅವ್ರಿಗೆ ಹೇಳಿ ಟೆನ್ಷನ್ ಕೊಟ್ಟು ಏನ್ ನಿಮ್ದೆಲ್ಲ you had never
Any
become
date may be fixed, my lord.
you had never become pregnant.
No, she was pregnant.
Was
with somebody else.
Not
No,
with
no, that
him.
is not the case, my lord. That is not the case.
That's what the image speaks about.
ಅವ್ರಿಗೂ
is
ಪ್ರಾಮಿಸ್ ಟು ಮ್ಯಾರಿ ನಾ?
No, ma'am.
The same page,
sir.
page
What is
107 in the compilation. And your lordship may see
ಈಗ
compare the dates.
ಬೇರೆಯವ್ರ ಜೊತೆ ವಾಟ್ಸ್ಆಪ್ ಚಾಟ್ ಇದೆ.
That is not furnished.
What's your name?
Akash, first petitioner.
ಅಂದ್ರೆ ಇಬ್ರು ಇಲ್ಲೇ ಇದ್ದಾರಾ?
ಅಲ್ಲ, the second and third petitioner members are the parents.
ಜಗದೀಶ್ ಇದು ಯಾರ ಜೊತೆ ಇರೋದು ಇದು?
ಅಲ್ಲ, ಅದು ಡೇಟ್ಸ್ ನೋಡಿ, ಡೇಟ್ಸ್ ಆರ್ ಡಿಫರೆಂಟ್ ಮೇಲೆ ಟೈಮ್ ಇಸ್ ದ ಸೇಮ್. ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ ನಮ್ಗೆ ಐವೋ ಕೊಡ್ಬೇಕಾದ್ರೆ ದೇ ರಿಮೂವ್ ದ ಡೇಟ್. I marked it in the first page itself, that scan image.
Oh, you had an affair prior to this also?
No, my lord.
ಮತ್ತೇನ್
No,
ಅಲ್ಲೇ
no.
ಇರೋದು?
Even while objecting to the bail, this document was given by correcting the date. When we have produced the same document.
What is this you have said? ಯಾರಿಗೂ ಇನ್ನ ಬಿಟ್ಟು ಎಲ್ಲೂ ಹೋಗಲ್ಲ.
ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಇರೋ ಡೇಟ್, ಸ್ಕ್ಯಾನ್ ಅಲ್ಲಿ ಡೇಟ್ ನೋಡಿದ್ರೆ the date is different.
I'll argue, my lord, next week, any date, my lord.
ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ ಮಾಡಿ.
Judgment.
List the matter on 5th January 2026. Made clear at the request of the council appearing for the respondent. It is made clear no further adjournment would be granted in the matter.
Just a few additional citations. Subsequent to my lord's several judgments.
ಹೌದಾ?
25. 2025, all of them, of the Honorable Supreme Court. And my lord's latest judgment is October 2025, my lord, Sampras Antony on that. I'm not produced.
Empress Antony ಆದ್ಮೇಲೆ ಇದೆ.
Subsequent, I'm not sure. Sampras Antony is the last.
ನೀವು ಯಾವ್ದು? ಅಮೋಲ್ ಭಗವಾ.
ಅದ್ ನೋಡಿ.
Which is the apex court judgment you are wanting to give?
No, that Jyoti Raghavan ಒಂದು.
ಅದು ಹಳೇದಾಯ್ತು.
ಅದಾದ ನಂತರ my lord's 3 more. In one of the judgment, the Honorable Supreme Court says it has become a trend now. Adide.
1230.
That is 2025 minutes.
SSC online SC 1230.
That also is there.
ಆಮೇಲೆ
In addition to that, Biswajit Chatterjee 2025. Batlanke Keshav again 2025 minutes. Amol Bhagwan, that's also produced.
All right.
In fact, in Amol Bhagwan minutes, in Batlanke, the Honorable Supreme Court observes the reason for the breaking of the relationship is there was a panic.
ಇದರಲ್ಲೇನು ಬ್ರೇಕಪ್ ಆಗಿಲ್ಲ ಬಿಡಿ.
Subsequently, there was a.
The tests are all done in 2021.
ಡೇಟ್ ಚೇಂಜ್ ಮಾಡಿ ಆಮೇಲೆ ಕೊಟ್ಟಿರೋದು.
I have now
ಯಾರ್ದೋ ಜೊತೆ ಟೆಸ್ಟ್ ಮಾಡಿ ಪ್ರೆಗ್ನೆಂಟ್ ಆಗಿದ್ದೀನಿ.
I'll make the farm also, my lord. I've placed the farm also.
Ten 2021.
My lord, we'll make submissions.
not even
but
met him.
I have answer for all those, my lord, but I'm not supposed to make.
Okay. You can answer. 5th January.
Interim orders.
Interim order subsisting will continue till the disposal of the petition. ಅವತ್ತು ಮುಗಿಸ್ಬಿಡಿ ದಿಲೀಪ್ ಕುಮಾರ್. Yes, next.
45.
ಎಲ್ಲಿ ಶಬಾಸ್ ಹುಸೇನ್? No, is this at? Where's the other one? I've reserved one matter in Dharwad. Okay, I wanted it, Shabas. No. There's one more here. Is this anything to do with that policy?
This was a policy matter.
Allu.
Was on 15/9/2025, stated as further hearing. Not a special order, it's a further hearing. One of the batch, there is a special order before your lordship.
ಯಾವುದು ಮೊನ್ನೆ ಯಾವುದು JSP green ಅಂತ ಇದೆ.
I'm not too sure which other. I just saw in the cause list my lord that there is. In one of the writ petitions, there's a special order. 45.5. 45.5.
I will de-link all the other ones because if chief judges are ordered specially,
Please.
one in matra care.
And that can be heard
They are
separately
all in a
because.
common
issue.
No, why is that? Unless there is a special order, why should I?
Because association matters are separate. That
ಗೊತ್ತಿಲ್ಲ. Anyway, there is one ರಲ್ಲಿ ಯಾವ್ದೋ 2799
can be heard
special order ಇದೆ.
That can be heard. ಅದು ಬಿಟ್ಟು ಬೇರೆದೆಲ್ಲ ಡಿಲಿಂಕ್ ಮಾಡಿ.
ಆಯ್ತು.
No, but
ತೊಂದ್ರೆ ಇಲ್ಲ.
I am told the issue in all are the same.
ಇದು ಗೊತ್ತಿಲ್ಲ. Now the learned additional advocate general says that it was not heard by special order. It came.
If my learned friend can say
No,
that they are
actually
not the
what
same
happened
issue.
was this was heard, ಯಾವ್ದು this 27996. While hearing that, this came as special order only. Then these were tagged to that.
That's right. Because it's the exact same issue.
Maybe.
We are not the exact same issue. No, I don't remember having.
No,
No, the reason I'm saying it's the same issue is my learned friend and I were discussing. It is in fact the same issue.
That's all right, but no, when he says that, not. The learned additional advocate general submits that the other matters, 45.1 to 45.6 were never heard, for it to be treated as parted or for further hearing. The what was heard was only 45, and that is posted before this court by way of special orders on 25/7/2025. In that light, dealing all the other matters, serial number 45 will list it on application.
Please.
The serial number 45 list on 9th January.
Great.
Yes. Shall I?
Yes.
Only difficulty, Your Lordship, I am applying 45.1. The difficulty is in all of these that policy is under challenge.
I don't know, sir. The additional advocate general says so, so I am doing it.
Honestly, I did not realize it's in the further hearing list. I'm not saying that, but can the court master just verify that if there is a
45.5, I think.
No.
Because the lordships are kind enough to see the cause 45 list.
ಇಲ್ಲ ಇರೋದು ಯಾವ್ದ್ರಲ್ಲಿದೆ ನೋಡಿ ಮೇಡಮ್ 45.5 ಯಾವ್ದು ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಇದೆ ಅದು ಬಿಟ್ಟು ಮಿಕ್ಕಿದೆಲ್ಲ ಡಿಲೀಟ್ ಯಾವ್ದ್ರಲ್ಲಿದೆ ಗೊತ್ತಿಲ್ಲ ವಾಟ್ ಇನ್ ವಿಚ್ ಎವರ್ ಇಸ್ ದೇರ್ whichever matter special order ಇದೆ ಅದು ಮಾತ್ರ.
Is grateful. But it appears from what I'm told, after the special order is passed, the others have been tagged along. That's what seems to happen. Anyway.
So special order I can't say take it off because
No, of
order by
course.
Chief Justice, so I have kept it, that's all.
But we'll have to. But if the issue is common, we'll just bring that to the attention.
Whatever.
But would your lordships, you kind of extend the interim orders in all the other cases. If your lordships are adjourning.
Interim orders ಇದೆಯಲ್ಲ
Existing
interim order
interim orders?
subsisting in all these cases shall stand extended.
Yeah.
Why is Patil sir waiting?
It's for this matter only is applying for credit for summer.
Respondent.
Respondent. We are sailing together.
All right. List on ಇದೊಂದು ಮಾತ್ರ whichever is special order ಅದು ಮಾತ್ರ list on 9th January.
Please. Remaining matter. Grateful.
Interim order subsisting will continue to the next date of hearing. Yes, sir.
Grateful.
In the other cases, Your Lordship, some date is being indicated.
Sorry?
Or it will come up? In the other cases which are.
No, it will come up before the regular court, sir.
Very good.
Yes, yes.
Good. 46.
My lord, kindly see, my lord, the order passed by this court. My lord, it is at annexure, my lord. Order dated 1/7, your lordship. Page 217, my lord. Page.
First matter. Sir, okay. Yes.
Yes, this is, my lord, CBI investigating the matter.
Yes.
Yes, my lord. Kindly see, my lord, page 217, my lord. This was the order on 1/7/25 it was passed. My lord, on the basis of status report submitted by CBI counsel. My lord, here it was brought to lordship's kind notice by virtue of the status report that some other department fund has been diverted. Therefore, expansion of investigation area to that department is also required, and this honorable court permitted it. My lord, kindly see the FIR, my lord, in this case. My lord, the FIR registered is at page 150, your lordship. Relevant page, my lord. Kindly page 161, my lord.
Yes, sir.
This is the FIR registered by CBI for investigation. My lord, the matter is at relevant page 167, my lord. 167 Roman 14, your lordship.
Yes, sir.
From the aforesaid, it is clear that some unknown persons have played fraud in the aforesaid illegal transfer of money from the account of the corporation and misappropriate the funds with the intent to cheat and defraud the bank of public money amounting to rupees 89.63 crores. Accused forged the valuable securities and other documents for the purpose of cheating. In the meantime, an amount of rupees 5 lakh crores has been recovered, and the remaining 84.63 crores remain to be recovered. The role of other public servants in the whole fraud committed as above, in collusion with the accused persons and unknown private persons, cannot be ruled out and can be ascertained after thorough investigation.
Sorry, yes. There's some confusion about the previous matter.
Yes, my lord, not that, my lord, not. Lordship, may kindly this 167, my lord.
I am there, sir.
Fund diverted, my lord, is 89.63 crores, my lord, from Union Bank of India. My lord, regarding this, my lord, complaint was lodged. FIR was registered by High Grounds Police. My lord, state government had constituted a SIT, my lord, they investigated, filed the charge sheet also. This petitioner, my lord, was accused number 12 in that charge sheet. As per the investigation of CAD SIT, my lord, no fund has come to the account of this petitioner. My lord, now this CBI registered this FIR only in respect of bank officials. My lord, this FIR, my lord, what I brought to your lordship's kind notice at page 167, though it pertains to the same amount of 89.63 crores. My lord, it is in respect of bank officials. My lord, now the relevancy is, your lordship, kindly. First page of FIR, my lord, at page 157, the period of occurrence, what it is shown, my lord, is 21/2/24 to 6/5/2024.
So what is your suggestion by reading
It
this?
is, your lordship, that, my lord, once the FIR is registered for this offence, entitled to investigate. My lord, now they are investigating in respect of some money which has come to the petitioner's account from somebody. They cannot investigate that aspect. My lord, the subject matter of offence is in respect of amount being misappropriated from Union Bank of India to the extent of my lord, 89.63 crores. My lord, FIR was registered for that offense. My lord, their investigation cannot cross over this FIR allegation. If at all, my lord, if any new offense said to have been discovered by virtue of or in the course of this investigation, my lord, they have to register separate FIR. My lord, here, my lord, the status report as per your lordship's order, my lord, what the CBI submitted report is, my lord, page 221, my lord. 221, what it says, further the investigation has revealed paragraph 6, your lordship, that.
Yes, sir.
My lord, further the investigation has revealed additional.
This is the
instances
status
of
report.
Yes, my lord. This is on the basis of status report, your lordship permitted them to investigate. My lord, these two items, your lordship, a sum of rupees 95 lakhs was siphoned off from the account of Karnataka German Technical Training Institute maintained at Canara Bank, Bangalore, and transferred to the account of accused Nekunti Nagaraj through intermediary accounts. This is one instance, your lordship. Lord, next is an amount of 2.17 crores belonging to Scheduled Tribes Welfare Department was diverted from another account of Karnataka, Maharishi, Valmiki, etc., maintained with the Bank of Baroda, Siddhaya Road branch, Bangalore, routed to accused Nekunti Nagaraj. My lord, these two accounts, my lord, 95 lakhs, 2.17, my lord, is the account of private person. It's not, my lord, amount is routed from this Valmiki Nigam's amount. It is the amount, my lord, which has come from the private person. My lord, this is nothing to do with the allegations made in the FIR. Even at the worst, my lord, if any such diversion has taken place, my lord, mere diversion is not that. An offense should have taken place. My lord, in such a case, my lord, they must register a separate FIR for the offense, because if a distinct offense has happened, they must commence independent investigation, not investigation with this FIR. They cannot cross over to the other department. My lord, the permission granted, my lord, is almost to interfering with the liberty of a person without there being an FIR and accusation. Particularly, my lord, that if an FIR is registered, my lord, they can, my lord, challenge the FIR on what basis it is. First, my lord, is important is happening of offense. Offense must occur, for which there shall be an FIR. My lord, FIR follows, my lord, investigation. If here, my lord, there is no FIR for these two departments, and first of all, my lord, these two departments have not lodged a complaint at all, and there is no misappropriation, no diversion of fund. My lord, the CBI has ascertained, my lord, the bank account of this petitioner shows the 2.17 amount has come from, my lord, SKR infrastructure and Golden Establishment. The two accounts, my lord, those accounts, my lord, have produced, your lordship. At page 226, my lord, this amount has come from them. As a loan transaction, this petitioner has shown in his income tax account. My lord, it is not a misappropriation amount, it is. It is a legal amount that has come to the account of petitioner. And my lord, he has answered, my lord, in his income tax returns. He has paid, my lord, income tax for that. My lord, when there is no illegality, my lord, the CBI cannot investigate this subject matter at all. My lord, therefore, the permission granted, my lord, is, my lord, beyond the scope of FIR.
Permission granted by this court.
By this court is required to be recalled or modified. That is our prayer in the application. Well, for this, my lord, I relay one of the decision of this court. My lord, and this has been upheld, my lord, by the Supreme Court.
Viren Khanna.
Yes, Viren Khanna. My lord, kindly go to paragraph 10, my lord, last paragraph 10, my lord. So happens that many a time the past incidents of crime will be detected when investigation is undertaken in connection with some other case. Whenever past crimes committed by the same person came to light, nothing prevents the police from registering separate FIR for every distinct offence detected and filing a separate charge sheet if all those offences cannot be tried jointly in accordance with section 219 of CRPC. In this case, as the charge sheet shows, the petitioner's involvement is there right from 2015. If the FIR number 109 is in connection with offences said to have been committed between 11/4/2020 and 4/9/2020, the petitioner cannot be tried for the earlier offences of the years 2015, 2018 and 2019 in view of section 219 of CRPC. It was necessary for the police to have registered separate FIRs for those past offences and filed separate charge sheets after investigation.
Yes.
Hello, I brought to Lordship's kind notice here the page number, the FIR melody is period of FIR is very relevant to Lordship. Page 157 melody. 21 to 24 to 6/5/24. 21/5/24 to 6/5/24 is the period of offence melody. Page 157 FIR. And subject matter of offence melody is regarding transfer of fund melody from the bank account of Valmiki Nigam to the extent of melody 89.63. These two transactions melody have nothing to do with the alleged FIR. Melody, if at all, if they had discovered something melody diversion of fund, melody it is melody a distinct transaction. They cannot investigate under this FIR. Well, they can submit a report to the jurisdictional police. If at all, if they have discovered new offence or a distinct offence, then my lord, that they have no authority to investigate or continue investigation along with
Separate
this.
FIR had to be.
Separate FIR is required to be registered. My lord, without being considering this, my lord, this honorable court permitted them, and they have, my lord, gone beyond the scope of this investigation. They have searched. My lord, kindly see, my lord, search warrants, my lord, that different persons, relatives, not only the person is not accused of an offence. My lord, their involvement is not shown, but they goes on searching wherever it is possible. And my lord, they have seized the cars, they have seized the personal belongings of the accused persons, and my lord, they are forced to approach the trial court for release of the vehicles, release of the properties. My lord, this is, my lord, that they have encroached, my lord, that the investigation beyond the scope of the FIR, which is not permissible as per law. My lord, one of the example your lordship may kindly see, we have produced one document to show how they have crossed over the investigation. The Panchanama is drawn, my lord, that at page 261, your lordship, page 261, well, a vehicle of one N. Ravi Kumar, son of late Krishnamurti, is seized. Well, this is, well, they have given a tabulation, Lordship may kindly see, page 262, 6324, 9 lakh rupees from Axis Bank, it has gone to Ravi Kumar. He is not the accused at all in the entire, even by SIT, CID, SIT also, and my lord, by CBI also. Well, similarly, Lordship may kindly see, one Yashwant Chaudhary, 25 lakhs which was transferred from the account. Melody, this Axis Bank account, melody, it belongs to private persons. It is not, melody, the account of the government. The amount has not come from the government department or department of KGTTI, what they are alleging. These are all the accounts you Lordship may kindly see. Account of bank, melody, Axis Bank, HDFC Bank. These amounts have come from private person. Melody, private persons, melody, they have given to this Ravi Kumar, Yashwant Chaudhary, and B. Raghavendra, and another N. Ravi Kumar. Totally to the extent, my lord, it is 77 lakhs. Different persons have received. All these persons, my lord, are subjected for interrogation. They are not named as an accused. My lord, they have been issued section 35(3) notice repeatedly, repeated phone calls. They are going to their houses, harassing even ladies also. My lord, this is, my lord, beyond the scope of investigation power. Therefore, it requires, my lord, this they are doing it because of the order passed by this honorable court on 1/7, my lord, 25. Therefore, I pray, my lord, that this order dated 1/7/2025.
So if that is recalled, everything goes.
Yes, my lord, it is, that is our prayer. And therefore, the pleading and the application is to be considered. My lord, the main prayer in the writ petition, my lord, that is to speed up the investigation and trial, not in respect of this. The petitioners have not sought for anything with this. Prayer is not there. When the status report was called for by this honorable court, CBI have submitted some status report. We are investigating on this direction also. Kindly direct the other department to assist. This is, my lord, that beyond the limit of the FIR offence or the subject matter of offence. They cannot cross over, they cannot encroach to the other limits at all. With this, my lord, I pray
But where
that
has, no, you are not a witness. You are not an accused.
accused, my lord, that accused.
You are an accused.
Accused, my lord, charge sheeted, already charge sheeted.
All right, then what that accused?
Not in this, your lordship, may kindly.
What I'm asking,
Lord,
not in this, in something else.
But lordship, may kindly see, he is an accused in the subject matter of offence. My lord, in this offence, my lord, he has been accused of, he has been charge sheeted, he has been arrested. My lord, ED also has arrested him. My lord, he has been dealt twice by two departments already in respect of same FIR. Now CBI, my lord, your lordship did not permit it. Your lordship's order is also there. My lord, a detailed order is passed. My lord, the CBI was not given an authority to take up the investigation from the hand of SIT or CID in respect of this. My lord, therefore, their limited jurisdiction to investigate is under the Banking Regulation Act. The CBI can investigate. There is no consent of the state government for them to take up this investigation itself.
State government is not involved in this.
Please, your lordship.
State government is not involved in this.
Well, it is the subject matter of state, my lord. It is the subject matter.
That is a larger question.
Lord, your lordship.
That you cannot contend in this petition.
Lord, I am
ನಿಮ್ದು
not-
ತೊಂದರೆ ಆಗ್ತಾ ಇದೆ ಹೇಳಿ, ನೀವು will consider.
Yes, yes, that is
ಅಷ್ಟೇ,
what
that's
my
all.
lord,
Whether
your
CBI
lordship-
can do it or not is
Lord,
a
in
different.
this, the FIR, my lord, is limited against bank officials.
That we'll see.
My lord, only
If
against them.
FIR is limited against bank officials,
this
charge
petition-
sheet also should not be limited against bank officials only. It's an investigation.
Lord, investigation should be limited to this offence. My lord, your lordship, kindly, this is the strong contention that we have taken it. My lord, they cannot go beyond the scope of FIR. My lord, offence is alleged. My lord, if any
No,
other offence is there,
no, that's all right.
there is no bar, my lord, for registration of another FIR investigation. My lord, once FIR is registered, the accused will come to know that he has been accused of an offence in a particular FIR. My lord, he is entitled to challenge even the FIR or the investigation it is. My lord, the purpose, my lord, that Supreme Court in 2011, my lord, put that FIR should be put online because the citizen or the accused person has been put in notice. They can challenge it.
No
My lord,
problem.
without there being an FIR going, my lord, wherever they require, my lord, this is, my lord, beyond the scope of authority. They cannot investigate beyond the scope of this FIR. Kindly appreciate this, my lord. This has encroached to the life and liberty of many persons. My lord, let them register. We will also get an authority and my lord, a right to challenge that FIR. If at all, if any offence is committed, no one is.
So in the garb of investigation, they should not come to you.
Investigation should be limited to this FIR, your lordship, that let them commence another investigation by registering FIR.
Concerning this FIR, we should hold their hands, don't investigate this, don't investigate this.
My lord,
That is your suggestion.
I made clear to your lordship that. what
Correct,
the-
you
my
made
lord,
clear, see,
Yes, what
even now, an offence is committed by X. Crime is registered. During the investigation, they find, yes, we will have to inquire into Y and Z also, saying that there is some link with them. X has some link with them or otherwise. No.
That is different, your lordship.
No, 1 minute. That is done. So you're suggesting that if Y and Z will have to be investigated into, they have to register separate crime against Y and Z?
No, I have not submitted
But,
like
sir.
that. Your lordship, kindly follow my argument, my lord. My lord,
That is exactly, you're
no,
telling,
not like that.
in the garb of
I
this
did not
order
submit-
of committing investigation, of directing investigation, they are coming and harassing, they're doing that, they're doing this.
My lord, sorry, that my argument is not like that.
Then what, sir?
Lord, my argument is, my lord, for every offence, investigation can be started only by FIR.
No qualm about that at
Yes,
all,
yes,
sir.
that
No
is what
qualm about that.
my argument is.
There is no offence committed by you yet. They are investigating into another offense where your investigation against you also is needed. Not investigation, at least the.
No, this is what, my lord, power of investigation arises by registration of FIR for a particular offense.
So you mean to say now against X it is registered. So the investigation, if you have to investigate another, you will have to register another FIR.
For a different offense, your lordship, kindly appreciate this.
Different offense, yes. What you say is different offense, it should be different FIR.
Yes, that is what, my lord, I am saying here. Karnataka German Training Institute from KGTTI, Canara Bank account, my lord, from this department 95 lakhs has gone. This is a separate department. This is nothing to do with Valmiki Nigam's amount of 94.63. My lord, 90 out of 94, my lord, entire amount is recovered by SIT.
That's a different thing. That is a different thing where they are that bank officials are being investigated.
Yes,
Leave
yes.
it.
Well,
No problem.
To know the real truth, my lord, in respect of bank officials is concerned, my lord, this petitioner can be interrogated.
That is all they are doing now.
No, not like that.
What
your
are they
lordship.
doing?
No, this two department, my lord, is nothing to do with this department, your lordship. My lord, this is totally a different offense it is. My lord, here, your lordship, may kindly see, your lordship order is very clear, 221, and their status report is clear. Amount of 2.17 crores belonging to Scheduled Tribes Welfare Department was diverted from another account of so and so. This is a different offense. If different offense has occurred, my lord, the department or whoever it may be, my lord, they can set the law into motion. Let them register FIR, start investigation independently. My lord, whether CBI has an authority in respect to state subject, this is what, my lord, that this KGTTA is a state subject it is. And this Scheduled Tribes Welfare Department is a state subject. My lord, not involvement of any bank officials. My lord, they cannot come to this state subject and investigate this matter. This is another hurdle it is. Apart from registration of FIR. My lord, registration of FIR for every distinct offense is mandatory. They cannot club, my lord, registering one FIR. Distinct and different offences cannot be investigated in one FIR it is, which is barred by Section 218 of the Code of Criminal Procedure. There shall be separate investigation, separate charge, separate trial for every distinct offense. This is, my lord, it is the protection which is the accused is entitled for, any person is entitled for.
All right.
Even
Yes.
involved in the commission of the FIR.
We'll answer it.
Please.
Lords, may I be permitted?
You are not well, sir.
And my lord,
Yes. Lords, no,
added
may
to
I-
this, your lordship, that I relate two decisions, my lord, that Lalita Kumari's case and Vinay Tyagi's case. What is, my lord, the three concepts of investigation? Well, initial investigation, further investigation, fresh investigation. What, my lord, it is defined in Vinay Tyagi's case. My lord, it is the investigation which are doing is initial investigation in respect of a particular FIR. My lord, that they have to investigate in respect of it. Lalita Kumari's case, my lord, paragraph 86, my lord, it is said that for every distinct offense, there shall be an FIR, which is the protection granted under Article 21 of the Constitution. Without that, my lord, they cannot investigate it. They cannot enclose somebody's house on the guise of registering some FIR and all this. With this, my lord, the strict principle of criminal law has to be followed. Otherwise, my lord, it is violation of Article 21 of the Constitution.
Yes, yes.
My lords, may I say this, my lords?
Wait, sir.
Please.
Lord, your lordship's order, which is now sought to be recalled. Lord, CBI files a status report saying that the money which is found in the proposed applicant's account is intrinsically connected to the Valmiki Corporation funds. Now today, my lords, we cannot decide the question of fact on the explanation sought to be given by the learned senior, saying that this money has come as a loan, I have declared in the income tax. Ultimately, my lord, the facts are hazy. They are not clear. So ultimately, we should allow it to go to the logical conclusion by filing a report. If at all a report goes against him, then my lords, he may have another round of litigation to question it, whether it is a double jeopardy, parallel investigation, all those things. Secondly, my lord, the complaint itself would say that, my lord, there are private individuals who are involved in this entire transaction. So, my lord, he cannot today say that, no, I am not involved, I have been already investigated and all those things. My lord, FIR is not an encyclopedia, my lord. It is a money trial. It's a money trail, my lords, which leads to different doorsteps, which CBI is now presently doing. So therefore, my lords, too premature, and he is not a proper and necessary party in my writ petition. No order is passed against him, saying that he should be made an accused or he should be taken to the task. My lords, an example is sought to be given that for every offense, my lords, a separate FIR and trial. My lord, a murder take place, somebody else will dispose of the body, somebody else will hide the weapons. My lord, whether they were part of same transaction, whether they were part of same conspiracy is a test. Now to say that, my lords, for a single murder and disappearance of body and disclosure, destruction of some other MOs, my lord, if separate FIR is sought to be registered, then my lord, this is something which is unheard of. So therefore, my lord's submission is that first of all, his application is not maintainable in merit. Secondly, it is too premature if he has got any grievance, my lord, he can explore his remedies somewhere else, not to come and, my lords, cause an obstruction in my writ petition. My lord, I'll pass on the few judgments. Paragraph 20, my lords, 2003-6 SCC, page 175. My lord, this is Superintendent of Police versus Tapas Kumar Singh. Of course, it relates to PC Act, my lord, where a general diary entry was made. Paragraph 20, your lordship would kindly take.
Yes.
It is, your lordship says.
Yes.
That's at page 183. It is well settled that first information report is not an encyclopedia which must disclose all the facts, details relating to the offense reported. An informant may lodge a report about the commission of an offense, though he may not know the name of the victim or assailant. He may not even know the occurrence took place. A first informant need not necessarily be an eyewitness so as to able to disclose in great detail all the aspects of the offense committed. What is the significance is that information must disclose the commission of a cognizable offense, and information so large must provide a basis for police officer to suspect the commission of a cognizable offense. At this stage, it is enough if the commission of cognizable offense, not that he must be convinced or satisfied that a cognizable offense has been committed. If for the reasons to suspect on the basis of information received a cognizable offense has been committed, he is bound to record information, conduct investigation. At this stage, it is not necessary for him to satisfy himself about the truthfulness of the information. It is only after completion of investigation he may able to file a report on the truthfulness or otherwise of the information. Similarly, if the information, Lord, this is very basic. So
too rudimentary.
Yes. Yes. So therefore, the question of, my lords, these are the cases, my lords, unlike the assault cases where the eyewitnesses are there. My lord, the veracity of FIR and all those things can be gone into. This is a, my lords, financial fraud. My lord, they will dig out the evidence. They will go to the doorstep of a person, whoever is involved. So therefore, my lords, first of all, the application itself is misconceived. When CBI says they are intrinsically connected, today, my lords, we cannot ask them that how we can intrinsically connected. It is for them to establish by filing an appropriate report. So therefore, my lord, the application has to be rejected.
Yes, Rahul, anything?
My lords, firstly, I would like to file my objections both on maintainability, my lords, of his application. My lords, this writ petition is called for speedy disposal of the investigation at the hands of CBI. My lords, Aman Kumar Singh has clearly said that one, the accused does not have a right, one, to choose investigation agency, two, that how the investigation has to proceed. Lords, the position of law is pretty well settled that it is not the say of the accused to restrict the scope or enhance the scope of an investigation. Lords, 154, if your lordship sees, is offence specific. It is not offender specific. Lords, the submission of the learned senior counsel is that only after I am named in an FIR, that investigation should commence against me. Lord, it is not so. If your lordship sees 154, if your lordship sees Lalita Kumari as well, it only says about pursuant to the disclosure of a cognizable offence, the officer in charge of a police station has to reduce incentive.
One judgment
reserved on the application.
Two lines I'll just read and
one clarification. The entire contention of petitioner in this is, Lord, out of this amount, my lord, of
last
Valmiki,
2 lines, lordship.
my lord,
Sorry.
Valmiki amount, if it had, my lord, which was misappropriated, for which FIR is registered. Even a pi, my lord, if it had come to this petitioner, or to any of those persons, my lord, who are named in that seizure concern, my lord, they can investigate. But not, my lord, in respect of other department it is. That department, that transaction, my lord, no complaint is lodged by the department. And when there being no FIR, my lord, that we have produced the account details, my lord, to show that whatever the transaction, it was legal transaction. My lord, taking up that itself, this amount, how it has come, goes on searching for it. My lord, when the report of CID we have produced, my lord, SIT report, each and every pie, my lord, they have traced, my lord, where it has gone. No amount has gone to the account of this petition.
Will answer.
Milords, may I be given the liberty to file my objections and my compilation, Milords?
ನೀವು ಮಾಡ್ತಾನೆ ಇರಿ ಸರ್. Yes. Next.
Grateful.
47, 48, and 49.
Your Lordship, the senior counsel will be making submissions on a different date if that's fine.
It's okay, I'll start. I'll finish in 15 minutes. So, the issue is fairly simple.
There's a meeting at 4:45. It's fine. We'll take it another day. Monday or Tuesday, whenever you want.
Any date is fine.
We'll take it at
Not on Monday, no.
We'll take it on at 2:30 Wednesday.
Wednesday 2:30 in Dharwad, no?
Yes, you can appear online. Sorry.
Yes, please.
Wednesday, we'll take it at 2:30. It's online.
50.
Your Lordship, the matter is posted for our reply. We are led by senior counsel, Your Lordship. May it be had on Monday, Your Lordship will.
My lord, just one submission, my lords. I finished my submissions, my lords, in October, 24th of October. This is on, my lords, contractual dispute that there is an admission.
Lordship, he is engaged in Kotal 1 in bike taxi. The answer.
The answer is appearing. Same Wednesday, we'll take it then.
My lords, then may I request, my lords, any day other than
Online.
Wednesday?
Thursday, when.
Thursday, this Monday, Wednesday, or Friday, he is requested.
Alternate days. All right, Friday.
Grateful.
Our alternate days matra vacant.
Grateful, my lords.
Grateful. Heard the learned senior counsel Sergeant Poya appearing for the petitioner. Learned senior counsel submits that he had completed his submissions on October the 24th, 2025 itself. What is awaiting is the reply from the hands of the respondent. List the matter on Friday, 5th December at 2:30 p.m.
Grateful.
Please.
Yes.
Good.
51.
Black magic.
Yes, Police. Bank lockers, 2 lockers have been seized by the
Jagdish sir,
state.
ನೆನ್ನೆ ನೀವು ಇರ್ಲಿಲ್ಲ. The black magic ಅಲ್ಲಿ ಸಿಗ್ತಾ ಇಲ್ವಂತೆ ಲಾಕರ್ಸ್ ಅಲ್ಲಿ ಏನಿದೆ ಅಂತ. So you have to help now.
At the time of Mazar, what he had done is bank locker open ಮಾಡಿ use ಮಾಡಿ ವಾಪಸ್ ಬಂದು ಡೈನಿಂಗ್ ಟೇಬಲ್ ಮೇಲೆ ಇಟ್ಟಿದ್ದಾರೆ. So I worked out ಬಂದು she has called the bank people. So what he has done is he has opened a new fresh locker. ಒಂದೇ ಲಾಕರ್ ಇದ್ದಿದ್ದು ಡೇಟ್ ಆಫ್ ಸಪರೇಷನ್ ಟೈಮ್ ಅಲ್ಲಿ. ಬಟ್ ಆಫ್ಟರ್ ಪ್ರಿಲಿಮಿನರಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ನೋಟಿಸ್ ತಗೊಂಡಿದ ತಕ್ಷಣ ಇಮಿಡಿಯೇಟ್ಲಿ ಸೇಮ್ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಇನ್ನೊಂದು ಲಾಕರ್ ತಗೊಂಡು ಅಲ್ಲಿ ಶಿಫ್ಟ್ ಮಾಡಿದ್ದಾನೆ. ಬಟ್ ಅಲ್ಲಿ ಏನ್ ಮಿಸ್ಟೇಕ್ ಮಾಡಿದಾನೆ, ಜಾಯಿಂಟ್ ಲಾಕರ್ಸ್ ಮಾಡಿದಾನೆ. ಸೊ ನಾವು ಒಂದ್ ಲಾಕರ್ ಕೇಳಿದ್ವಿ 189, ಬಟ್ ಬ್ಯಾಂಕ್ ಅವರು ಈಗ ಹೊಸ ಲಾಕ್ ಓಪನ್ ಮಾಡಿದಾನೆ ನಿನ್ನೆ ಅಂತ ಅನ್ಬಿಟ್ಟು 79 ಬಗ್ಗೆನೂ ಹೇಳಿ.
ಬ್ಲಾಕ್ ಮ್ಯಾಜಿಕ್.
ಒಂದು ರೆಪ್ರೆಸೆಂಟೇಷನ್
ಲಾಕ್ ಓಪನ್ ಆಗ್ತಾ ಇಲ್ವಾ?
ಇಲ್ಲ, at your lordship hands, my lords. Some magic.
Black magic ಅಲ್ಲಿ ಲಾಕ್ ಓಪನ್ ಆಗ್ತಾ ಇಲ್ಲ.
Yes, my lords. 6 years 22,000 judgment ಅಲ್ಲಿ ಇದೊಂದು ಬ್ಲಾಕ್ ಮ್ಯಾಜಿಕ್.
Oh, correct. ಅದೇ.
ಡಿಸ್ಪೋಸಲ್ ಇದೊಂದು ಡಿಸ್ಪೋಸಲ್
ಸ್ವಲ್ಪ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಇನ್ನು.
Yes, my lords. ನೆನ್ನೆ
given representation, my lord, will ask them to.
My lords, have given the representation.
ಕೊಟ್ಟಾಗಿದೆ ಬ್ಯಾಂಕ್ ಗೆ. ನಾ ಹೇಳ್ದೆ
ಅಲ್ಲ
ಐವೋಗ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಯಾಕೆ ವಿಲ್ ಪಾಸ್ an order.
No, my lords, have given representation.
No, we will direct him to do something. Yes. The petitioner is before this court on the score that the bank is not permitting the petitioner to operate the bank locker on the score that the investigation or charge sheet agilala. The investigation charge sheet is pending. The trial in the charge sheet is pending, which relates to the bank lockers. In the bank, the learned counsel of the petitioner submits that the officials of the bank have communicated that if the investigating officer would direct the locker to be permitted to be operated, it would be done. The learned additional SPP therefore to secure instructions after directing the investigating officer to do the needful, list the matter on 5th January.
Obliged.
52.
ಒಂಬತ್ತು ದೇವದಾಸ್ ಸರ್ ಬಂದ್ಮೇಲೆ ತಗೊಂತೀನಿ. 9ನೇ ತಾರೀಕು ಬೆಟರ್. 9th. Yes.
53.
53, 54 reserved. Yes.
55.
Let's appear in 55 minutes.
I have shown to your lordships, my lord, the order
Locus.
passed by.
No, I'm only on locus now.
Locus, and I have shown to your lordships, my lord, the order passed by a coordinate bench of this court. Considering your lordship's earlier order and the order passed by the division bench.
Yes, Poya sir.
Yes, please, my lords. My lords, I appear, my lords, in 55.1. My lords, on the locus issue, my lords, would your lordships permit me to just show 3 paragraphs? And my lords, dispel the myth that the situation that was submitted to your lordships is that
Who
there
appears in
was.
the KIDB? Where is? Ask him to come. Yes. Yes, sir.
Yes, please, my lords. My lords, the impression that was sought to be created, my lords, in this court was that there was a petition in the first round of proceedings. There was, my lords, a demonstration of locus, and that finding now stands reversed by a subsequent order, my lords, pertaining to a subsequent set of events. And consequently, my lords, we do not have locus to raise the dispute before your lordships in the present petition. I am keeping, my lords, the merits of this matter aside. Just on the issue of locus, my lords, would your lordships permit me to just show 3 paragraphs, my lords, of the previous orders, and then, my lords, take your lordships to what the subsequent order was. Please come to, my lords, the order that was passed, my lords, in writ petition 18986. Your lordships will find that, my lords, it annexure F. Would your lordships permit me to straight away invite my lord's kind attention to paragraph number 19, my lords, at 178?
Yes.
My lords, I stop at 19 before I read 19, my lords. The factual matrix was that there was a property worth, my lords, today in my assessment, my lords, just in terms of modest assessment, it is 5,000 crores. That a property worth 5,000 crores, which was leased, and the leaseholder had, my lords, created charge of about 1,300 crores in that instance, without the consent of the board, and consequently a writ petition came to be filed on what is the board doing, my lords, under the KDB Act. Please see, my lords, 19. In the aforesaid narrated, glaring enough they are, what would emerge is that the board is silent on the alleged violation of the property that was leased to the second respondent for a particular purpose, albeit on consideration. The purpose is deviated and not stopping at that, using the scheduled property. The land which belonged to the board, the second respondent, has created several charges in the property in violation of the terms of the lease. In such glaring fact, what is involved is inaction of the board, the state under 12 of the Constitution, qua the property that belonged to the board, and the question of locus standi of the person who brings before a constitutional court such illegality gets blurred as the issue that is brought before court masks over the issue of locus. This, my lords, was the finding. Now, please permit me to, my lords, point out to para 22 for 1 minute, my lords.
Yes.
Para 22, your lordships will find in, my lords, 292. Therefore, your lordship, that's the operative part of the order. A mandamus was, my lords, issued to the board. My lords, this matter was taken up in appeal before the division bench. And therefore, my lords, kindly see what are the division bench's observations. Your lordships will find the division bench's order, my lords, in 251. I'm sorry. 182, my lords, where it starts. I'm not 251, my lords. Would your lordships come to, my lords, straight away to paragraphs, my lords, at 191, which is, my lords, paragraph 5.
Yes.
My lords, I read this and, my lords, dilate a minute on this point. 5 starts, my lords, at 190 bottom quadrant. I'm reading, my lords, in 191. The respondent number 2 in the petition, and also taking note of the affidavit filed by the board, has observed that the board in its statement of objection on oath has stated that it was not aware of any charge that was created that would take, and that it would take action in accordance with law. Thus, the board proposes to inquire into the matter, and it was submitted to the court that certain factual aspects were not made known to the board, etc., etc. Please see 6 months. In view of the specific stand taken by the board to inquire into the matter regarding violation of the terms of the lease on its own, the question of issuing mandamus would not arise. That apart, in our opinion, there is no need or necessity for the petitioners to participate in the inquiry proceedings which conducted by the board. Now, two things fall out of it. One, my locus to initiate a writ petition before your lordships was never set aside, my lords, at finding which your lordships will find in paragraph 19 of the first order, which your lordships, my lords, found in annexure F at 150. That has not been set aside. My lords, for a minute may look at, my lords, paragraph 19. Paragraph 19 is in 178, which says that the locus will now mask over, and therefore, my lords, mandamus is granted. That, my lords, has not been in any manner, my lords, touched by the division bench. I am bringing your lordships back to 191 for a minute.
Yes.
The argument of my learned senior, Mr. Raghavan, was that because a mandamus is not issued by the division bench, it is, my lords, a sequatorial understanding that I do not have locus to seek a mandamus. Now, that finding has not in any manner, my lords, cannot be sequatorially be held to be forthcoming from the division bench order. Now, please see one other aspect of the division bench order, my lords. Please, my lords, permit me to point out paragraph number 8B. Your lordships will find 8 is the operative part. 8, my lords, begins at about 192. Please see, my lords,
Yes.
8B at 193 and 8D. I'm reading, my lords, 8B. The respondent board shall conclude the inquiry as expeditiously, etc., etc. Please turn to 194, my lords.
Yes.
This, however, shall not affect the rights of the parties to seek appropriate remedy as may be available under law before the competent forum. My lords, this D starts in the previous page, which says that it is made clear that the respondent board shall carry out the exercise of inquiry into the matter without being influenced by the findings or observations made by the single judge. This, however, shall not affect the rights of the parties to seek appropriate remedies as may be available. It was my writ petition. I received a mandamus at your lordship's hand. The division bench says that because the board is inquiring into the matter, a mandamus may not be necessary. Please see, my lords.
Now, what did the 1 minute, sir. What did the board do later?
My lords, board did two things. They conducted an inquiry, and in the inquiry, my lords, indicated, of course, reasoned out all the violations done, and in the last paragraph said, whatever it may be, I am giving them another 2 years to develop the property. We challenged, my lords.
34B order.
Yes, 34B order. The 34B show cause notice, my lords, elucidates 5 violations. The 34B order does not say anything about those violations, except elucidating them again and saying I'm giving him 2 more years. Tacitly, my lords, indicating that, all right, I will condone it. Now, the question is whether they can condone the violation or not. That's a different matter, my lords. Now, but please see, my lords, D, 194D. My lords, in the last paragraph.
Yes.
Clause 3 and clause 4 of the operative portion of the order of the learned single judge are deleted. Clause 3, my lords, was my right to participate in the inquiry.
Yes.
And clause 4, my lords, was an interim order, etc., in terms of third-party rights, etc. That why the interim order third-party rights was deleted? Because the respondents gave an undertaking before the division bench that until inquiry gets over, we will not do anything on the property. And why was 3 deleted, my participation? Because the division bench thought that, all right, they are undertaking an inquiry, you don't participate, but I will keep your rights alive. And that is 194, the first 3 lines. This, however, shall not affect the rights of the parties to seek appropriate remedy. I am entitled to challenge the outcome of that board's inquiry. I am entitled to challenge, my lords, what happens. Now, please see, my lords, the board, of course, inquires, does not give him a clean sheet, but extends time. I challenge that, my lords, by virtue of a subsequent writ petition, which lands up, my lords, before a learned single judge of this honorable court, that is Justice Hemant Chandragowda's order. Please see that order for 1 minute, my lords. Your lordships will find that order, my lords, at page number, my lords, 245. Annexure K 245.
Yes. Yes.
My lords, there are 2 findings in this order which are against me. I will read those findings, my lords, and make good my submissions. Please see paragraph number 19, my lords.
Poor sir. Poor sir.
Yes, my lords.
I have a meeting at 4:45. I'm already late.
I'll continue.
We'll continue it on Monday or Tuesday.
Whatever.
Will, ನಿಮ್ಗೆ ಯಾವತ್ತಾಗತ್ತೆ? Monday, Tuesday?
Monday, my lords, subject to my lord's convenience on Monday.
Monday. Next working day is Monday.
Yes, please. My lords.
Next working day is
Can we
Monday.
get a little later, my lord, by 4 o'clock?
Ah, no problems. No problem. Yes.
Your lordship will be sitting in Bangalore, my lord.
No.
Oh, why? Will.
Online. Whatever. Masmat Pasha sir was waiting. Anyway, ಇನ್ನೊಂದು ದಿನ ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್. ಅದು ಇನ್ನೊಂದು ದಿನ ಹಾಕ್ಬಿಡಿ.
Interim order has to be extended.
That will be extended. Wherever interim orders.
Much.
Canvas of this agreement.
Let's finish Monday.
Fine, ಯಾವತ್ತಿಗೆ ಬೇಕಾದ್ರೂ.